Oh yes, yeah. Well,
Your
my
health condition.
it's my diabetes is right up here because I'm not eating at the right times. I'm not,
So yeah, so just you'll have to have a conversation
yeah,
with him.
yeah. When he comes in. Yvonne. Hello. Thank you for coming and supporting me. I'll tell you what, you had a laugh last night. We went to Brentford.
Hey, you managed to go to Brentford and then come here the next day.
I was late last night. I want to see if it went through. Which it did. Yeah, which it did. I'm going to have to ask for extra comfort breaks today. Is that all right? Yeah, because my blood sugar is up completely to pots. It's just I need a couple because I'm having to drink so much. And of course, you drink a lot, you need to weigh a lot. So I might say to them, I need a 5-minute comfort break. It won't be continued. If it's not a case if it's getting awkward. I'm not going to answer this. I'll answer all the questions, and then once I've answered them, I'll say if I feel I need to, I have to. Yeah. If you could let Miss Reed know, thank you. It's only because my levels are going shooting up through the roof. Sorry, no. Oh yeah. So because there must be, because they must be getting old. The liquid must be just evaporating. Don't know why. Yeah. Because Andrew must have just decided to give me the older ones, not just up the nose ones. I've got the throats and I've got the one up. Up. If I could, if you haven't. Oh, thank you. I can't turn it off. It's the sound engineers. Yeah, they're banging all live. Yeah. Morning. Mind that lead. Mind that lead. No. Morning. Oh, thank you very much. I didn't see it.
Yeah, I just thought it was easier.
Well, good morning, ladies and gentlemen. It's 9 o'clock. The inquiry is resumed. Just the usual housekeeping points. attendance list, I hope, is circulating, so please put your details on that before you leave today. And mobile phones, if you've got one, please make sure it's switched off or on silent whilst the inquiry is sitting. In terms of paperwork, I've been handed some redacted photographs from the Rule 6 party to replace evidence submitted earlier, so thank you for that. And I understand there's another batch to be submitted shortly.
That's correct, sir.
Yep, thank you. Thank you for that. The only other thing I wanted to say is that I saw an email from the Inspectorate's case officer with forwarding an email from the MP, Mr. Francois, which had got attachments to it of the Inspector's report and Secretary of State decision that he referred to in his presentation. Has that found its way to the parties?
That's,
yeah.
he called me this morning to let me know it's on the way. And
Okay.
just to reiterate, it's what he said he would do after he gave his evidence on Tuesday.
Yes, I'm quite happy with that. But the only reason for me raising it is I'm going to ask the council if it's possible for them to print out a copy for me.
We have. I think we've got one for the inspector. So
I don't need it at the minute. But
I'm not sure we've received the email, but we had already printed a copy of the appeal decision.
right. Okay. Well, I'll at the morning adjournment, mid-morning adjournment, I will check with the Inspector's case officer whether that's been forwarded to the parties.
Not to us, sir.
Not so far.
Not so far.
Okay. Well,
Thank you.
I spotted that it had come in first thing this morning, so I'll contact him and make sure it gets sent on. But I mean, you're aware what it is that he's referring to, and
Yeah.
they're the only attachments to the best of my knowledge.
That's not a problem.
Okay. Anything else from any of the parties then before we move on to today's business?
If I may, sir,
Mr. Foster.
just briefly, I would imagine that this afternoon I will start presenting my evidence at some point.
Hopefully, yes.
And as I mentioned, there's a planning meeting this evening. I've managed to find a substitute for me in that meeting. And therefore, I would suggest, in order to save time and get it over with, when I finished evidence and cross-examination starts, we continue through to its end, however late that might be.
Well, I appreciate what you're saying. We'll certainly bear that in mind, but obviously I need to consider the well-being of all participants. So we'll see how things go. But it's good that you're prepared to not be constrained by that committee meeting. So thank you for that. There are no restrictions on the time for this use of this room, are there? I checked that on the first day. Yeah. Okay. Well, we'll bear that in mind and see how things go. Anything from yourself, Mr. Parkinson? No, Miss Reid? No, thank you, sir. No. In that case, would you like to begin your cross-examination of Councillor Shaw, then, please?
I would do, sir. Good morning.
Oh, sorry. Before you start, I was just going to double-check. You gave me a time estimate of 3 to 3.5
Yep.
hours. I want to know if that still
It is.
stands. Okay, so I'll be able to check progress against
Hopefully.
that. Yeah. Okay.
Good morning, Councillor Shaw.
Good morning.
Now, I just want to start by looking at your proof of evidence. I'm hoping that we're going to go to documents that we've tried to help tab up for you, just to move things on. So if you could turn up your proof, please. So you set out in your proof of evidence that you are an affiliate member of the RTPI. Is that as a result of the time you've spent as chair of the committee in terms of the experience, as opposed to any professional qualifications in planning?
It's since I've been on the committee itself, not just being the chair.
Yeah.
I haven't got any formal planning qualifications.
Thank you. Now, what you do in your proof of evidence at paragraph 3.7 is you set out the key concerns of the committee, and those are points A to F that we've looked at before a little bit with Councillor Eaves. You see that?
Yes.
Yeah. And so just to be clear, and it was a point that I set out with Councillor Eaves as well, is that, particularly since you're an affiliate member of the RTPI, you would have been aware of the importance of setting out in detail the basis of your case in your proof of evidence, wouldn't you?
Yes.
Good. And so we can understand that the points that you wish to raise against the scheme are set out comprehensively in your proof of evidence and also in the evidence of Councillor Eaves that you take into account in your evidence. Good. And so in respect of paragraphs A to E, what you say at paragraph 3.8 is that in terms of those substantive matters, you were providing evidence about A, B, D and E, and Councillor Eaves was giving the evidence in respect of points C and F, which were effectively the congestion points he discussed yesterday and also the highway safety point that he had in respect of the Rectory Road improvements.
Yes.
In respect of those points, then, paragraphs A relates to the width of the pavement outside the school, B, pedestrian safety generally, and the package of measures proposed by the appellant, D related to parking space for the school, and E related to the loss of the designated cycle lane and the proposal of a shared use space with pedestrians outside the school, which was initially set out to be a highway safety concern, wasn't it?
Yes.
And it's now the position that you do not, or well, you, the local planning authority, does not pursue a case in respect of any of those points.
That's correct, but I still believe there is problems and concerns regarding Holt Farm School with the width of the pavement being reduced.
Yes, I understood your evidence in that respect, and we'll turn on to that later, and that's something that feeds into the planning balance, isn't it? Because you're aware that paragraph 111 of the MPPF sets out that schemes should only be refused where there are unacceptable highway safety issues. So you're not suggesting that these matters should lead now to a refusal of permission. Your point is that those disadvantages should be weighed in the overall balance, as
Yes,
I understand it. Yeah, okay, good. Now, next point, and it's just a point of clarification at the outset so that we know exactly where we are with this. There are a number of statements of common ground that have been signed on the part of the council. I'm going to focus, because your evidence is on the planning side of matters, on the planning statement of common ground, and there's also housing land statement of common ground. I assume, because you've not told us otherwise in your proof of evidence or in examination in chief, that you accept that the content of those statements of common ground reflect the position of the local planning authority.
Yes, they do.
Thank you. Good. Thank you. Now, in respect of the congestion points raised by Councillor Eaves, I know you raised some points at the outset in respect of your experience. Just to be clear, I've raised my points in respect of Councillor Eaves already, so I'm not going to ask you about those. It's not that we accept the position, but there's no point going over that ground because your evidence focuses on these other matters. Now, what you say at paragraph 2.1 of your proof of evidence is that you present the planning case for the local planning authority, don't you?
Yes, I do.
Yeah. And you say at paragraph 4.2, that you recognise that the starting point for determination is the development plan and that application should be determined in accordance with the development plan unless material considerations indicate otherwise. Yeah?
Yep.
Good. And to be clear, the core strategy and the allocations plan are the council's development plan, aren't they? Not the appellant's, the council's development plan.
The local plan.
Yeah, it's the council's plan, isn't it?
It is.
Thank you. And you have a copy of the MPPF, please, in front of you.
But it's disappeared. All right, thank you. Yes.
Good, you're faster than me. Just a sec. Paragraph 15, please.
Sorry.
And what paragraph 15 of the framework tells us is that the planning system should be genuinely plan-led. Succinct and up-to-date plans should provide a positive vision for the future of each area, a framework for addressing housing needs and other economic, social and environmental priorities, and a platform for local people to shape their surroundings. So that is essentially why we have section 38.6, isn't it? And it reflects the purpose of the plan-led system.
Yes.
And it's no part of the council's case, either in your examination in chief or in your proof of evidence, to say that the plan fails to reflect national priorities, is it?
No, but it is out of date.
Well, it's out of date because, well, when you say it's out of date, the policies within it that are out of date are the housing policies, because the housing numbers in the plan are lower than those now implied by the standard methodology. You understand that?
Oh yes, I say that's why it's out of date,
Yeah.
because the methodology has changed,
Yeah.
and the figures have changed.
Yeah. But the figures have gone up.
Well, they've changed, haven't
yeah.
they? If
Well, the figures have gone up, haven't they?
Yeah.
Yeah, and that's recorded in the statements of common ground. But at no point in your proof of evidence or your examination in chief have you suggested that less weight should be accorded to the policies of the development plan?
No, not at all.
No. So the inspector can record then that full weight should be accorded to the policies of the council's development plan.
Yes.
Thank you. And it is no part of your case, either in examination in chief or through your proof of evidence, to indicate that there have been any material changes in circumstances following the adoption of the plan, and it follows from what you've just said, full weight to the policies, that indicates that less weight should be given to the policies of the plan. That's not part of your case.
No, except what Councillor Reeve said regarding the severity of the congestion.
Well, that relates to the individual impacts of the scheme, which we'll turn on to. I'm dealing with the broad point at the moment in respect of weight that should be attributed to the policies of the development plan. You don't identify in your proof of evidence or examination in chief that there have been any material changes in circumstances since the plan was adopted that would justify a decision that less weight should be given to any of those policies, do you?
No, I don't.
Good. Now, in respect of, just bear with me a second. In respect of the framework, we can see at 16, paragraph 16, plans should, and it tells us what plans should do. You confirmed with me a moment ago that it's no part of your case that the plan is inconsistent with the framework. So you accept that the development plan, although adopted prior to this iteration of the framework, reflects the objectives of the framework. I think we agreed that a moment ago. In respect of paragraph 16, we see the directive that plans should be shaped by early, proportionate and effective engagement between plan makers and communities, local organisations, businesses, infrastructure providers, operators and statutory consultees. You see that?
No, can I stop you there? Plan 16 should. What are you reading? A, B, C, D up to F. What one part are you reading that?
C. Plan should.
Yeah, thank you. I've still got it. Thank you very much.
Okay, so just take a moment if you want to. I can read it again. So,
I can read it, thank you. If you want to carry on, I'll read it. Thank you. Yeah, okay.
Okay, plan should. So the point there, be shaped by early, proportionate and effective engagement between plan makers and communities, local organisations, businesses, infrastructure providers and operators and statutory consultees. So the plan would have been, the core strategy would have been prepared by the council's plan, and would have been shaped, therefore, by engagement between the local planning authorities, communities, infrastructure providers and statutory consultees in accordance with those points that are set out there.
Yes, it would.
Thank you. And we can see it, so you can pop aside the framework now for the minute, and we might turn back to it in a moment, but let's try and keep on top of the numerous documents in this case. If you turn up, please, the core documents, and hopefully you've got a tab in the core strategy.
Sorry, we're in the...
Oh, I'm so sorry, sir. It's core document 6.1.
6.1.
Sorry, sir. Obviously, I've not been through your papers.
Yeah, you'll need to keep giving me a heads up on which one I'm turning to.
Yeah, I'm so sorry. So, do you have a copy of the core strategy, core strategy, councillor?
I have.
Good, thank you very much. And if you turn at page 8, please, we're going to start at page 8. And of course, just as context, the core strategy is the strategy for the entirety of the district, isn't it? Not just one particular part of it.
No, it's full of Rochford district.
Yeah, exactly. So if we look at paragraph 1.11, we can see at paragraph 1.11 that it is reflected there that community involvement is an essential part of the plan-making process. There has been ongoing community involvement in the preparation of Rochford's core strategy, and in particular at 3 key stages: core strategy issues and options, core strategy preferred options, and core strategy revised preferred options. And then at 1.12, consultation on the core strategy has been carried out in accordance with the Council's adopted statement of community involvement. And then at 1.13, in addition to community involvement on proposed policies within the core strategy, consultation has also been undertaken in relation to aspects of the evidence base, particularly in respect of deliverability and viability of residential development locations. So 2 points arising from that. Firstly, the core strategy reflects that there was extensive community involvement, as one would expect, prior to the adoption of the core strategy.
I can't answer that because I wasn't on the council at that time.
Okay.
I wasn't elected when this come through.
No, but I understand that. But the core strategy on its face, those paragraphs that I've just read out to you, reflects the fact that there was community consultation and involvement in the plan-making process that was carried out in accordance with the council's statement of community involvement. That's what it says in those paragraphs.
Yes, my experience with the council, that is what would have happened.
And secondly, what we can see from these paragraphs here as well is that in addition to the community involvement, consideration was given to all aspects of the evidence base, particularly in respect of the deliverability and viability of residential development locations. So consideration was given to the deliverability of the residential development locations that were then promoted through the core strategy.
It was, but it would have been, the residents would have objected to various sites.
Yeah, and that's the purpose of the plan-led process, isn't it? It's that those concerns are listened to by the local planning authority, going through what we see in 1.11, which is the issues and options stage, the core strategy preferred options stage, and then here, revised preferred options. And all of those matters are taken into account, along with other matters, such as the council's housing needs, for example, and then a judgment is taken as to the most appropriate locations for development, which are those promoted by the council through the plan process.
Yes.
Thank you. Good. And again, in deciding and determining the most appropriate locations for growth, the council would have considered the consultation responses of all of its residents, clearly, not just those in one particular area.
When they do the local plan and they get the allocated land come forward, where that is, the council will do a plan for that area. So if we've got something in Rochford, those consultations will not go out to Rayleigh. It's just subject to where we are.
Uh-huh.
But this has gone through, and I believe Councillor Eaves has already said this. The roads have got busier. This all the SCR8 site was put forward, and the traffic wasn't as bad as it is today.
Yeah.
And I think that is a consideration.
Okay, well, we'll look at that in a moment, but I did ask you at the beginning and you confirmed that you're not relying on any material considerations that have happened since adoption, which indicate that less weight should be given to the policies. And I'm going to look at the impacts of the scheme with you in the planning balance, but that was the answer that you gave me. Now, in terms of the plan then, the purpose of the plan, and this is, sorry, you are going to need the framework again. The purpose of this is, if we look at paragraph 20 of the framework, it tells us that strategic policies should set out an overall strategy for the pattern, scale and design quality of places and make sufficient provision for a number of matters, one of which is housing, which is point A. You see that?
Yes.
So the purpose of the core strategy is to set out the strategic policy, setting out the council's overall strategy for the pattern, scale, design quality of places, and to make sufficient provision for housing, amongst other matters. Yeah? Yes. And obviously, because where you're providing development, and because there is a requirement of national policy to provide for sufficient housing in your area, it is the case that through the plan-led system, the council will need to undertake a balance and consider the balance in respect, essentially, of various interests. So, on the one hand, the need for housing, and on the other hand, other considerations.
Yes.
And I just want to understand in that context a little bit about the overall strategy before drilling down into some points. So, if you go back to the core strategy, and it's page 27 this time, please. And so this is just so that we understand a little bit about the context of the district. And we can see at page 27 of the core strategies, there is a heading issues and options. And
opportunities.
Sorry. Yes, sorry. Opportunities. Thank you, sir. Issues and opportunities. And we can see at paragraph 2.11, it says this: locations for development are limited by physical constraints, including land at risk of flooding, areas protected for their landscape value, sites protected for ecological value, etc. Some such areas are of local, regional, national and international importance, including those protected by the EU Habitats Directive. And we can also see, if we move on to 2.33, again, issues and opportunities, on page 29, just over the page, we see this: the district is predominantly green belt, tightly drawn around existing settlements, the vast majority of which is undeveloped. There is a limit to how much infilling and intensification existing settlements can sustain without their character being adversely affected, particularly given that the district contains 10 conservation areas. As such, there are concerns as to land uptake and loss of greenfield land that the housing requirement will engender. And then at 2.34, potential housing development land is further limited by the fact that much of the district is subject to constraints which prohibit the development of housing such as flood zone 3 or areas of ecological importance. Details of land subject to constraints are included in the SEA baseline information profile. And then if we just put that in context and turn up page 173, please.
Sorry, page
173.
173.
And it's the key diagram. It's right at the back, so just a few pages from the back.
Yeah, thank you.
And we can see here that this is the key diagram showing those constraints that we've just spoken about. And we can see that effectively most of the district is washed over by the green belt. Those are the areas of green on the diagram, yeah. And also we can see to the east areas of coastal protection belt as well. And so the point really is that in terms of the district as a whole and the opportunities for development, it is a district that is heavily constrained by landscape, greenbelt and ecological designations that limit the opportunities for new development to come forward, isn't it?
Well, we have brownfield sites that could be taken up when it hasn't happened in this core strategy.
Okay, but as a whole, if you look at the district as a whole in terms of additional opportunities for growth, we can see the large areas of greenbelt, the coastal protection, the ecological designations. Just went to the paragraphs where the core strategy confirms that there are limited opportunities for growth based on those greenbelt, ecological and landscape designations.
I've got a lot of background on this, sorry, as per this map shows, yes.
Yes, thank you. Good, so limited opportunities for growth based on those constraints. And if we turn back to page 32, please. Page 32 and 33, under the heading Transport. And we can see at 2.62, the strength of the spheres of influence of the large neighbouring centres of Southend, Basildon and Chelmsford mean that traffic is drawn through Rochford district's own centres to them. This not only has an impact on traffic congestion in general, but it also engenders concern with regard to air quality within the district's town centre. This situation has the potential to be exacerbated if development is not directed to the appropriate locations around the settlements. Particular locations where there's a concern include east of Rayleigh, where commuters to Basildon and Chelmsford are drawn through the centre, west of Hockley, where those commuting by car to Southend or Chelmsford, Basildon are drawn through the centre of Hockley or Rayleigh, respectively, and east of Rochford, where vehicular movements would inevitably be directed through Rochford's historic centre. Given such concerns, the location of future development must be considered alongside opportunities to locate development in areas where alternatives to car use are more viable, alongside other sustainability issues. So just taking a couple of points from that. First one is that traffic issues arise across the district as a whole, including in the other Tier 1 settlements. Yeah?
Yep.
Secondly, areas of particular concern that are flagged up in this paragraph in respect of congestion do not include Ashington, do they?
Yes, it will do, because it's going through. It has said here that it will be directed through.
It's talking about east of Rochford there, do you see? And east of Rochford, where vehicular movements will be directed through the centre.
Yes, but it says, given such concerns, the location of future development must be considered alongside opportunities. So if we got a new development where this SER8 is, it will then be pushing all traffic to the Ashington Road. It will not be pushing it out to the east of Rochford or through Hockley, Rayleigh, will it?
Right. So that's, again, in terms of the implications of this scheme, which we're going to turn on to in a moment. But just looking at this paragraph, traffic congestion is an issue across the district. Ashington is not specifically identified as one of the points of concern in this paragraph, is it?
No, is that because it's not, SER is not being mentioned in it?
No, exactly. And then number 3, the point that you raised a moment ago, is the last sentence of that tells us that given such concerns, the location of future development must be considered alongside opportunities to locate developments in areas where alternatives to car use are more viable, alongside other sustainability issues. So what that's telling us is that the core strategy recognised that given the issues in respect of congestion and traffic across the district, the strategy would be to direct development to areas where alternatives to car use are more viable alongside other sustainability issues. That's what it tells us.
It does, but I would like to know where, how we have a lot of residents that work at Southend Hospital. So I'd like to know how, if we have this SER8, how they can't walk to the hospital, they can't cycle to the hospital, and there's not a bus, well, there's one bus that goes whenever, and there's not a train station, so they will need the cars.
Okay, well, we're going to look at the relative sustainability of the settlement in terms of what the core strategy says about it now. If we turn up next, please, page 43. And sorry, just be clear, sorry, just taking a step back. One of this point about issues across the district in terms of traffic, including in other tier 1 settlements, Rayleigh and Hockley, we can see those are the ones in the table on page 43. Those are issues, I presume, that you accept still exist.
Oh, they do, yes.
Thank you. Also in terms of tier 2, Hullbridge and Great Wakering, I think those are issues that still exist there as well, aren't they?
And they're getting worse.
Yeah, getting worse, right. If we look at that page, we can see that there are essentially 3 tier 1 settlements that are identified: Rayleigh, Rochford, Ashington, Hockley, Hawkwell, and so Ashington, together with Rochwell, is classified as a settlement at the top of the settlement hierarchy in tier 1, isn't it?
You meant Rochford, didn't you, not Rochwell?
Sorry? Just.
You said Rochwell.
I'm
Did you
sorry.
mean, so you meant Rochford, yes?
Yes, I did, yes, sorry. In terms of, so top of the settlement hierarchy, and if we look at what that means in 4.9, we can see, as described in the spatial characteristics, issues and opportunities chapter of the document, the district contains a number of settlements. Some of these settlements, although they have their own distinct identities, are not functionally separate from their neighbours, and for the purposes of the core strategy have been grouped together as one, namely Rochford, Ashington and Hockley, Hawkwell. These settlements, groups of settlements, can be divided into 4 tiers, with the settlements in the higher tiers being more developed, subject to greater housing demand and need, and generally more suitable to accommodate additional housing for the reasons described above. And then the settlement hierarchy as follows. So the tier 1 settlements are the settlements that the core strategy identifies as being the more suitable settlements to accommodate additional housing. That's what we're told in 4.9.
That is what we're told, yes.
And then if we go back to page 33, please. We can see at 2.60 the point that there is a high level of car ownership in the district. However, the proportion of people travelling to work by public transport is greater than the national and regional averages, primarily due to the accessibility of rail links from the district's 3 main urban areas. Away from the 3 main settlements, car dependency is high. Congestion and environmental impacts will continue to worsen with population growths if this trend is not reversed. So just pausing there, several points arising from that. Firstly, the plan is expressly recognising that car dependency is particularly high away from the 3 main settlements. So it's saying the position's worse outside of those 3 main settlements.
In the villages, you need a car to
Yeah.
get to anywhere because there isn't any public transport of any sort.
Yeah, exactly. And so the second point is that in terms of issues in respect of congestion and environmental impacts, The core strategy, this is 2.61, recognises that that will continue to worsen with population growth if this trend is not reversed. So it's really emphasising there the importance of encouraging people to use sustainable transport modes, isn't it?
Well, I'd like to know how that can be achieved when the villages are 5 miles away from the local train station.
Yeah,
They can't walk, and that means more cars will be coming in to the from the Anne Boleyn junction through to up through to the station. So we have got a congestion problem with cars coming in from the villages. Yeah. And these villages aren't like 2 or 3 houses. You're talking. You can talk. They still call themselves villages, but there could be 500-600 houses there.
Yeah. So those are the issues in respect of the villages. But what we can see if you look at 2.63 is the lack of public transport provision through most of the district is an obstacle to reducing car dependency. There is, however, some opportunity to utilise public transport, particularly within the 3 main settlements which contain rail links between each other, Southend and London. So just pausing there, what the core strategy is doing, because it's got these top-tier settlements, the 3 top-tier settlements, the most sustainable locations for growth in the district, and then you've got your villages that sit below that, as you've explained, there are limited opportunities and there are issues in terms of car ownership. What the core strategy is doing is it is focusing development to the top-tier settlements where there is more opportunity to use sustainable transport modes. That's what we're being told in 2.61 and 2.63.
That is what we're being told, but it's not practical. I don't agree with these statements.
But this is your council's adopted development plan,
It may be that, but it doesn't mean you have to agree with everything that's written down in paper.
In terms of in terms of the statement of common ground, which you confirmed to me at the outset, that you do not dispute, could you turn that up, please? Just bear with me a second.
Yeah, give me a moment as well, please.
Statement of common ground, please. No, that's his.
Sorry, that was the planning statement of common ground.
It's the planning one, sir. Yes, please. Sorry, just bear with me a minute, sir, because my planning one appears to have fallen out here. Have you got a spell on?
Yeah, I think I've got it whenever you're ready.
Thank you, sir. 5.9, please, councillor. So this is the local authority's agreed position in respect of accessibility. And there is agreement here that the appeal site is located within walking and cycling distance of a range of local facilities and services, including, and I'm not going to read them all out, but they're set out there. And then at 5.9.2, it's agreed that these facilities are located within the National Travel Survey 2020 average walking distance of 1.36 kilometres, and all facilities are located within the Manual for Streets suggested upper limit, referenced in the former PPG 13 guidance of 2 kilometres. Furthermore, all the facilities are located within the Institute of Highways and Transport's preferred maximum walking distance of 1.2 kilometres. So quite a lot of technical speak there, but broadly the point is at 5.9.1, it is agreed that the appeal site is located within walking and cycling distance of a range of local facilities as set out in the Statement of Common Ground, isn't it?
Yes, if they're in good health, they can walk, but we've got a very older population.
Sorry, say that one again.
Sorry.
I didn't quite catch it. Yeah.
I'd say, yes, if you're well enough to walk, we have a very elderly population in Rochford who do depend on their car for that reason.
if we then turn back to the core strategy, 2.67 on page 35. We then have this. Within the district, there are 4 tiers of settlement. We've just looked at those already. The first tier comprises Rayleigh, Rochford and Hockley. We know that it's Rochford, Ashington and Hockley. We've just looked at that. But then we see this. These are all settlements with a range of services and facilities, as well as some access to public transport. So it's recognising the point that we've just looked at in the Statement of Common Ground there. You see that?
Yes.
Yeah. And then at 2.68... of the first tier settlements, Rayleigh has the best access to services within the district, and then Rochford and Hockley contain local town centres catering for local need. And then later on in that paragraph, it's recognising that Rochford is a local centre. You see that?
I can, but when this was done, that was correct. If you look at Rochford Town Centre, it's now very lacking of shops and amenities.
Okay, but
Lots of charity shops if you want anything.
Okay, but it's still, it's still in the Statements of Common Ground accepted that the site is within walking and cycling distance of a range of local facilities, isn't it?
Yeah, you can walk there, but there's no facilities.
Well, there's a cafe.
Well, yeah, but if you want, excuse me to interrupt you, but if you're a young mum that needs food for their children or other amenities for their children, there's hardly anything there. They have to go into Southend for their school uniforms. They can only get it in one place in Southend. They can't even go to jump on a bus or a train to Hockley or Rayleigh to get these things for their children that the schools demand.
But at 2.63 of the core strategy on page 33, we see that in respect of the Tier 1 settlements, there is some opportunity to use public transport, particularly within the main settlements which contain rail links between each other, Southend and London. That's right, isn't it?
The bus services have completely been cut since the COVID, because obviously people working from home, and they have not been increased. Okay. There's a meeting next week regarding the bus with Essex County Council to actually advise us how it's increasing.
Okay, just in respect of that point, you've seen that the appeal scheme will contribute a significant contribution towards improving and enhancing the bus services. I assume that's something that you would welcome.
If it was actually going, as Councillor Eves said yesterday, we've had money go into bus services, but if the bus services, and we know this, has gone down by 64%, if they don't deem that a bus is necessary, it's not anybody who has a business and a business brain will not run a bus empty or just for 1 or 2 passengers. People are still very, very worried about this COVID, as we've seen today. None of us need to wear masks, but a few of us have walked in with masks. And people are concerned, so they will not get on buses. They will actually still use their cars. So that means the bus companies will not actually put money into buses when it's not necessary. And apart from that, if you're sitting having a bus idling at a bus station or a bus stop, it's causing air pollution.
Right. Councillor, you have not put any evidence at all before the inquiry, have you, in respect of the viability of the bus service provision that exists or is proposed?
No, I refused it on pedestrian safety.
Yeah, then those concerns have now been resolved. Now, in respect of just moving back to the core strategy. So, what we can see from all of that, and irrespective of what you think about the current position, what the core strategy does, having recognised the constraints in greenbelt landscape ecological terms and the traffic issues across the district, it seeks to deal with that by, as well as it can, by directing growth to the most sustainable locations in the district, those 3 top-tier settlements, doesn't it?
It's considered to be, yes.
Yeah, good. And if we look back at the framework, please, paragraph 105 this time.
hang on. Sorry, what paragraph?
Sorry, 105. We have the planning system should actively manage patterns of growth in support of these objectives being sustainability objectives, which are set out in the paragraph 104C above, for example. The planning system should actively manage patterns of growth in support of these objectives. Significant development should be focused on locations which are or can be made sustainable through limiting the need to travel and offering a genuine choice of transport modes. This can help reduce congestion and emissions, improve air quality and public health, and then it talks about the difference between urban and rural areas. But the point is here is that that strategy of the council's plan of directing growth to the tier 1 settlements is consistent with that paragraph of the framework, isn't it?
Yes, it is.
Thank you. And in terms of the impact that strategy of directing growth to those top tier settlements, including Rochford and Ashington, might have, if you look at 3.8, please, 3.8.
Sorry, 3.8 in...
Of the core strategy, sir, page 37. What we can see at 3.8 is the council's balanced strategy to the distribution of housing is beginning to take shape. Housing development is focused on the settlements with the greatest range of services and facilities, but directing a proportion to smaller settlements to ensure that rural communities are nurtured and sustained. At the same time, the distribution of housing is balanced, ensuring that there is a fair and equal division of new development across the district, providing new sustainable residential developments that are carefully planned, well related to infrastructure, community facilities and play spaces. So just pausing there, the strategy within the core strategy, the distribution of housing within it is considered, was considered by the council to be balanced and a fair and equal division of new development across the district.
Yes, but it's saying directing a proportion of smaller settlements, but 662 houses isn't small, is it?
No, that part there, councillor, is talking about the smaller settlements are the ones that are lower down the settlement hierarchy.
Yep. Sorry.
So what it's saying is that it's looked at the issues that you've got in the villages that you've described, and it's obviously looked at the landscape, greenbelt, ecological constraints, the traffic issues across the district, and it's come to a distribution that it describes as balanced, ensuring that there is a fair and equal division of new development across the district. Do you see that? Mm-hmm. Yeah. Good. And we then turn, please, to page 41, please, of the core strategy. Which is telling us about housing. And we can see that a number of objectives are set out at page 41, which we can look to. And they include, in 1, ensuring a delivery of an adequate supply, 2, delivering a balanced strategy for the distribution of housing, directing housing growth to the most sustainable locations, so that's your tier 1 settlements, having regard to social, economic and environmental considerations. The next one's about rural services and settlements, they're not concerning us in here. And then prioritising the redevelopment of appropriate brownfield sites and minimising the release of greenbelt land for development and ensuring the delivery of housing catering for the needs of all communities in terms of tenure type and location. and ensuring appropriate infrastructure, which we'll turn on to in a moment. And then over the page, we see at 4.1 in respect of housing, it is important that that planning ensures the provision of sufficient good quality new homes in appropriate and sustainable locations. So just pausing there, it is a priority of the Council's core strategy, as well as national policy, to secure a sufficient supply of housing to meet its needs, isn't it?
It is, but as we've said, we need the right homes in the right places with the right infrastructure.
Yeah, well, we'll look at the scheme in a minute and we'll look at what the Council's policy does about that. But I've noted your answer. And if we turn then to, I'm going to turn and look at housing in a little bit more detail later, but if we look at 2.35, please.
Still on the core strategy.
Sorry, in the core strategy.
Sorry, 2.35.
2.35, so
Okay.
at page 30. We can see, just in terms of what the plan does and what the plan recognises, there is a high level of home ownership in the district. However, concealed households, personal persons living with a household wanting to move to their own accommodation and form a separate household, e.g. adult children living with their parents, are largely unable to afford to enter the local housing market due to the gap between house prices and income. There is a limited supply of affordable housing in the district, and the development of additional affordable units across the region is not keeping pace with demand. So just pausing there, that's noting a particular issue in respect of the supply of affordable housing in the district, isn't it?
It is.
If we then look at 2.36, there's reference to the SHMA there, the Strategic Housing Market Assessment, also examines the need for different forms of affordable housing. And then we see a recognition that there is an acute, and that's the word of the plan, an acute need for social rented housing, as well as significant potential market for intermediate housing. So an acute need recognised in the plan for additional affordable housing.
It's a very broad definition of what affordable is.
Yeah.
What people on very high incomes can afford a £500,000 house. People who are on very low incomes, and I hope I'm not insulting anyone who's listening to this, on people with carers, who are carers on lower wages, cannot afford any of these new houses in any of these new developments that are coming forward. Okay. So we still will have the need for reasonably priced, affordable housing, which I don't think we have in this plan.
Right, okay. Well, we'll look at what the appeal proposals are providing a little bit later, but my question here was that the development plan recognises that there is an acute, it uses the word acute, need for additional affordable housing.
Definitely, there is definitely an acute need that needs to be addressed.
Thank you. And in terms of Rochford specifically, we can see that at 2.37, that acute need that we've just looked at, it says this: housing needs studies and other data from sources such as the housing waiting list indicate that demand for housing is focused primarily on the district's largest settlements of Rayleigh, Hockley and Rochford, and there is demand as well in other settlements. So it's identifying a focus in respect of affordable housing need in those top tier settlements, isn't it?
That's where the concentration of people are.
Yeah. So a focus for affordable housing need in those top tier settlements.
There is.
Thank you. And then we can see that reflected in the table at 2.38, which is a snapshot. And I appreciate that housing waiting lists are always a snapshot, but this is the snapshot that's been included in the Council's core strategy as an indication. And we can see a snapshot of housing need based on the Council's housing waiting list in 2009, indicated demand as follows, and Rochford was second, 29% of the district's total. So presume that we can agree, well, we agree acute affordable housing need across the district, focus of affordable housing need in top-tier settlements, and a particular need for affordable housing in Rochford.
Yes, there is definitely a need.
Thank
Oh, and as you say, an acute need.
you. In 2.39, we start to see how that works its way through the core strategy, which is, as well as directing housing growth to areas of need and demand and away from unsustainable locations subject to constraints, the council must consider the relationship of housing growth to areas of employment. And then we see this at 2.42, the construction of additional housing will have the potential to deliver affordable housing to meet the current shortfall in order to supply housing for local community need. This will only happen, however, if planning policies are in place to ensure a proportion of the housing developed is affordable. So the point that's being raised in 2.42 is that the way that the plan anticipates that affordable housing is going to come forward to meet those acute housing needs is through the delivery of market schemes with a proportion of them required to be affordable housing.
As I said earlier, it's the definition of affordable.
Right,
And
well,
what price range we're looking at.
okay, but the way that we'll...
Yep,
yeah,
I understand that, yeah.
yeah, thank you. And then at 2.40, we see a recognition, having regard to the constraints that we've just looked at, that the development of additional housing will impact on forms of physical and social infrastructure. This impact will require contributions to be made by developers by way of planning obligations. Yep, you see that?
Sorry, what number were we looking
I'm
at?
so sorry, it's 2.40.
2.40, sorry.
At the top of the
Yeah.
page. Yeah, okay. Good. Then, if we turn up page 45, please. If we turn at page 45, please, we see at page 45 there is a heading, extensions to residential envelopes and phasing. You see that? Mm-hmm. And we see, in order to fulfil the requirements of what was then the East of England Plan, which was setting at that point the housing requirements, and meet the housing needs of the district, the council is required to allocate additional land for residential development, including land which is currently allocated as greenbelt, due to the limited supply of alternative land. And that's the point that I was raising a moment ago in respect of constraints. But what 4.17 tells us is that in order to meet the housing needs of the district, the council would allocate additional land for residential development.
Yes, it doesn't mention brownfield sites, does it, in this?
Right, well, no, but if you just focus on, if we may, that paragraph, please. The council's plan is telling us that in order to meet the housing needs of the district, the council will need to allocate additional land for residential development.
It does indeed, yeah.
Yeah. And then if we look at 4.18, whilst the council acknowledge the housing requirement stipulated in the East of England Plan is a minimum, we know it's gone up now, but at this point it's talking about those figures, it must also be mindful of the need to maintain greenbelt as far as possible. And then we see at 4.19, the locations and quantums for housing development set out in Policy H2 are such that on a settlement by settlement basis, when combined with development proposed through H1, which is points about efficient use of land for housing and sites that have been identified through that process. So the locations, and back to 4.19, the locations and quantums for housing development as set out in H2 are such that on a settlement by settlement basis, when combined with development through H1, a balanced strategy for housing provision is delivered. So that's saying, again, the council's looked at its needs, it's considered its constraints that we've discussed. It's that fair and equal distribution to meet housing needs is delivered essentially through policy, the allocations within policy H1 and H2. You see that?
I can see that. I don't necessarily agree with it, but I can see it.
Okay. So that's what the council's plan says. And then we have 4.20. In addition to identifying settlements where housing development will be directed to, so that's your tiered approach we've discussed, the core strategy also sets out areas around such settlements where an extension to the residential envelope is appropriate. The council will direct development to the most sustainable locations on the edge of settlements, having regard to a number of factors, including the proximity and relationship of existing centres, facilities and services, the availability of infrastructure and or potential for additional infrastructure to be provided for development in such areas. So that's been expressly considered. We can see there as a bullet point, yeah. The potential to reduce private car dependency, so that's also been expressly considered there as a bullet point, hasn't it? And the impact on the highway network, including availability and impact on existing network, as well as the potential for improvements to be delivered. So that's been expressly considered there as well, hasn't it?
Yes, it has, and I think it's also been covered by Councillor Eves' statements yesterday.
Right. And so having looked at all of those factors, those bullet points, and considered them, what we can see in 4.20 is that having identified the top tier settlements, there's also an identification of the areas around such settlements, which are the most sustainable locations to accommodate growth. That's what we see in 4.20.
As I just said, it does say that, but Councillor Eves has pointed out various points that we consider it will not work.
Right. Well, again, for purpose, I've done my cross-examination of Councillor Eve. I'm doing the planning bit with you and looking at the plan.
Fine.
So this is what the council's plan says. So that's what...
Can I just interrupt you?
Yes.
Sorry. When you say that you've done with Councillor Eves, if I don't actually agree with some of this on the infrastructure, can I actually point that out? Because can I just point out that Councillor Eves has made those points, or should I not? I would like to take advice on that.
You answer your questions as you wish to answer them.
All right.
And I'm happy for you to do that. Councillor Eves has given his evidence, but if there's something you wish to say in answer to one of my questions, I'm more than happy for you to do that, Councillor.
Thank you for the clarification.
Right. Then, so having identified the most sustainable locations on the edge of settlements, having regard to all of those factors, we can see where those are in policy H2, and that's the green box in policy H2. And this is, just bear with me a second, and policy H3. And so what we see in terms of policy H3 at 4.26, in considering general development locations for post-2021 development, so that's the period we're in now, isn't it, Councillor? Mm-hmm. The same issues as for policy H2 above have been considered. So just pausing there, those bullet points we've just looked at have been considered, we're told. Yeah?
Yes.
But areas identified for post-2021 development may not be immediately deliverable, or the situation with infrastructure is such that deliver earlier would not be appropriate. So it's essentially saying that some sites are earmarked in the same way for development post-2021, isn't it?
Yes.
Taking into account those considerations. And we're now post-2021. And then at paragraph 4.28, sorry, not 4.28, policy 4.
Policy or paragraph?
Sorry, just bear with me a second.
Yep.
So let me just check the reference. No, sorry, I've dealt with that point already. Sorry, then if we go to the policy itself, which is policy H3 in the green box, we see this. So post 2021, so that's now, the residential envelope of existing settlements will be extended in the following areas as indicated on the key diagram to deliver the following approximate number of units post 2021. Prior to that time, Greenbelt land will be safeguarded. So the temporal restriction of 2021, we're now past that, and you have no objection to this scheme, clearly on the basis that it's coming forward at the wrong time in terms of the plan. It's a post-2021 position we're now in, isn't it?
I've no problem with it coming forward, just we, as a committee, we didn't actually agree with it.
Yeah, that's a separate point in terms of impact.
Yes, it is,
isn't it?
yeah.
Yeah. So no problem in terms of time. And then we have this, the detailed location and quantum of development will be articulated within the allocations development plan document. So I'll turn to the allocations plan document in a moment, but what we can see from the table is that in the core strategy it's saying approximate number of units for South East Ashington, 500, yeah? And then it's saying it will look to precisely where that will be provided for and the quantum, so the number of units in the allocations plan, which came afterwards, yes? Mm-hmm. And then we see this. Just bear with me a sec, yeah. So then we see this, development within the above areas will be required to be comprehensively planned. A range of other uses and infrastructure, including off-site infrastructure, having regard to the requirements of the core strategy, will be required to be developed and implemented in a timely manner alongside housing. So it's talking about the delivery of infrastructure to accompany the development proposed there. And then it says Appendix H1 outlines the infrastructure that will be required for each residential area and should be read in conjunction with policy CLT1. Yeah, you see that?
Yeah.
Now, we know from the statements of common ground, and we can turn it up again if you wish, but we know that in the statements of common ground on behalf of the council, and if you turn up paragraph 4.2.2, please. And in paragraph 4.2.2, we can see the list of policies that are relevant, yeah? And one of those, it's just over the second page, is CLT, it's a bit of a mouthful, CLT1, which is planning obligations and standard charges. So that's recognised as being a relevant policy in that list. You see that?
I do.
And then onto the next page, and it's paragraph 4.4.1, but it's right at the bottom of that paragraph above 4.5 material considerations. And the sentence I'm taking you to starts with following the case management conference. Yeah. Says, following the case management conference in respect to the appeal, the local planning authority have confirmed the only policies considered relevant to the reason for refusal are SER 8, T1 and DM 31 as listed above. No breach of any other policy is alleged. So that's effectively confirming that there is compliance with policy CLT1. Yes?
Yes.
And if we look at policy CLT1,
Give me a page reference.
I will do, sir.
Yeah.
Sorry, my tab's fallen out, so just, pardon? 92, thank you.
Is that on the core strategy?
It is, yes.
I don't know what page she was on. 92. That's what's gone to. Gone too far.
It's okay, don't worry. Take your time.
Thank you.
So this is just a point of clarification in terms of what that policy actually says to remind ourselves, because we know there's compliance with it, there's no dispute between us. It says the council will require developers to enter into legal agreements in order to secure planning obligations to address specific issues relating to development, including requisite on-site infrastructure and the provision of on-site affordable housing. So we know there's compliance with that. And if you just now go back to page 48, what that is telling us is that the infrastructure that is required for each residential area is provided through the development, because it says should be read in conjunction with CLT1. We know there's no conflict with that, but also if you look at the list of relevant policies with which there is no allegation of conflict, we can see that the council agrees that there is compliance with policy H3, extensions to residential envelopes post 2021. Do you see that in the statement of common ground?
Yes, I do.
So what that means is that that requirement, because the statement of common ground is confirming that there is compliance with policy H3, what that means is that in terms of this policy of the core strategy, it is accepted that the range of other uses and infrastructure, including off-site infrastructure, having regard to the requirements of the core strategy, are coming forward through the development in accordance with that policy.
I can read it, and I agree that what it says, but on paper it looks very good, but in practical terms, I can't see how they can improve off SER 8 site the infrastructure going onto Ashton Road.
Well, again, that's the point about the impacts of the development, and we'll come on to that. But my point at the moment is in terms of what the plan is requiring in policy H3 specifically. There's no allegation of conflict with policy H3. There's agreement that there's compliance with policy H3 and CLT1. So in terms of the wording of the policy, the range of other uses and infrastructure, having regard to the requirements of the core strategy, are going to be developed and implemented in a timely manner alongside affordable housing in accordance with that policy. Because there's no conflict with it. If you didn't think that that was the case, having looking at the terms of the policy, you'd be alleging a conflict with it. So can we agree compliance with the policy on that basis? Thank you.
Ground.
Good. So compliance with H3. So compliance with H3, if we want a bit more detail about what that means, we can see that H1, Appendix H1, so that's an appendix to this policy, outlines the infrastructure that will be required for each residential area. And that appendix is at page 54. And our site is at page 56. So this is the location for growth identified in the core strategy. And so if we're looking at what we have just agreed is provided in accordance with policy H3, it includes local highway capacity and infrastructure improvements, including contribution to traffic management of Ashington Road, public transport infrastructure improvements and service enhancements, link enhancements to local pedestrian cycling and bridleway network, sustainable drainage systems, public open space, place-based youth facilities and community facilities. So we're in agreement that those are provided in accordance with policy H3. Your point, I think, Councillor, to be fair to you, is you're just not convinced that's enough and it's going to work.
Exactly.
Yeah. Okay. So provided in accordance with H3, not convinced will work. Okay, thank you. Good. So we then, just check how I'm doing on time. So do you want me to carry on? Or
Well,
do you-
I was thinking we started at 9. You've told me you've got 3 to 3.5
Yeah.
hours, so I thought we'd try and get through at least an hour and a half
But,
before looking for a break.
Yeah.
So round about 10:30,
Yeah.
quarter to 11. Because obviously I don't ideally want to take 2 breaks in the morning. Well, if we need to, but so if you carry on, Councillor Shaw, you still okay carrying on?
Could we stop at 10:30, please?
Okay.
If that's okay.
It's
Let's try that.
absolutely fine.
Yeah, we'll find a convenient point round about.
And just on the basis, I mean, Councillor Shaw's, we've had a discussion outside of the inquiry about specific requirements. If Councillor Shaw needs an earlier break, I've asked her just to let us know, if that's
Yeah,
okay, sir.
of course. I mean, and if we need a second break in the morning, then I'm quite happy with that. It's
Thank
just,
you very much.
Obviously, we've got things to get through, so I'm just trying to
Yeah,
press on as
no.
best we can. But yeah, okay.
Okay. Okay, so that takes us, so we've got compliance with policy H3, we've got provision of the infrastructure requirements set out within that policy. And then we know, because we've just looked at it, that what policy H3 said was that the location and precise quantum of development was going to be looked at through the allocations plan. So we'll turn to the allocations plan. Oh, sorry, just before I get to that point, there is another point actually, I'm sorry, which I forgot about. Yes, in terms of what was considered at that point in time and the core strategy and the infrastructure and so on that was being looked at and the locations for development, the Rule 6 party and also the MP have made reference in their representations to a decision. If you just turn up the Rule 6 parties, it's in the Rule 6 parties evidence, have made reference to an appeal decision. It's the Cogent Land case, High Court case. Don't worry, I'm not cross-examining you about law.
Good.
So it's the Cogent Land decision.
Is this one of the specific attachments?
It's attachment 12, sir.
Yeah, I've got
And-
it. Yeah, thank you.
So it's a High Court decision in front of His Honourable Mr Justice Singh. And as I say, don't worry, I'm not cross-examining you about the law. I'm interested about
Oh, please.
some of that wouldn't be proper for me to do that anyway, but I'm not going to. You'll be pleased to know. But this was a challenge. This was a challenge to the adoption of the council's core strategy. And we can see, and it's just by way of background, that at paragraph 5, and it's just by way of background in terms of what all of this was about, that the claimant in that case made numerous criticisms as to the production of the RCS, that's Rochford core strategy, yeah? And then it sets out what its grounds were, but essentially one of the issues was the approach that just trying to sort of simplify this, the approach that had been taken to the consideration of the council of reasonable alternatives through its plan process prior to adoption, okay? And the bit that I'm interested in looking at with you is if we look over the page, please, at paragraph 27. Sorry, 26 and 27, we can see that the court is looking there at the background to the core strategy in respect of the draft core strategy preferred options paper that predated the core strategy. And we can see at paragraph 27 that the preferred options for general development locations that were consulted on through that are set out. And then at 28, the alternative options for general development locations. The reason I'm skipping over those is, of course, because We then went through to the core strategy that was adopted, and that's the adopted development plan, but I'm just setting the scene in terms of what this was looking at. And in terms of the, it's paragraph 31. So this is an extract from the preferred options document that fed into and informed the core strategy. We see this. Rochford, Ashington, and this is a point that's been raised in the Rule 6 part in the MP's statements, but we see this. Rochford, Ashington has, in theory, reasonably good transport links to Southend and the A127, but in practice, the area is heavily congested, with congestion on Ashington Road being amongst the worst in the district. To the West Hall Road links directly to Cherry Orchard Way Link Road, but the railway bridge at the eastern end of Hall Road is a severe constraint on traffic movements. Now, those reflect some of the concerns that have been considered through this inquiry, but my point is those were concerns that were set out in the preferred options document that informed the core strategy, and nevertheless in the core strategy the council's decision was that approximately 500 units should nevertheless come forward in that location, Councillor, wasn't it?
Yes, that's what he said, but it does... when was this judgment made?
Well, the judgment, the judgment was made in answer to your question. If you look on it was 2012, okay? But my point isn't really about... My point here is about what informed the core strategy, which is the council's adopted plan. And my point is that those issues that have been raised here in terms of congestion and the railway bridge being a constraint on traffic movement, they were known when the council adopted its core strategy because they've been set out and considered in the preferred options document.
Yes, that's true.
Thank you. Good. Right, you can pop that one away.
Don't need this anymore at all?
No, you can close it. That's it. I told you I wasn't cross-examining. Don't worry.
So I can actually clear my desk a bit. Thank you.
And just to be clear, as the Rule 6 party and the MP has correctly noted, the claimant's claim against the core strategy was dismissed, which is why we now have the adopted document in front of us. Good. Okay, so those constraints were known when that was adopted. We've got compliance with policy H3. And then we then turn to the allocations plan. So this is core document 6.2, please. And again, this is part of the council's adopted development plan, isn't it?
Yes, it is.
The council's, not the appellants. And just as it was the case with the core strategy, you do not advance a case in your proof of evidence examination in chief to the effect that reduced weight should be given to any of the policies in this document. No. Okay. And if we just look at the firstly paragraph 1.8 of the core strategy.
Sorry, core strategy.
Sorry, allocations plan.
Yeah, okay.
Sorry, sir. On page 7. We can see this. The core strategy. I was reading it before I was saying it. The core strategy is the overarching planning policy document of the Local Development Framework, LDF, which sets out our main issues for the future and the policies which will shape the future development of the district. The allocations document will sit below the core strategy in the LDF and must conform to the approach set out in it in order to be sound through independent examination and to deliver our vision. The allocations document must not repeat the policies in the core strategy and should be read in conjunction with them. Therefore, both these documents will be used in the determination of planning applications for the development and use of land and buildings in the district. So that's just explaining there, isn't it, the relationship between the core strategy, which sets out the strategic priorities, the spatial objectives and policies, and the allocations plan, which effectively sits underneath it.
Yes.
And just in terms of the inspector's decision that you were taken to yesterday by Mr. Parkinson, which is at core document 6.14.
Sorry, Katie.
Bear with me a moment.
Get your steps in.
I think it's still open, so...
Oh, sorry.
And the paragraphs you were taken to by Mr. Parkinson are at page 6. And obviously the inspector can, just not going to read every paragraph out now, but just invite the inspector as part of his potential bedtime reading to read paragraphs 22 through to 29 there, so that he gets the full context of those paragraphs. But what we can see in paragraph 22 is there is a reflection there of a criticism that was made, presumably by objectors to the council's plan, that the overall impact on highway capacity had not been addressed. You see that?
Yes.
And then the points Mr. Parkinson took you to are effectively the inspector looks at that, records the fact that there's stress on the network at 24 and residents are sensitive to congestion. So these are points that have also been raised here that we've heard. Then we see at 25, and it's just this paragraph I want to focus on, because this is what the allocations inspector, and just bearing in mind the role of the allocations plan sitting below the core strategy, says this: that said, notwithstanding the general misgivings, there's no technical information about the impact of additional traffic. So what he's saying there effectively is that not finding that those concerns have been substantiated on the basis of the evidence before him. Furthermore, there is no other assessment to contradict the Highways Authority's position that the network as a whole should be able to cope. So reflection there that the Highways Authority position is that the network as a whole should be able to cope. And just pausing, we know that the Highway Authority has no objection to this specific scheme. No, you disagree with that, but that's the position they still hold. But then and it's this paragraph that I really want to focus on with you. Not paragraph, sorry, sentence. It's coming up to 10:30. We see this. Most significantly, the scale and location of development has already been assessed and determined through the core strategy. Because of all this, the allocations plan is sound in this respect. So the most significant factor that the inspector has identified in looking at those issues is that those issues have already been assessed and determined through the core strategy. You see that?
Yeah.
Thank you. Because you understand that the allocations plan has to be in general conformity with the core strategy sitting underneath it. Yeah. Okay. Good.
We're very close to half past.
That's probably just a good point to pause then, sir, I think.
Yeah, okay. Let's take the mid-morning break then. Let's take 20 minutes because there's a fair number of people. I don't want to be longer than that, but let's try and see if we can do it within 20 minutes. So I'll adjourn now. If we can resume at 10:50. Councillor Shaw, as before, you'll have to stay incommunicado from your colleagues, but okay. So adjourn now and resume at 10:50. Thank you. the inquiry is resumed, ladies and gentlemen. Ms Reid, just before I ask you to continue, at the start of the adjournment, Ms Wright indicated to me that she wanted to ask a question. So, Ms Wright?
I don't want to ask a question now, sir. I just want to know if under this process I will be allowed to ask a question before the end.
What I indicated when I opened is that I'll give the opportunity for interested persons who've already spoken to put questions to relevant appellant's witnesses. So that's what you'll be allowed to do. You've made your statement. I've got your written representations. So that's the sum total, as it were, of evidence to come forward from yourself. In terms of any other participation in the inquiry, yes, if you've got relevant questions to put to appellant's witnesses that haven't been asked by Mr. Parkinson or someone else, then yes, you can put that. But that's the sum total, as it were, of your future involvement. Having said that, sorry, you will be able to summarise your case, as I said, if you so wish, at the end of the day. But it can't introduce matters that you haven't already raised when you made your statement. So I say it's simply a summary of the case, of the information you've already put forward. Hopefully that's all clear.
It is clear.
Yeah, okay, thank you. Ms Reid.
Thank you, sir. So we were just looking at the allocation plan. And you deal with this at... Oh, sorry, I didn't realise I hadn't. Thank you very much. Start again. We're dealing with the allocations plan. And you deal with this at paragraph 4.6 of your proof of evidence, where you say, having looked at the core strategy, and H3 of the core strategy... Oh, sorry, I'll just wait for you to get
That's
it.
all right.
I'm so
Don't
sorry.
worry. I can stretch. Yep,
Okay,
that's it,
so
thank you.
yeah, you're dealing with the development plan. And at 4.5, you deal with the core strategy, and we've looked at that already. And then 4.6... 4.5, the core strategy, you talk about the extension of the residential envelope of an existing settlement to provide land to deliver housing to contribute towards meeting the local authority's 5-year housing land supply. And then you go on to deal with the allocations plan at 4.6. And you say, accordingly, the appeal site is allocated for residential development in the council's adopted allocations plan. And the principle of the proposed residential development is therefore accepted. And then you say that is not to say any form or residential development within the allocation would be acceptable. It's simply the principle of the residential development that is accepted. Now, I just want to be clear in respect of what's meant by those points in that paragraph. So just want to pick up a couple of points of clarification with you. The statement of common ground confirms that there's no allegation that the form of residential development in terms of design, density or layout or those considerations is objectionable to the council.
That's what it says.
Yeah. So the form of residential development is acceptable in this case, the form of it. Yeah?
Yes.
Yeah, okay, good. And in terms of policy SER 8, which is the allocation policy, if we just turn that one up. And
Give me a page reference again,
yeah,
please.
I can, sir, sorry. Just bear with me a sec. It's page 71.
Oh, what? Sorry.
Oh, sorry, the allocations plan, which is core document 6.2.
Oh, sorry. Which one? What number, sorry? What page number?
Sorry, it's page 71.
71. Thank you, sorry.
Yeah. And page 72 and page 73, and it just goes because it goes right through to page 76.
You want me to read all that now?
Pardon?
Are you going to...
I'm not reading all of
sorry.
it. No, I'm just locating the relevant page references
Okay.
for the inspector. Okay, so just a couple of points in respect of it. I just want to look at numbers first of all. So if you look at 72, please. And we can see Actually, I'm going to, sorry, 72 and 71. Start at 71, I'm so sorry. Paragraph 3.224. And we can see there's a recognition that the site, through the core strategy, the site in this general location should have the capacity to accommodate a minimum of 500 dwellings during the plan period. Yep, you see that?
I do.
And the Ben. And the end of the plan period is 2025, isn't it?
Yes, but that's not the application we had in front of us. The application we had in front of us was for 660,
Oh, I know.
not 500.
I know, I do appreciate that, don't we? Just taking it in baby steps.
All right, okay.
So first point at 3.224 is that the site in this general location should have the capacity to accommodate a minimum
Yep.
of 500 dwellings during the plan period. First point, end of the plan period, is 2025. Yeah? Yes?
Yes.
Okay, so it's anticipating then that a minimum of 500 dwellings should come forward before the end of 2025 during the plan period.
I thought it had been extended to 2029. That's what was discussed yesterday. And
No.
Have I misheard what you've said? Sorry?
So the 2029 date is the date that the traffic impacts were being assessed in respect of. The end of the plan period is 2025.
So if it goes ahead, they're going to do 500 units, or minimum of 500 units by 2025?
Well,
My understanding.
No, the capacity to accommodate. So it's talking about the fact that the site should come forward, so planning permission it's anticipating should be granted by 2025 to deliver a minimum of 500 units. Okay?
Yep.
Good. So the words so that's the plan period and when it's anticipated that those dwellings will come forward. And second point is that the word minimum is used there. So 500 is the minimum number, yes? It's not expressed as a maximum, it's expressed as a minimum.
I do understand what minimum means. Thank you.
Good. And if we turn over the page, we can see the circumstances that are set out within the policy in respect of when the numbers can be uplifted to more than 500 dwellings. And there are 2 bullet points, and they are as follows. Firstly, the additional number of dwellings are required to maintain a 5-year land supply. Now, just pausing there, it's a matter of agreement. It's a matter of agreement between the parties that there's no 5-year housing land supply, as I understand it. So there's a tick against that first point, isn't there? Yeah. And the second one is that the additional number of dwellings to be provided on the site is required to compensate for a shortfall that has been projected to be delivered within the location identified in the core strategy. And Mr. Pycroft has indicated that there has been a shortfall in the units projected for this Tier 1 settlement, Rochford Ashington, by 2021. And you haven't produced any evidence to dispute that, have you?
No, I haven't.
So what we can see is then that those 2 bullet points in 3.227, which allow more than 500 units to come forward on the appeal site, those have been met here.
Met the conditions.
Yeah, thank you. So met the conditions. And so when you are saying, if we just turn back to your proof of evidence, when you are saying at 4.6 of your proof, you say the appeal sites are allocated for residential development in the allocations plan, then you say this, the principle of the proposed residential development, so that's the 662, is therefore accepted, what you're saying is that the 662 is in accordance with that allocation, that number of units is in accordance
I
with...
do actually say that is not to say that any form of residential development within the allocation would be acceptable.
I know
in
you
my proof.
do. I know you do. And we've just looked at the fact that you've agreed with me. I take it, I understand you've got these highways points against the scheme. I'm just looking at the numbers now and what you mean by the principle of residential development. And so in terms of the numbers, because those two conditions in the policy are met, the principle of the proposed residential development, i.e. 662 units, as I understand it, is accepted to be in accordance with the allocation policy.
Committee didn't reject this application on the number of houses.
Right. Right, so is that... Okay, that's very helpful. So what that means is that the planning authority accept that 662 units are in accordance with the allocation in principle. Your point is, but there's also traffic considerations we need to take into account.
Yes, that's definitely correct.
Yeah. That's helpful, and that helps me just cut through things a little bit because I understand where we are in terms of that point. Okay, and just as a point in terms of the conditions that are set out in paragraph 3.227, in terms of uplifting the number from 500, they did not, in terms of the policy of the plan, and again, Councillor, I understand that you have a different view in respect of it, but in terms of the policy of the plan, they did not have, the policy of the plan did not have a cap introduced or a requirement imposed in respect of the number of units that might come forward having regard to traffic or highways consideration. We don't see that as a bullet point, do we?
No, we don't. It's just, as you say, it's a minimum of 500.
Yeah. Thank you. Okay, and then if we look at the parts of the allocation, policy and its requirements that are dealing with highways matters, and they start at page 74. And so hopefully, again, this is just points of clarification. I'm just ticking them off to just check if and where we disagree. At 3.243 on page 74, we can see that there's a point there about vehicular accessors. And just to be clear, the local planning authority hasn't taken any issue in terms of the location or suitability of the vehicular access.
It was discussed and debated at the committee.
Okay, but there's no reason for refusal on that basis
But
now.
it was, that was one of the reasons it was refused, because of the severity of the congestion on Ashton Road. We thought it would impact more on the Ashton Road.
Okay, let's just split it down into...
Do you want to split it more?
Split it down into smaller points. Sorry, it's probably the way that I'm putting the question in terms of that. I understand that you've got a point in respect of congestion. We know. But in terms of the site access and the location of the site access, and in particular now those highway safety concerns that we discussed are no longer being pursued as reasons for refusal, which we discussed at the beginning. The council does not object to this scheme on the basis of the location of the site access.
The actual location, they don't disagree.
Right, thank you. So no conflict, no material conflict alleged with that particular, I'm just taking it into that particular part, 3.243, okay? So the reason I'm looking at all of them is because they're all dealing with highways points. This is where we're dealing with them. And then at 3.244, it's talking about the potential to also have an access to the drive Percy Cottis Road, yeah, and it's looking at what needs to be considered in that respect. And again, it's hopefully this is a point of agreement because it's not been a point raised by the local planning authority. No issue has been raised in respect of the access on Percy Cottis Road by the local planning authority and its objection to the scheme, has it?
No, but can I clarify that again? In the committee, it was discussed how narrow that road is, and when there's no off-street parking for residents, and you wouldn't, at times, you wouldn't even get a bicycle down the middle of that road, let alone a flow of further traffic.
Okay, so councillor, understand your concerns, and I know residents have got concerns and we'll have a think about those later, but in terms of the local planning authority's decision and its reason for refusal, which we discussed at the beginning in terms of those points A to F, it's not a reason for refusal, is it, by the planning authority?
It's not being on
congestion issues.
Congestion on
Yeah.
the sites, both sites, from Percy Cottis Road and the Ashenden Road.
Right.
That's what the congestion and severity was.
But it's Councillor Eaves that's given the evidence.
He
in
has
respect to
indeed.
Congestion. So, okay, so in terms of in terms of the position in principle of that access and its safety and suitability, no issue taken with that. Your one relates to the congestion points Councillor Eaves has made.
Yes.
Okay. No issue, safety and suitability. Okay. So in terms of 3.244, which is really dealing with safety and suitability, and again, I'm just trying to understand where there might be a difference between us. Safety and suitability. So in terms of 3.244, no allegation in your proof of evidence or examination in chief or what you've just said to me that there's conflict with that particular paragraph there.
No, because Councillor Eaves covered it.
Well, no, Councillor Eaves doesn't allege conflict with that particular paragraph. What he said to us is that there are these congestion issues that need to be taken into account. So,
Okay.
No point has been taken anywhere in the council's proofs of evidence or examination in chief in respect of the point raised in 3.244. So no evidence produced in terms of conflict with that specific paragraph, Councillor.
No, that'll
Shaw.
be my personal opinion then.
Okay, right. So no conflict from the LPA.
No, it's my personal opinion.
Okay, thank you.
And that of my residents.
Okay, well, I'll pick that up either with residents or with Mr Blair, given that you're here. We're discussing the view of the local planning authority, if I may. Okay, so local planning authority, no conflict with either of those two parts. And then 3.245 is relating to public transport infrastructure improvements and service enhancements. Now, in respect of those points, there's no... We've looked at policy CLT1 already. There's compliance with it. So I know your point is, well, I'm not convinced all of that's going to work in the end, which is a separate point, because what 3.245 is saying is that there will be it says public transport infrastructure improvements and service enhancements will be required. The potential for the existing bus route along Ashenden Road to be diverted onto the site will be considered. So not a requirement, but to consider it. But in terms of CLT1 and the obligations in respect of public transport provision, it's not a reason for refusal on behalf of the authority that those contributions don't go far enough or that there would be conflict with policy CLT1, is it?
Can I just say, it says the potential for the existing bus route along Ashenden Road to be diverted. Yeah. It doesn't actually say considered. So it's...
No, it says explored.
Yeah, explored. But that doesn't mean that it'll definitely happen, will it?
No, sorry. Let's just, again, it's probably my questions are a little bit long. Let me just try and focus it. The local authority hasn't refused this application on the basis of inadequate contributions towards public transport infrastructure, service enhancements, or anything to do with public transport, has it?
No, and
okay.
Has the local bus services been actually consulted on this to say they would consider going onto the site?
Well, that's something perhaps you could ask Mr Parkinson to ask my witnesses.
Okay, thank you. But that's just a point I'd like to make.
Well, sorry, that's something you can ask your advocate to ask my, because I'm not allowed to answer questions because I'm the
no, I
barrister.
understand that. But whoever's listening, perhaps they could actually make a note of that and answer
Well,
that for me, please.
If Mr Parkinson asks them, I'm sure they'd be delighted to.
Thank you.
But if we could just return to the text here at 3.245, and it's just, all I'm trying to do, I understand what your case is, but what I'm trying to do is just understand which parts of this policy the council is alleging conflict with. And there hasn't been an allegation of conflict with this part of the policy, and actually you've accepted compliance with CLT1 in terms of the contributions that have been provided. Yep. So we understand therefore that there is no conflict alleged with this part of the policy.
That's true. Yeah, thank you.
Right, thank you. And then 3.246 is dealing with pedestrian cycle routes should be provided throughout the site. So, and also to the south of the site should be provided, etc. And again, no conflict with this part of the policy is alleged because pedestrian and cycle routes are being provided.
As the applicant's plans show, yes.
Yeah, so no conflict with this part of the policy. And as I say, I'm only dealing with these because these are all the highways ones, so I just want to understand. So no conflict with this part of the policy, okay? And then we have this, links and enhancements to local pedestrian cycling and bridleway networks should be provided. And a recognition that a modal shift to reduce use of private vehicles and encourage walking and cycling is particularly important in this location. Contributions towards the development of the proposed Sustrans cycle route may also be required. And we know that the planning obligation is providing cycle infrastructure contributions. And again, there's no conflict with this part of the policy alleged, is there?
No, but the bridleways won't be going down Ashton Road, will they?
Okay, but that's
immaterial.
I'm asking about the policy.
Yeah.
So no conflict with this part of the policy. Good. And then we have this, 3.248, a transport assessment, including an assessment of air quality, must accompany any planning application to develop the site. Now, before I move on, appreciate residents have got concerns, but the statement of common ground confirms, doesn't it, that the local planning authority is not taking an objection in respect of air quality.
That's correct, because we haven't got any monitors up on the Ashton Road.
So no objection, air quality. And then, I'll go back and now talk about the other bit of the policy. So transport assessment must accompany any planning application to develop the site. This must examine the additional transport impacts that the site will generate. Just pause. I will move on to the next bit. But we do have a transport assessment, don't we, that has examined the additional transport impacts that the site will generate. Yeah?
Yep.
So that part of the policy, there's a tick against it. I'll come on to the next part of it.
Yeah, again, that may be, but I don't, as you
No, you
are
don't
aware, I don't agree with it.
That's fine. Yeah. And then we see this. Actions, and I think this is probably where we just need to pause for a moment. Actions to address impacts identified through the transport assessment must accompany the development of the site or be provided prior to the commencement of development. So the policy is requiring actions to address impacts identified through the TA to be provided. And if we turn back to 3.224,
224, sorry.
which is on page 71.
That's where I was reading about wildlife.
We can see there that having set out the minimum of 500 point, which we've dealt with already, the overall site area is 23.5 hectares, to take account of site constraints and accommodate the following infrastructure, service and facilities. And it lists the infrastructure that's going to be expected to be provided. Yeah? You see that?
Yes, I do.
And so that's linking back to 3.248, isn't it, in terms of the actions that to address impacts that need to be provided.
Yes.
Yeah. And these ones here, this list this list of infrastructure provision that needs to be provided in accordance with 3.224 and 3.248 are the same ones that we looked at in terms of policy H3 in the core strategy.
Yes.
And so they are the ones which we've already agreed will come forward as part of the scheme. Yeah?
Yes, it is indeed.
And so I appreciate your point as well. None of that's good enough. Get that. But that means that there is compliance with the terms of policy 3.224 and 3.248, doesn't it?
Yeah.
Pardon?
But yes, it is.
Yes,
but if the
thank you.
impact is severe, it's not compliant, is it?
Well, no, that's a separate point, isn't it? 'Cause that's something that comes from the MPPF as a material
Yeah.
consideration. So what I'm doing is that section 38.6 test, which you look at the development plan first and then you look at other material considerations. So I'm not ignoring what you're saying. I'm just trying to understand where it comes into the balance.
Yeah, I appreciate that.
Okay.
Thank you.
So what we can agree then, having regard to all of that, because those are, I think, all of the highways points that are raised within the four corners of the policy, is that taking those into account, there is compliance with policy SER 8. Your point is there are other material considerations to weigh against that. Is that
Yes,
fair?
there is.
Yeah, I know that's
Yes,
it.
it is.
There is compliance with SER 8. Your point relates to material considerations. Good. So compliance SER 8. Thank you. And then if we then think about how that feeds into the other policies in the development plan, and again, I understand your point in terms of material considerations. So policy T1, please, next, which is in the core strategy at paragraph 107.
Just being found. There you go. Yep.
Now, what you'll understand, Councillor, because you're the chair of the planning committee, is you'll understand that when we look at the policies of the development plan and whether or not the proposal is in accordance with the plan, we have to look at the policies as a whole, don't we?
Okay.
So the test in section 38.6 is whether the plan is in compliance with the development plan as a whole, yes? And so when we are looking at policies in the development plan, one reads them naturally, or one should read them in a way that they are, insofar as possible, in regard to their plain meaning, consistent with each other, yes?
Yeah, also yes, sorry.
Yeah, so you don't want to adopt an interpretation of them which is effectively you've got policies pulling in different ways. Because it would create an internal inconsistency within the plan. Yeah? So you agree with that as a general
of course,
proposition?
yeah,
okay, good.
very generally.
Yeah, of course, of course. If we look at page 107, and this is where we see policies T1 and T2. And policy T1 says this. So firstly, development will be required to be located and designed in such a way as to reduce reliance on the private car. Now, just pausing there, we spent a lot of time this morning going through the core strategy, and that reflects, doesn't it, that sentence, this point about directing growth to the top-tier settlements, essentially, yeah?
Yes.
So because the development is in the top-tier settlement, there's compliance with that part of the policy, yeah? And also, because, so that's the located point, and because it's providing obligations in accordance with policy CLT1, which are going to provide obligations towards public transport, cycle infrastructure and so on, those are measures, I know you think they don't go far enough, that's a separate point again, but those are measures that are designed to encourage the use of modes other than the private car, so bus, cycling, etc.
Excuse me, can I just clarify that? I don't say the money wouldn't go far enough. I just don't think the proposals are workable along from the routes that the access will be coming out.
Okay.
So it's not a case of I'm disputing the money.
Yeah.
It is, the committee and I didn't think that it was sustainable what they were proposing.
Yeah. So your point again is one about congestion, and you don't think it's going to resolve the issue essentially in this location.
And for public transport and for cycle routes, because you can't put a safe cycle route on. You might be able to do it on the estate,
Yeah.
which will be good that you can go to King Edmunds. That would be appropriate, but there's not enough room even if you reduce the pavements. If we've got two SUVs, you will not be able to get a cycle route through there. And if any big wagons come up from the Baltic Wharf, they actually come over the white line, so it isn't safe for a cyclist. And we've got these new rules that are coming out from the highways that we've got to give priority to pedestrians. It's coming out this week.
Yeah.
So that's my concern.
Yeah.
As we've said before, it's very good on paper and it does look very good, but is it practical?
Yeah. Got your qualification in terms of practical issues, and I'm going to look at those.
Okay.
But at the moment, I'm just looking at the policies because I'm just trying to split it down into parts to understand where we agree and disagree. So those points in terms of the pavement and so on, we clarified at the beginning, they're not reasons for refusal, but they're something you think should be weighed in the planning balance, in the overall consideration of the matter. I'm looking at policy T1, and Councillor Eaves agreed with me, and I assume you do too, just to cut in terms of that first sentence, given its tier 1 location and given that there will be obligations which comply with policy CLT1 as we've discussed, there's compliance with that first part there. Developments will be required to be located and designed in such a way as to reduce reliance on the private car. So
Yes,
compliance with that.
I'll
yeah.
go with what as
Thank you.
Councillor Eaves.
Good. Right. Then, this next part. So, we have, however, some impact on the highway network is inevitable, and the council will work with developers and the Highways Authority to ensure that appropriate improvements are carried out. The council will seek developer contributions where necessary. Okay? Now, that's the bit I just want to have a think about with you. Now, we know, because it's what appropriate improvements means essentially. Now, we know, because we've looked at it, that we have allocations policies here, so policy H3 and SER8 read together, and you have agreed with me that the proposals are in compliance with those policies, and they set out a number of measures that the development will be expected to bring forward in respect of contributions and improvements, okay? So, if one is reading the plan as a whole, which we must do, where policy T1 is talking about appropriate improvements, the policy requirement is effectively to deliver, in terms of an allocation, to deliver the improvements that are envisaged through the allocation, yes? And if it does, and it also delivers against CLT1, which is your policy about obligations, which it does, the proposal is in compliance with policy T1 as well, read in the context of the plan as a whole.
Read in the whole context, yes.
Right. So we can agree then that the proposal is in accordance also with policy T1. Your point again relates to material considerations.
Yes.
Thank you. And then finally, and I don't think we need to spend much time on this because I think it's the same point really, but policy DM1, which is the third part of your development plan, it's the development management plan.
So again, a page reference.
Oh, so
please.
sorry.
We're in
I keep forgetting to do page 81.
6.3, is it?
It is, thank you, sir.
Page 81. Yeah, I've got it, thank you.
Is that page 18?
No, page 81.
Oh, 81, sorry. I've got DM1 on page 18. DM31.
And it's the same point really, but it's talking about major developments including appropriate traffic management measures, etc. And then it goes on to talk about what those might be. But again, the word appropriate traffic management measures within the meaning of the plan is talking about those where we're dealing with an allocated site, which we are here, those that are specified within the policies that we've looked at already, and also the obligations in terms of CLT1. And so it's the same point as T1 really. I assume that reading the plan as a whole, you accept compliance with that policy. Your point is about material considerations.
Yes, it is.
Thank you. Okay, so what we have, and again, understand the point about material considerations, but what we therefore have is we have a proposal that is in compliance with the development plan. Your point is that there are material considerations that outweigh the compliance with the development plan.
Yes,
Thank you.
as I've already outlined, I think.
Yeah, no, I'm just,
Yeah, of course.
okay. That's very helpful. So compliance with the development plan, but you say material considerations outweigh. Okay, let me just check where I'm up to, because I've sort of gone off piste a bit, but I think I've covered a lot of these points. So just give me a second if you wouldn't
Yep,
mind.
sure.
Okay, so yeah, just in terms, just bear with me a second of where we're up to. Yeah, okay, I'm going to deal with this point next, I think. I just want to have a think next in the context of material considerations about what the consequences might be in respect of housing delivery if the site's not brought forward for development. So that's the next topic we're going to be dealing with. And just a second. Can you please turn up the Statement of Common Ground on housing?
Is that a statement on the ground?
So, have a look. So, tab them all up and all the tabs. Do you have that one, councillor? Or is it just been found for you?
No, I've got it here.
You've got it. Sorry, I wasn't sure.
We're just tight. Well, sorry, we're just
I could just see somebody doing some housekeeping under the table.
Nice
So I wanted
housekeeping.
Right, so consequences. Statement of Common Ground on housing. And so we've already identified that the delivery of a sufficient quantum of housing is a key particularly affordable housing, but housing in general is a key priority for the council, as set out in its development plan, haven't we?
Okay.
And it's also, as I'm sure you're aware, a key priority of national policy, which seeks to provide a significant boost to the supply of housing. Yeah? And Statements of Common Ground on housing supply and delivery, again signed by the council, so you don't take any issue with the points set out in here, do you, as I understand it?
Oh, sorry, no, sorry. Shake of head, my belt
No, I
wasn't
know.
working.
I think it's just if somebody's looking away and taking a note, we might miss the head shake. So if you
Yeah, sorry.
Okay, thank you very much. Now, I'm just going to take you through some of the technical points in here because I just want to understand where they take us. And if we look at page 5, please. So, page 6. Page 6 has got a table in it, and what that table is looking at is it's looking at completions, so the number of houses completed, against the housing requirements of the plan, which is 250 homes per annum, and it's looking at the years when there's been an over or under provision against that 250 requirement. So, for example, you can see in 2007-8, I'll just take one near the top, for example, there were 169 completions, which was minus 81, which is the 250 minus the 169. You see, Councillor, just to talk through the way it's set out, yeah. So what this does is it sets out over and under provision, and then the last column there is cumulative over and under provision. So that column takes into account everything that happened in the years before as against the council's housing target, you see?
Yes.
Yeah. And so what we can see at the end there, bottom right, is that to the period 2020 to 2021, there was a cumulative under provision, because it's a minus number, of 829 units against the plan requirement. You see that?
Yes.
And so what that means is that firstly, the council has not, or it has not been delivered as many homes as firstly was anticipated as being needed, and secondly, as required to meet the plan requirements.
Yes, but these will not be for people on the housing list. There's 829 homes, and
Yep.
whatever broad, I'm saying on the SER8, they do 662 houses.
Yep.
That will not diminish our people on the waiting list, only by the social housing. It's if people, as we've said earlier, if people can afford the affordable housing, that's fine, but we've got many people that are on low incomes in this area that will never ever be able to afford any of this. So we may have the numbers not actually made what we should have, but it doesn't actually help our people, our residents on our waiting list. It will not diminish them.
Right, can we just take it in
I'll do it in bite sizes.
Yeah, bite sizes. Is that okay? So
Yes, of course.
just in bite sizes, there are 2 points in the Statement of Common Ground. One is dealing with housing need generally, so that's market housing generally, so not just affordable housing, but the number of homes that are required across the district, yeah? The second point is looking at affordable housing specifically.
Yep.
Now, what I'm looking at the moment is the general point in terms of market housing, because your plan identifies that there is a need to provide 250 homes generally per year, so that's market and affordable combination, 250 homes per year. And what I'm looking at the moment is how many homes have been delivered against that requirement.
Yes,
I'm going to deal with
understand that.
affordable housing in a moment, don't worry. But in terms of housing generally, there have not been as many homes delivered as were anticipated, and there have not been as many homes delivered as are required to meet your plan requirement of 250 per annum, have there?
No, I quite agree with that, with the
Lovely.
table.
Okay, and the cumulative shortfall to 2020 to 2021 is minus 829, and then we see at paragraph 2.5, to meet the housing requirements set out in the core strategy, 1,829 dwellings would need to be delivered over the next 4 years. So when it says the next 4 years, it means the 1st of April 2021 to the 31st of March 2025, and that's reflecting the monitoring periods.
That's
that
a
the
stated
council
in this
uses.
2.5.
Yeah. However, the council's housing trajectory only identifies a supply of 1,498 dwellings over the remainder of the plan period, excluding the appeal site. So therefore, and because we know that the plan period is to 2025, yeah, we discussed that earlier, both parties agree that there is a shortfall against the minimum housing requirement in the adopted development plan of 331 dwellings, and that's set out in paragraph 2.6. You see that?
Yep.
So what that's saying is that without the development site, the number of homes that the plan anticipated should be delivered to the end of the plan period will not be delivered based on the council's supply position.
That's what it says, but unless we bring in some brownfield sites forward.
Well,
That will help.
yeah, but well, councillor, what we have to do, you understand, when we're looking at housing land supply, is we have to look what the position is now as we sit here in front of the inspector, and secondly, we have to look at what sites are deliverable, because we know we're in that 5-year period now to the end of the plan period. And that, when we carry out that assessment, it's based on an assessment of existing planning permissions, allocations and windfall developments, which are in the council supply. So all of that's been taken into account by your housing officers, presumably that helped and assisted in terms of this statement. And what it demonstrates is that both parties agree that there is a shortfall against the minimum housing requirement set out in the adopted development plan of 331 dwellings. So what that is demonstrating is that without the appeal site, because that's not included in that calculation, the council will not meet its housing figure that it's required to meet by the end of the plan period. You see that, based on the current supply, yeah?
As it is now, but we don't know what's coming forward
Okay.
within this period up to 2025, which may actually bring more sites forward and help with the housing supply.
Okay, but you
But we don't know that because we haven't got them in. Well, I assume we haven't got our planning department as yet haven't got any new developments coming as at when this was printed on the 7th of
and
the 12th.
you understand this is based on your deliverable supply?
Oh, yeah.
Okay, good, thank you. And we can see that in terms of the council's trajectory, which is anticipating 1,498 dwellings, a supply of 1,498 dwellings over the remainder of the plan period, excluding the appeal sites. That's table 4, yeah? We can see that that is essentially assuming 380 units in 2021-22, 362 the following year, 447 the following year, and then 309 the following year, giving us the total of 1498. You see that? That's the
within
maths.
whole Rochford district.
Yes, it is. Yes. Okay. And just looking at those numbers there in that table, we can see that completions to that extent is going to be challenging, because there's only been, if you look at this, it's reliant on, for three of those periods, completions in excess of 360 dwellings per annum. And that is something that has only been achieved once, if you look at the table above, since 2006 to 2007. You see that? Yeah? So the point that I'm putting to you here is that even this 331 dwellings to the end of the plan period shortfall is conservative. Even completions at this kind of level in table 4 are going to be challenging for the council, aren't they?
No other applications come forward, yes.
Okay. Thank you. And in terms of other allocations and other sites that might come forward, if you look at page 9, please, that sets out the latest position in respect of housing allocations. And this is the agreed position. Okay, and you can see at 2.12 it says it's agreed the following table sets out the latest position on residential allocations in the allocations document, and the appeal site is the last of 9 settlement extension residential land allocations to start delivering dwellings. And we can see there that effectively there's no, other than the appeal site, there's no capacity left within the other allocations to deliver the 331 dwellings required to the end of the plan period.
Well, we've got 500 on SER 6, which is going to be completed in 20...
Yeah, that's accounted for in the numbers though, isn't it?
That has been counted, and so has the Great Wakering site?
Yeah, so those are...
They're actually in this site?
Yeah.
Okay.
Yeah, so sorry, the point is that when you're looking at your forward supply, you're looking at ones that might have planning permission or be an allocation that can come forward in additional... additional ones.
Okay.
So those sites have already been counted, yeah?
Yes, because that make it clear in the... Sorry, that
yeah.
clear.
So those have been counted. So my point is, in terms of additional sites, that there isn't additional spare capacity of any other allocations, etc., that can meet that 331 figure to the end of the plan period.
Not that has come forward at today's date.
No, but no, not at all, because what this table does is it looks at what those allocations are and what their existing position is in respect of them. So they're either complete, not deliverable, or under construction. So my point is, this is the only allocation that can come forward within your plan to meet that 331 unit shortfall.
But as I stated before, this is the as at today.
Yeah.
But if, for argument's sake, if next week we get an appeal decision that's gone against council and we get an allocation for 300 homes, and this is hypothetical, then that could be added into this plan.
Sorry, I think
added into these allocations.
I think we're talking at cross purposes. So I'm not talking about windfall planning permissions, which are ones that come forward not on allocated sites. I'm talking about allocated sites. So page 9 sets out what the position is in respect of the sites that the council has chosen to allocate in its development plan. So that have some planning status now, yeah? And what that table demonstrates is that there is no additional capacity on any other allocated site
to increase the
numbers sufficiently to deliver those 331 dwellings by the end of the plan period.
I accept that.
Yeah, thank you. And so what that means is that as we sit here now, based on what we know, because the deliverable supplies looked at existing planning permissions and also sites that are deliverable that perhaps don't have planning permission, and it's also, we've also just discussed what there is in respect of allocations, which is not sufficient capacity within them to meet that particular housing need, 331 to the end of the plan period. What that means is that the appeal site, which is an allocation within the plan, is critical to achieve the numbers that the plan envisaged would be delivered or come forward by the end of the plan period, isn't it?
But yes, but that's not why we refused this application.
No, I know, and I know you've got your other material considerations.
Yeah, but I say we did not refuse it on 500. Well, we didn't refuse it on 500 because the application was 662. No. So that wasn't a reason why it was refused. No. And I fully agree, this is on the appeal site, and it would help for the housing allocation that is needed within this area.
Yeah. But I just want to be clear, because I appreciate your point in terms it wasn't refused on that basis, but you'll understand as the witness that's doing the planning balance, that as well as the other impacts that you've taken into account, you also have to take into account the benefits.
Of course.
And so, yeah, and so my point really to you is that this allocation, and not only this allocation, but the 662 units that are being brought forward in accordance with that allocation, are critical to meet the requirements of the plan to the end of the plan period.
Yes, yeah, for the 800 and whatever, yeah.
Yeah, thank you.
191.
That's very helpful. And we also know, though, that the 250 figure, which was in the plan, and you've alluded to this several times, does not now reflect the requirements in the framework, because now the framework says that the council's housing need is actually 362 rather than 250, doesn't it? Yeah. So what that's telling us is, in fact, that it's even more important, critical, more important, that those allocated sites come forward because the housing requirement has increased now. Yeah?
Yeah, as long as the housing, well, we can't stop anyone from outside the district. We may have 662 houses, and then we're not going to talk about the social housing, but if you reduce that, if you've got 400 units it will take our need out, but it will not necessarily help our residents, because people outside can actually buy the houses. So even though we may produce what they say, it doesn't actually affect or help our people in this district.
Okay, but you understand that as chair of the planning committee and an affiliate member of the RTPI, you understand that national policy and the PPG, it sets out a formula for assessing what the housing need is in this district, and that housing need is 362 dwellings per annum, and there is a requirement for the council to identify sufficient sites to accommodate that need, and because that need is now figure higher than your development plan figure, it's even more critical, even more important, that the sites that the council has allocated in its plan come forward to assist you in terms of addressing those needs.
Yes, but we have issues with the infrastructure.
Yeah, got that.
I know it's going to be, we highlight that all the time, but I do think it's a very good point.
Okay, well, don't worry, we're going to come to the overall balance in a minute, but I'm looking at the components of it.
Yep,
so
that's fine.
Even more important that allocated sites come forward to meet those housing needs. Okay, and we also know, if we look at 2.34 of the Statement of Common Ground, please. Oh no, there's not a 2.34, just bear with me a second. 2.24, sorry. 2.24 on page 11. And 2.23 just above it. And you can locate that by reference to a table. Do you have that?
Yep.
Yeah. So this is telling us here, because you're also aware as chair of the planning committee, that there is a requirement, and it's a requirement of national policy, to demonstrate a minimum of a 5-year housing land supply against that housing need figure that we've just discussed. Yeah?
Yes, I do.
And we can see in paragraph 2.23 of the Statement of Common Ground that the council's forward supply is 4.04 years. You see that?
Yep.
And so the authority is not meeting its minimum requirement in respect of its forward supply as set out in national policy, is it? Which is a minimum of a 5-year housing land supply.
Oh, sorry.
Yeah,
I thought
Yeah, okay.
Sorry.
And we can see it's also agreed at 2.24 that both parties agree that should the appeal be allowed, then the shortfall in the 5-year housing land supply would be addressed by the deliverable dwellings on the appeal site, and therefore the council would be able to demonstrate a deliverable 5-year supply at the 31st of March 2021. So just pausing there, what that's demonstrating again to us is that the delivery of the appeal site, which is an allocated site, is critical because it's going to allow the council to effectively recover its 5-year housing land supply position.
Yes, it's an allocated site.
So it's critical, isn't it?
It will be.
Yeah. Good. Now, we're going to turn to affordable housing next. So we've already looked at the fact that the affordable housing needs are acute in the core strategy. That was a core strategy that was adopted in 2011, so we're now 10 years on from that. Now, what I'm going to do is I'm going to look at what the need is with you, and then I'm going to look at how we say it will be met through the appeals scheme. So 2 stages, 2 bite-sized chunks to what we're looking at. So if you look at the Statement of Common Ground, please, and it's paragraph 2.24. 2.7 is where we start dealing with affordable housing delivery and supply.
On page 7.
Yes.
Yeah.
And we can see at 2.7 that there's a reference there to the core strategy, which was talking about that at the time the core strategy was adopted, there was a need for 130, it identified a need for 131 net additional affordable homes to be developed in the district per year. So that was a net requirement for 131 units. You see that, yeah? And we can see in the table, in the following paragraph, that it is agreed that only 362 net affordable homes have been delivered in Rochford 2006 to 21, which is an average of 26 affordable homes per annum. You see that?
Yes.
So that is very significantly below the 131 net additional homes per annum that the core strategy identified was required, isn't it? And we can see actually, if you look at the table, because that's the average figure, in terms of, we've got affordable housing needs, that's the 131 figure, completions, shortfall against need, and then cumulative shortfall. And we can see that since 2006, which is the start of the plan period, even though it was adopted in 2011, that there has not been a single year where that affordable housing requirement has been met. Yeah, you see that shortfall against need. They're all minus figures.
That's right, because we've got only got a 35% on each development. So unless you allow thousands of houses to come into an area, then it won't be. This will not be completed.
I'm thinking about what the need is.
Oh, we definitely need social housing, as I think I've said and others on their statements.
Yeah, so just looking at the table, what we can see is there has not been a single year
that we've achieved it. No.
And we can see at the bottom of the page, in the right-hand column, we then have a cumulative shortfall, which is standing at 1,603 dwellings as against that core strategy figure.
Yes.
And then what we
Even
also...
though it's getting better, as we can see in the last 3 years, it's still not good.
No, exactly. And then if we look at 2.9, we see that there's a more recent SHMA that's been produced by the council, which contains the latest calculation of affordable housing need in Rochford, and demonstrates a significant need for more affordable housing across all tenures, which is the point that you've raised, Councillor. And it says that it identifies now a need for 296 affordable homes every year, falling to 238 after 5 years over the period 2014 to 2037. So it's a different period, but it's effectively rebasing the need, isn't it, and looking at that. And it says against this, so it's coming out with the same shortfall almost, bar 3 dwellings, but there is a shortfall of 1,606 affordable homes between 2014 and 2020, and that's set out in the following table. So however one gets to it, the position is that there are over 1,600 homes that were needed and that have not been provided to date.
To date, yes.
Thank you. And what we can also see is, because you recall when we spoke about the core strategy, one of the things that we looked at was how those are delivered, and it says that, well, the only way really that we can do that is through market-led schemes where a proportion of the housing is required to come forward as affordable housing. Now, I'll look at what the appeal scheme does in a moment in terms of that, but we can see at 2.10, in terms of other things that are happening, that the council's supply over the next 5 years is 471 homes. You see that?
Yes.
Now, obviously, over the next 5 years, you've got an additional requirement that arises year on year, as well as the existing shortfall of 1,600 odd affordable homes that are required, yeah? And so the council's existing supply, the 471 figure, is not going to scratch the surface, is it, of meeting affordable housing needs in the district?
Not according to these figures, no.
These agreed figures.
These agreed figures.
Okay. And then what the appeal proposals, just bear with me 1 second, because I just want to check something. Reference, just a sec. Just want to make sure we're not talking at cross purposes. Okay, so at 2.11 of the Statement of Common Ground, what that records is that given the position on affordable housing delivery and supply in Rochford, it is agreed that the delivery of 232 affordable homes at the appeal site carries very significant weight in the planning balance. Now, that's the agreement. Now, I just want to be clear that you understand what we're actually delivering, because I'm not sure from some of your answers that
Oh,
that we do.
I have read it, and I do know how
So-
many there was.
No,
yes.
it's not just the number. So in the framework, in the MPPF, there is a definition of affordable housing at the back of the framework if you want to have a look at it. And it's housing for sale or rent for those whose needs are not met by the market, including housing that provides a subsidised route to home ownership and or is essential for local workers, and which complies with one or more of the following definitions. And I'm not reading them all out because they're all quite lengthy, but they're set out there. And so there's a specific definition of affordable housing within the MPPF. And what the appellant is providing is 80% affordable rent and 20% shared ownership, and shared ownership available to households with less than, with a certain level of income, yeah? And 20 wheelchair adaptable affordable units, 72 accessible and adaptable units. And the obligations in respect of what we're providing in terms of the types of housing and the fact that they need to be affordable housing that falls within the definition of national policy, so not just low-cost market housing, but affordable housing, is secured through the Section 106 obligation. And I
do agree with I
Yeah.
completely understand that, but on the Hall Road estate, the affordable housing, the minimum rent is £600.
Right.
And as I will go back to, if you've got carers on minimum wage, £600 odd is not affordable. And this is what I was trying to say earlier. I appreciate we've got this new development will give us 232, 35%. Completely agree with that. I completely agree with the figures because I've done finance all my life, so I do know figures. But my still point is the definition of affordable is that's what we've got to look at for the residents of Rochford.
Right.
The Rochford district.
So, but I want to be clear, because the local planning authority's position here at 2.11 is that taking into account the definitions of affordable housing in the framework and the specific obligations that my client is delivering through this scheme, not talking about other ones, but this scheme and the obligations offered here, because that's what we're dealing with, the agreed position of the authority is that very significant weight should be attributed to that in the planning balance, as set out at 2.11 of the Statement of Common Ground. You agree with that, Councillor? Thank you. Okay. And in terms of, just in terms of Yeah, and just in terms of the provision of housing generally at 2.25, so sorry, I should have raised this point when I was talking about the general position earlier. It's also the agreed position in terms of the general position with those housing numbers, that new housing at the appeal site would carry significant weight in the balance. Yeah?
Yep.
Good. Okay, and then what I want to do as well is also think about the degree to which the council's emerging plan is going to effectively come to the rescue in terms of the housing needs that we have considered. And we know, you can pop that one aside now, the Statement of Common Ground.
Where's the emerging plan?
If we turn up,
Excuse me, I don't think I've got a copy of that. What's the reference?
it's core document 6.4. Sorry, I'm just trying to find it as well. Just bear with me a sec. Yeah, it's just behind the. Oops. Oh, sorry, you've got different folders to me, apparently, in terms of the way they're organised. So it's the one that looks like, I did tab it up the other day.
Yeah, that's what we've got.
You got that one?
That's fine.
So sorry, CD 6.4.
6.4,
Yeah.
sir.
Yeah, I've got it. I can read it.
Okay, and this is the new local plan spatial options consultation paper 2021, yeah? And it's at regulation 18 stage, so it's being consulted on, and it's consulting on spatial options for an emerging local plan, isn't it? And just bear with me a second. And I think on page 5 it said that consultation will close on Wednesday the 22nd of September 2021. So consultation's closed on it. What it does at page, if you turn at page 7, please. And it's page 7 is setting out that this is a consultation paper that forms the latest stage in the production of the council's new local plan. And it sets out, this is paragraph 2, a range of challenges and opportunities relating to the district, and it's looking at how the district can change and grow over the next 20 years. And it says, just bottom sentence there, this consultation is an important step in exploring the advantages and disadvantages of different strategy options alongside the contribution these can make to fulfilling the objectives of the district and its diverse settlements. So I'm not going to read, the inspector can read all of that later, but that's basically...
You're not going to read the whole lot now?
I'm not going to read the whole lot. So that's basically what it's aiming at. And it's right, because it's been out to consultation already, and it's a Regulation 18 consultation. So as I understand it, the process in this council is that prior to this document going out to consultation, it would have been approved firstly by the policy committee and then secondly by full council.
Yes.
And that was in July 2021, I think. Those are my instructions. If you can't remember the exact date.
I can't remember, but yes, I could always go back onto the minutes.
No, don't worry. I don't need the July.
Break,
But
I can always go through the
last year.
minutes. Yeah, it would have been last year, definitely.
Year, yeah. And my understanding from those, did you, I think you voted to approve this document when it went out to consultation?
I've got my book over there with all my minutes on, so I can actually tell you.
Okay. So you voted to approve this document to go out to consultation. And just if we look at it on page 8, in terms of looking at what the potential options for the district might be, we can see there that there's a reflection. It's under how have we got here, and it's talking about that there's a reflection that prior to formulating the options, there was a period of community and public engagement that the council would have taken into account. Yeah.
Yep.
If we then turn to page 49, please. we see again at the top of page 49, why is it important to plan for the right amount of growth? And it's talking there about the up-to-date position. Rochford district's an area with known housing challenges, many of which have been exacerbated by COVID. Our housing register has grown by 20% in the last year to around 1,000 households. So just pausing there, that's the more up-to-date position in respect of the council's housing waiting list. And what we can see is that there's been a decrease, there's been a decrease in the supply of affordable home, or an increase in the housing waiting list since the core strategy was adopted. And the ratio between house prices and local earnings is amongst the least affordable in the country. So it's again recognising that there really are the most significant affordable housing needs in this district, aren't there?
Yes, there is.
And when new homes are built, around a third of these are built as affordable, typically discounted by at least 20%. By taking a positive approach to growth locally, we can help create a more inclusive housing market, avoiding the emergence of housing-related issues, including homelessness and concealed households, such as whereas younger people are forced to remain or return to their family, etc. So those are the points we've just discussed in terms of those needs. But the point here is recognising those needs, and that the council needs to plan to accommodate housing needs going forward.
As our population grows, we need more houses.
Yeah,
That's a fact of life.
it is. And if we look at page 73 and 76, we can also see there, and I don't think I need to read these out, but it's effectively the same point. And if you just cast your eye over the first two paragraphs at 73.
Again, I would say we do need the right houses for our local people, and this is what they'll be looking at this new local plan.
Yeah. Okay. So it's recognising the importance of continuing to plan for and provide an adequate quantum of affordable housing, essentially.
It's a very poor council if we didn't do that.
Thank you. If we then look at page 53, so page 53 is looking at what options are available to the council.
The option one, urban.
Yeah, so this is looking at, and I know obviously the council needs to determine which of these options it's going to, because we can see at pages 53 through to, well, it's about page 61, but essentially there are a number of options set out here in terms of how the council will accommodate its growth, yeah?
Yes.
And strategy 1, urban intensification, and it says, option 1 is the minimum expectation of national policy and is likely to be required within every strategic option. This option would be to make best use of our existing planned development and also brownfield sites and so on, which you've already mentioned. A strategy based on urban intensification could also include taking a more permissive approach to higher densities in suitable locations, such as at town centres and near stations. We expect that at least 4,200 homes will be built over the next 10 years under this option, and our urban capacity study suggests a further 1,500 homes could be built through a mixture of maximising capacity of planned housing developments and taking a more permissive approach to higher densities in urban areas. So I'm just going to pause here and break it down into bite-sized bits. So the first point in respect of this, and the options that the council has approved through this, the potential options that the council has approved at Regulation 18 stage, every single one of those options includes that first option, which is 4,200 homes through urban intensification. Yeah? So that is because option 1 is the minimum expectation of national policy. We see that in the first sentence, yeah?
Yeah, and obviously we're going to be bringing the brownfield sites forward before Greenbelt.
Right, okay. Well, we'll look at that, how you're going to do it in a minute,
Okay.
but just bite-sized for the moment. So option one is reflecting the minimum expectation of national policy. And you're right, is likely to be required within every strategy option. And the reason that it is, and I think this is the point you're raising, Councillor, necessary to include it in any option that the council might consider going forward, is because if we look at, because we've looked at the Greenbelt constraints across the district already, and that's because paragraph 141 of the framework requires authorities, before they look to Greenbelt release and exceptional circumstances for Greenbelt release, it requires the strategic policy making authority to demonstrate that it has examined fully all other reasonable options for meeting its identified needs for development. So it's saying you maximise other opportunities before you move to release more land from the Greenbelt, essentially.
Well, that's what it says, so that's what we should, any council, and we should be doing that as well.
Exactly. So, so option one is something that's going to happen. The other options within the preferred option document talk about whether and to what extent you also then release Greenbelt on top of that option, essentially. That's right, isn't it?
It's, yeah, obviously it's looking that it says we expect at least 4,200 homes. And how I've read this is we do the brownfield sites first. We don't know how many that will bring in. After that, then there may have to be an option to go into the Greenbelt. But first, before going into any Greenbelt, we do the brownfield sites.
Yeah. So what I think where we are with that is that the 4,000, although this is at a relatively early stage because it's regulation 18 stage, and in terms of these other options, so options 2 to, what is it, 2 to, is it 5, 4? 2 to 4, options 2 to 4 will look at if and to what extent you're going to then go into the Greenbelt and where, etc. We're not really concerned with that here because we've got an allocated site. But in terms of the baseline position, the council accepts that it is going to need to bring forward the sites under option 1 for those 4,200 homes.
At that stage, but if we're not actually going through all this, why are we discussing it if we're only going to SCR8? If we're only appeal is SCR8, I'm a bit confused.
Okay, well, just bear with me. So the council accepts it's going to need to bring forward those sites to deliver those 4,200 homes in accordance with the minimum expectations of national policy.
Yep. Agree.
You? Good. And if we look at what those 4,200 homes are comprised of, we know we've talked about the brownfield allocations, but if you look at page 47, please, and 40, oh, just bear with me a second, is that the right? Yeah, page 47. This is looking at the, and it's planning for housing growth, and it's the bottom paragraph in that little section, housing and economic land availability assessment. Do you have the reference there?
Yeah.
So what that says is our housing economic land availability assessment, I'm just going to abbreviate that to HELA from now on, 2020 identifies a supply of 4,300 homes that are already planned for. Yeah? So that's reflecting that figure we've just looked at in option 1. Yeah? This includes existing allocations, sites with planning permissions, and an allowance for windfall developments of around 45 homes a year. Windfall development is development which happens on sites which come forward unexpectedly and are not provided for in the local plan. So what that's telling us is option one, which is required to meet the minimum requirements of national policy, and which is part of every single option that the council might pursue, as set out in here, includes bringing forward existing allocations.
Yes.
So existing allocations include the SER8 allocation.
Yes, sorry, yes.
Yeah. So by resolving to put this preferred options paper out to consultation, which was approved at full council and included you voting for it, what that demonstrates is that the local planning authority also recognises that in its new plan, in order to meet housing needs going forward, that is going to also need to include the existing allocation at SER8, isn't it?
Yes.
Thank you. Good, and okay. Done that bit. Dealt with that, just bear with me a moment. Dealt with that. Okay, so now I'm just going to look at a few other matters that are sort of, you can pop that away now.
Go on the floor, I don't need to
Yeah,
bring
put
it
it
up.
on the floor, it's fine.
I'm not into weightlifting today.
Now, what I just want to consider with you now is a few other inputs in terms of the planning balance in respect of benefits, and then we're going to look at the planning balance as a whole. Okay, so that's the sort of topic approach we're going to be thinking about. And we know that the local planning authority now has no objection to the scheme that it says is a sufficient basis to refuse planning permission based on those highway safety concerns that you outlined in your proof of evidence, yeah? No, Councillor Eaves has got his point about the mitigation, but I'm talking about the ones that you dealt with in your proof in the vicinity of the appeal site, yeah? And so we know no highway safety issue sufficient to found a reason for refusal there. We also know that it was initially the case that the local planning authority took issue, and if we just turn back to your proof of evidence, this was initially your point B, which was the pedestrian safety generally, in a view the package of measures proposed by the appellant was simply renewing what is taking place. You recall that one, which has also been, the council also is no longer pursuing. Yep. Yeah. But I just want to have a look at those with you. So for this, you're going to need the Highways Statement of Common Ground with the Highways Authority, please.
It's the green, isn't it?
Okay, and attached to that document, there is a drawing. I'm just going to hold it up so you can see what it looks like. You're looking for one that looks like that. It's in the vicinity of the side.
First one or the highways?
The Highway Authority one. The one from the Highways Authority between the appellant and the highway. Have you got it? That one.
Yeah, oh, mine's in colours.
Can you hold it towards
Sorry,
me?
sir. It's drawing 185 180 004, and it's showing the site access and works there.
Yeah, got it.
Thank you. And so, all right. So what we've got here, and it's just telling us about some of the, and we know the council doesn't object on the basis of B anymore, but I just want to be clear what we're talking about in terms of what we say are upgrades in the vicinity of the school in highway safety terms, okay? And we can see, just bear with me a second, at the top of the page and at the bottom of the page, that there is going to be existing signs are going to be replaced with flashing school ahead signs, yeah? So that's going to warn motorists with flashing LED signs that the school, they're on the approach to the school. You see that?
Yeah.
So that's a benefit, isn't it? Because it's telling, well, it is, isn't it, Councillor?
Well, yeah, if you say so, but I do know that a lot, we've got the VAS signs in other areas that are completely ignored, so, and it'll be it'll be queuing there, but yeah, for safety reasons, yes, I will say yes, but they would, with my experience, they most probably be ignored in other parts of our district.
Well, let's hope that people do what they're legally
Well, let's
obliged
hope
to
so,
do.
yes.
And we then have pedestrian guardrails. And the point about pedestrian guardrails is that they segregate pedestrians from traffic, don't they? That's their purpose.
Yeah, we have them there already.
Yeah, but you understand that they're actually going to be increased in respect of their length, I think by 20 metres? 20 metres,
Yes.
yeah. They're also, the visibility of them is also going to be improved, brought up to standard. So again, that's a benefit, isn't it?
That'd be a benefit.
In terms of highway safety. And in terms of the Toucan crossing, we can see there it says existing Toucan crossing to be retained and extended for widened carriageway, refuge island added, signal operation to be modified if necessary to ensure efficient and safe timings. We also, refuge island there, we also know from Mr Blair there's going to be renewal of the anti-skid surfacing there, which is worn at the moment. So again, that's a benefit in terms of highway safety, isn't it?
Can I just point out, and I'm not being awkward, it is a benefit, but when you've got the age of the children, they don't always adhere to the highway code. And they're in the middle of an island and they see their friend across the road, they have a tendency, they don't think, they're too young, they run. And we've already had 3 accidents in the last 6 months with children along that because they've just, if you've got young children, they just look, they don't look outwards. So it could be addressed, but I don't think it is.
But you know, I suppose...
But highways perspectives will say it is
Yeah.
an improvement.
Well, but I mean, just thinking about that point in terms of children, in particular, say, primary school children, you know, anti-skid surfacing is a benefit for kids, isn't it? Because it's going to stop them skidding sort of onto the road. A refuge island is also a benefit, isn't it? Because it's providing a refuge in safety terms. So my point is here that you might say, well, okay, there are still outstanding issues, they're not sufficient to lead to a reason for refusal, but there are benefits here as well, aren't there?
The minimum benefits.
Benefits, okay. We also know that there are going to be provided alternative routes through the appeal site, which is, in particular, there are going to be routes from those to the south and north to access Waterman Primary School and King Edmund School by avoiding Ashington Road, because they'll be able to walk through the appeal site, won't they?
That's after, while the construction, it won't help. Well,
Yeah.
it'll be after the construction is finished.
Yeah,
And most of the children going up to King Edmunds will go straight up Ashington Road into the Co-op or Cafe 206 to get their lunch.
right.
And that is what they do now, and I cannot see that being altered. They will not go through the new site to school. A lot of our children will go and get their breakfast before going into school, unfortunately, because they do not have breakfast at home.
Okay, but there will be, and you know, you might say, well, not all of them will use it, but there will be alternative routes provided through the site which allow the option for pedestrians to avoid Ashington Road on that basis, won't there?
Most of the parents that use Watermans do not use the Ashington Road. They come from Malting Villas, the Drive, St Mark's Field and St Clair's. So they're the school and catchment areas, so they would not actually use the Ashington Road to go to Watermans. The parents that use Watermans would be St Teresa's, it would be Rochford Primary, St Teresa's, Holt Farm Junior, Holt Farm Infants. You've got a nursery at St Teresa's, and then you've got King Edmunds.
Okay, let me just take it really simplistically, do you accept that providing alternative routes through the appeal site will provide some benefit?
Only to the people going to Kes, not going to Waltons.
Thank you. And so what we have there is we don't, okay, next point is in respect of highway width, So we know that that's no longer a point being raised in terms of highway safety as a reason for refusal. What you do though, Councillor, I'm just going to pick this point up with you in terms of your residual concerns about it, but you do include in your proof of evidence a letter from ECC. I just want to turn it up because there's a chronology here in terms of the letters from ECC, and you've included one at Appendix 2, which is from October 2020. And that's the one that, as you say, sets out the point about it being a downgrade, essentially. That's what you summarise in your proof of evidence, albeit acceptable in highway safety terms. But then if you look at Appendix 4, there's the letter dated the 12th of February 2021. Yeah, sorry, just checking you've got that. And so this is, we can see here that this was following a letter from the council seeking further views and clarification in respect of education, public health and highways matters. Do you see that? Yeah. And so there's a question there about the minimum technical width point. And over the page under 3, some more points about that, but making it clear there, we do not consider the proposal to reduce the foot and cycleway to be unacceptable, providing it meets the minimum technical standards for shared or segregated areas as per point 1 above, which sets out what those standards are. So that's the point. The Highways Authority doesn't object in respect of highway safety considerations either, yeah?
Yeah, but I have brought the highways, Essex Highways people down to actually look at this.
Right, okay, well, we're dealing with the evidence that's been
Yeah,
produced.
I do appreciate that,
Okay,
yes.
bite-sized points. Next point, however, as outlined in our initial corporate response, it would be a significant downgrade from what's already in place and therefore undesirable from an education and public health perspective. And that's the point that you rely on in terms of it still being a benefit, a disbenefit that you say weighs in the planning balance. But I just want to read on to the next paragraph with you, because it then looked at how or potential ways that could be dealt with in this letter. And it says this: we welcome sight of the developer's landscaping proposals within the school boundary, highlighted in your email of the 4th of February 2021, which includes measures such as improving internal paths, benches and additional planting. This developer-funded mitigation may be appropriate, but would require support from the school and ECC property service. We would therefore recommend further discussions to explore the acceptability of the specific mitigation. I'm sorry, I'd prefer not to have the interruptions.
Yeah, we don't need this. I've said it yesterday. Please.
We would therefore recommend further discussions to explore the acceptability of specific mitigation measures. But then it says this: indeed, a preferred approach may be agreeing a financial contribution to provide the school with some flexibility in terms of specific mitigation measures. So what it's saying there is, thank you for the proposals. They may be appropriate. They're probably going to need further discussion. So actually, the better way to deal with it in the planning sense might be to agree a financial contribution to provide the school with the flexibility in terms of what it wants to do. You see that?
I can see that, but as colleagues just said, and I do know this, that school they've got over 500 children coming through there, and they come from north and south, and to put a small pavement through the school will not help the safety issues of the children going in. And I don't know how if this development goes ahead, that they can offer a sum of money to the school to improve it, because we don't know, we haven't got that in outline anywhere, how much an improvement would cost.
Right, well, let's just take it in bite-sized points. First point, can you turn up, please, Mr Blair's volume 4 of his rebuttal evidence?
Where's Mr. Blair? What's my bit there?
I've got volume 5, but not volume 4 to hand, so just bear with me. Oh, there we go. Yep.
So I don't think we have, apart from my marked up copy, a clean copy of that on this side of the room. I was wondering if someone on the appellant's team could help.
Of course.
It looks as though, yes, looks as though
And just, you're also going to need as well, whilst you're getting it, well, actually, I might have to read this. We asked for copies of this, but I know there are copying issues at the venue, so the still compliance schedule. But what I'll do is I'll read it to you if you don't have a copy, and then it can be checked later if that's acceptable. Yeah, because we've asked for copies, but there's been issues at the venue. You've got, oh, brilliant, okay. Right, so I'm going to go to this. I'll just wait for the, yeah, just wait a minute, hang on a moment, because I think the copy of the other document's coming, so let's just get everything stacked up and then we'll go to the
Can I have a 5-minute comfort break while they're looking? Is that all right, sir?
Well, let's. I was just going to check how progress was going. How are you? Through?
Probably got about, what's my time at the moment? 12:30, so I've had about, am I on track? What time do we start?
We will have a short break
a
now.
short break.
but,
So I've
yeah.
probably got about half an hour or so left, I would think.
If we break, it's 12. I make it 12:32. If we have a short break to 12:40, then if you've got half an hour, that'll go just after 1 o'clock, which
Yeah.
could still be acceptable. So let's try and aim for that.
Okay,
Let's have an adjournment now. Then we'll resume at 12:40.
Thank you very much.
thank you.
Thank you very much. I say, it's because we're not walking around. Oh, is it? I think so, yeah. Have you not? Thank you very much.
The inquiry is resumed, ladies and gentlemen. Apologies, that was fairly a short and rushed break, but I'm trying to keep things moving as best we can. So, Ms Reid.
Thank you. So you recall, Councillor, that just before the break we were looking at ECC's response, which had said that in terms of that issue that they had raised about there being a downgrade and points about education and public health, their comment that followed, which was talking about a financial contribution to provide the school with flexibility to mitigate that. And what Mr Blair has included in his volume 4 is I think this is the plan. This is the plan, and we can see this from his proof of evidence at 3.2.5, that this was the plan that was before ECC and the council.
Can I stop you? Sorry, where are we looking?
Oh, I'm so sorry, Mr Blair's rebuttal. Volume 4.
Oh. Yeah.
Right.
So what page?
Right. So if you look at first, let's look at 2.3.5. Yeah. Para 2.3.5 on page 3. Have you got the right? It's volume 4.
I've just got it from your...
It's volume 4.
Yeah. I haven't got any maps like you're showing.
No, I'm 3.2.5.
Although perhaps unrelated. Does that say?
Yeah, that
right,
one.
Right, well,
okay, it's talking about the Section 106 agreement contains an agreed contribution towards a landscaping scheme to deliver amenity enhancements in the school frontage area. A drawing of these works is attached to Volume 4 Rebuttal Proof Appendix A. This is an agreed item as described in 2.35 of the committee report. Yeah? Okay, so this was a matter that was before the council which was, and then if you turn up Appendix A, which is right at the back, these are the landscaping proposals that ECC is referring to in that letter we looked at a moment ago, where it says we welcome sight of, yeah? And we can see it's not just a path that's being proposed, you can see that it's a landscape proposal which includes new areas of, for example, planting and also circular and wave. These are examples of what could be achieved. Seating to create focal points and gathering opportunities for pupils and parents for school drop-off time. Yeah, you see that? So these are the proposals that were being considered that ECC said they welcomed sight of. Yeah?
Yep.
And then in terms of what the local authority, planning authority, has said about those, it's in the SIL compliance schedule and it's under the heading School Landscaping Scheme.
Whereabouts is that in the schedule? Is it near the end, or because it's not paginated,
is it?
No.
Which is the issue with it. Bear with me a second. Let's have a look. 1, 2, 3. I think it's on page. When I say page 4, they're double-sided, but it's the actual physical page 4.
I see it's starting education.
Yeah, and then after the next one after that.
School landscaping. Yeah, got it.
that's
Thank you.
And the local planning authority's comments are in the second column. Sorry, do you have that, councillor?
Page 4, you said.
It's probably your page 8 because yours isn't double-sided. Looking at that.
Well, count again.
I know.
Widen the footpath, or have I gone too far now?
No, it's after the education, it's school landscaping scheme.
Oh, yep, right at the bottom.
Lovely.
Sorry.
Unfortunately, it's not paginated, which is not
No.
assisting, is it? Right, so this is still compliance schedules. This is the council's position in respect of why these contributions are necessary, directly related to the development and fair and reasonable. And it says necessary. The widening of Ashington Road to create a ghost right turn for the development would result in the footway being narrowed. So that's your point. And then it says, this landscaping scheme would ensure the footway is a suitable size. So the reason it's saying that is because although the footway will be narrowed, there's a sum of money, which we can see is either, the obligation is in the first paragraph there, either a scheme to landscape the frontage will be submitted to the County Council at the same time as application for reserved matters, or a £50,000 contribution to the council to be used to carry out works. Yep, you see that?
Yep.
And the reason that that's necessary, this is the council's words, is because the footway will be narrowed and this landscaping scheme would ensure the footway is a suitable size. So what it's saying is although the footway will be narrowed, because the obligation provides money to secure an improved environment within the school frontage, that's going to compensate and provide a safe and convenient drop-off and pick-up area for parents and children within the school. And the council's words are, this landscaping scheme would ensure that the footway is a suitable size. So that is the council's position, isn't it, now?
Yes, I know it is, but I don't agree because this looks very, very pretty and it's very nice for Holt Farm children, infants and junior schools. But you will still have, as I said, I think there's 500 and something children go to those two schools. And coming from Rectory Road, that's Junction 1, going towards Junction 3, Daly's Road, we have got St Teresa's on the same side. So we still have accumulation of children and parents on that footway where they've got to go past the school to go to the other school. If they go to the Rochford Primary, it'll be the other side. That's not an issue.
Just bite-sized chunks again. There are 2 points that were raised in respect of this. The first was highway safety and the narrowing point, which has been resolved, and which just bite-sized chunks.
Yeah.
So that's the highway safety point, and that's people going up and down the road, and that it's going to be safe for those people.
Perceived to be safe.
And the council has withdrawn its objection in respect of the safety issue. The second point that you raised was in respect of this public sort of general amenity point for those people who are effectively waiting on the pavement before and after school drop-off. Yeah? And that's the point that's being dealt with by ECC there in that letter. And that point is resolved through the provision of this obligation, isn't it?
Yes, it is.
Right. So what that means is taken in the round, and now that you've had an opportunity to have a look at this and to consider the obligation properly in the SIL compliance statement, those matters do not, the narrowing of the footway, taking into account that mitigation, the contribution, is not a disbenefit to weigh in the equation because those matters have been dealt with.
That's what I said yesterday. That, yes, we know it's being reduced, and yes, it is compliant, but no, I still don't agree with it, which is a completely different matter.
Right, but sorry, just bite-sized chunks. No way highway safety concern sufficient to refuse the application or otherwise is being raised by the council now. The secondary point was in respect of this public health issue that was raised, and you relied on ECC's letters in that respect, yeah? I'm sorry, I'm just struggling to hear. The second was the point about ECC and the amenity point, yeah? That point has also now been resolved, even as a disbenefit by virtue of this obligation within the Section 106 obligation. So what that means is that there is no negative taking everything into account to weigh in the planning balance in respect of this issue, is there?
No, I still don't agree with it. Sorry.
Right, so no negative, but don't agree with it.
Sorry, was that a no, but you don't agree with it?
Exactly, sir.
Okay, yeah, okay.
Because what the council doesn't do either, and just to be absolutely clear on this point, is you haven't produced any evidence taking into account these 2 points to demonstrate that active travel would be hindered as a result of these measures either. So also not a negative to weigh in the balance, taking everything into account.
Yeah.
Agreed?
Agreed.
Thank you. And so where that, and then final point is in respect of parking. And again, although the council initially raised an issue in respect of parking, that's now been withdrawn. Yeah? Agreed?
Agreed.
And just want to be clear about this. In terms of what is proposed, it's, just bear with me a second. The 2 points is that as follows. The first is that there is going to be dedicated parking that's going to be secured as a result of the planning obligation, isn't there, within the
On the
appeal
site,
site? Yeah?
yes.
And what that is going to result in is firstly that there will be dedicated spaces for school drop-offs and pickups, yeah?
There's going to be 10, isn't there?
Yeah, dedicated.
Dedicated.
Right. So there are 2 points in respect of that. The first is that there is going to be a net increase in the number of spaces available as compared to those that are lost. Yes?
No.
Well, there are, councillor, aren't there? Because
There isn't. Can I say, they're using a slip road at the moment, which is Essex Highways land, and they can put up to 20 people parking there. But the safety partnership, Essex Partnership, are going to be putting yellow lines on, so you completely lost those.
right. So just to be clear, the scheme, the appeal scheme, is going to lead to the loss of 4 of those spaces in that lay-by.
It's going to lose them all, as I've just said, because there's going to be double yellow lines all the way through there. The plan is going ahead now with this safety,
That's the
South
TRO.
Essex parking.
TRO.
Yes,
Yeah.
the SEP
Okay. right.
have got lost it. They have been given permission and the funds, or they will be putting in, Essex will be putting in double yellow lines, which will stop the parents or relatives picking up the children. So we have actually lost those, but yes, we have gained the ones on the site.
Yeah.
But who is going to police those? Because if you've got 20 parents, there's going to be rage wars going on. Who's going to pick the kids up? Because they get there. I don't know if it was Mr. Blair that actually went and did the assessment, but the school comes out of 3. They can be there from 1:30, guaranteeing getting a parking space, which is absolutely ridiculous.
Let's just
And I'll do
Let's just do the bite size.
I appreciate.
I understand your concerns. Let's do the bite-sized points. The first point is the traffic regulation order that you've just discussed. So that's now at a stage where it's going to be implemented.
Yes.
Right. That's nothing to do with this development, is it? That's going to happen anyway.
Yeah, regardless if we had the
Right.
development there or not, that will happen.
So in the world that the development doesn't exist, all of those car parking spaces go
Yes.
and nothing additional is provided for school drop-off and pick-up. Yeah? In the world where the development goes ahead, there are going to be 10 dedicated spaces that are provided in respect of school drop-off and pick-up provision. Yeah? Now, those 10 spaces, that is going to be an improvement over and above what is going to exist without the development, because you go from none in the world
10.
without the development to 10. So that is a benefit, isn't it, of the scheme?
Will be a benefit.
Thank you. And given the Given the issues that you've just identified, I assume you accept that significant weight should be given to it as a benefit.
There should be benefits, but I think if you're going to do a development for a size of 662 houses, that parents they'll be parking on the road with their own developments, and there will be potential people parking on the road from the schools
Right,
to
but
pick up. So yeah, we have got right. Sorry,
we
didn't declare that, didn't do it.
we can't.
No, I know you can't do that. I'm sorry.
No.
If you've got the community centre
Yeah,
or whatever it's going to be,
yeah.
those 10 allocated spaces will be within that centre, as I thought I read on the plans. Now, if you've got a health centre, our health centres open at 7 o'clock in the morning in this district. So the parking spaces may be allocated to the health centre, and then you're going to say to patients, sorry, you can't use them.
I'm just going to
Or have I missed the
Well,
point,
no,
sir?
I'm going to interject because
Yeah.
I'm waiting for the answer to the question which was put to you about significant weight should be given to this benefit.
Yes, it should be given.
And
significant
I was waiting to write what you thought about that, and then suddenly we went somewhere
Off on
else.
the tangent.
So that's why I've interjected.
Correct.
So, okay.
So thank you. Significant weight to that as a benefit. But then, in terms of your point about how are you going to secure that, the SIL compliance schedule gives a bit of information about that. So I'm just going to read it to you because the problem's finding it. Developer proposes to provide a number of parking spaces to the far west of the site for use by the public when drop-off and pick-up of children from Holt Farm Infant and Junior School. The specification of these visitor spaces will be controlled by condition. The Section 106 secures the delivery and management of those spaces prior to first occupation. The developer is proposing that these spaces only be used in connection with the primary school during certain times of the day, and aside from these times, the spaces could be used by those visiting development. And then in terms of the LPA's comments, necessary, the LPA did not originally request these spaces be provided. I think that's officers didn't originally request it. However, it has since been established these will benefit the local community, so that's why it's said to be necessary there. And then fair and reasonable. It is fair and reasonable for a development of this size to provide visitor parking, and due to the development's location, allowing these pickups and drop-offs for the children is welcomed as it will ease congestion on Ashington Road. So then it says, it sets out in the appellant's box, points about SIL compliance, and then this planning obligation is particularly welcomed by members. And when you look at the Section 106 obligation, there's an obligation there to secure that that happens and the management of that and how that's going to be secured. So taking all of that into account, it has been secured through the 106 obligation, and significant weight should be given to it as a benefit, shouldn't it, Councillor?
Yes, it should.
Thank you. And in terms of those highway safety points then that we've just looked at, we've got the position where, and we're looking at where the balance is in terms of highway safety, no issues now taken by the council in respect of high pedestrian safety in the vicinity of the site access. And we've been through what the proposals are in terms of improving highway safety. And also we've got the landscaping scheme in terms of public amenity. So on balance in terms of highway safety in the vicinity of the school site, there's going to be a net benefit, isn't there? On balance.
On balance, on the paper.
Well, you appreciate that we have to deal with the evidence that we've got here now. So on balance, on the evidence, there's going to be a net benefit in terms of highway safety, isn't there?
I actually agreed that. I said yes.
Yeah, thank you. And in terms of highway safety, that's obviously a key priority of the council. And so that net benefit in terms of highway safety should be accorded significant weight, shouldn't it?
Yes.
Thank you. And then in terms of, I'm not going to go through every single point in Mr. Gascoigne's proof with you in terms of benefits. I'll pick them up with Mr. Pycroft because I'm aware of time constraints and I've got some other points I want to take with you in terms of the balance. But I do just want to have a think about the community centre because in terms of the SIL compliance schedule and the community centre, happily, this one is the first one on the, is the first one. So hopefully we can all have a look at that. And what we can see there is in part 1, it says healthcare land, and it says the landowner is offering an area marked as community land on the healthcare plan to the NHS for the sum of £1. The offer period will run from 2 years from the commencement of development. And then it says necessary, and again this is the council. The development site will mean that there will be more people requiring local healthcare services. If used by the NHS, the healthcare land will facilitate a new general practitioner medical surgery and surgeries and associated facilities for the residents of the development and other residents who live in the vicinity of the appeal site. This will generate GP surgery capacity and mitigate against the impact of the development. So a facility that's going to be offered to the NHS for £1 can assist in meeting some of the issues we've heard about from residents. Yeah? And if, given that's the position, and again, the council has said this will generate surgery capacity, mitigate against the impacts of development, and will also provide facilities for the residents of the development and other residents, that is a benefit of the scheme, isn't it?
It is a very generous offer from the developer, and it's lovely to have a brand new healthcare facility, but we don't want it to be a white elephant when we can't have the healthcare workers in there, when we can't, the doctors are not coming through the system as we sit today.
Okay, well,
But it will be a generous offer.
yeah, well, just want to be clear because, you know, it's something that's in the obligation and that the council is saying is necessary, directly related and fair and reasonable. So the council's position is that it's a justified contribution on that basis, isn't it?
That's what I've just said. It's
Yeah.
a generous offer,
But
but the Section 106 money for the NHS will go to the NHS. The council actually hold it, give it to the NHS, and then it's down to the NHS on how they spend it.
Well, hang on, we're talking about the land at the moment.
Yeah,
so-
but I'll say you're saying it's an NHS healthcare, which
Right, just-
it won't be. It will be under the NHS, won't it? It won't be under the councils.
No, the landowner's offering
Community.
an area of land to the NHS for £1.
Yep.
Then if you turn over, there's also a contribution of £262,300, which again, the council has agreed is necessary, directly related and fair and reasonable. So the council's accepted those contributions and is putting them in front of the inspector on the basis that they meet the tests for asking for those
I quite agree, but I
obligations.
say they will go to the NHS after this has gone through,
Yeah.
and then it'll be down to the NHS where they spend the money.
Okay. Right, so the opportunity to provide that land and to provide that facility for the benefit of the community, firstly, is a benefit, isn't it?
As I said, it's a very generous offer.
Yeah, it's a benefit, isn't it?
I've said.
Clearly. And
Sorry,
It is a benefit.
right, I
Right,
just want to be
thank
clear,
you.
thank you.
And it is a benefit that should be accorded significant weight, isn't it?
If it is used, yes.
So is that, well, there's no evidence it won't
No,
be.
it can't, but it's got to be yes.
Right, so it's yes, thank you, significant weight. So now we turn to the planning balance, Oh, sorry, just final point in terms of benefit. The other one, and there was a bit of, I think, confusion in your examination in chief on this, but we're now at the point, aren't we, where it's agreed that bringing forward the appeal development will be in accordance with the development plan. We've dealt with that. Your point is about material considerations, which we'll come on to in a minute. So, in examination, in what Mr Gascoigne and Mr Pycroft say as well, there is a benefit, looking at your housing needs, etc., of bringing forward development in accordance with the plan-led system and the allocation, and that should be accorded significant weight. Given that you now agree that there is compliance with the development plan, I assume you agree with that position as well. Your issue is one of balance.
Yes.
Thank you. Okay, so then in terms of what that balance is, if we return to your proof of evidence, So we know, and you're going to need the MPPF as well, actually, just for this section. So if you turn up paragraph 11 of the framework, please. And just put your finger in that or a tab on it, and the other one you're going to need is paragraph 111.
I had that open a minute ago. That's what I thought you were going to refer to.
There you go. You're at the point now where you're preempting my questions. So there we go. So 2 points then. In terms of the point that you raise, having regard to paragraph 111 of the framework, first, there. Right. So. Development should only be prevented or refused on highway grounds if there would be an unacceptable impact on highway safety or the residual cumulative impacts on the road network would be severe. So what that's telling us is if there is an impact that is below that given level, so below an unacceptable impact on highway safety or below a severe impact, i.e. an impact that's not severe, then in those circumstances, that should not stop planning permission being granted. Yeah?
Yep.
And just to be clear in terms of your point on highway safety, and this is a balance point really, yesterday we heard Councillor Eves' concerns about his perception of the mitigation measures at Rectory Road. You recall that?
Yes.
But you, Councillor Shaw, as chair of the planning committee and also an affiliate member of the RTPI, you understand that significant weight needs to be given to the view of the statutory consultee, the Highways Authority, and you can only depart from that if there are clear and compelling reasons to do that. You understand that, don't you? So we understand that, and the reason I'm asking you this is because it's you giving the planning balance evidence, and you're obviously an affiliate member of the RTPI. Whilst we understand Councillor Eves' concerns and his perceptions that he's set out in his evidence, I presume you accept that there is no evidence that the scheme should take into account the other points we've dealt with in terms of highway safety. There is no evidence to suggest that the scheme should be prevented or refused on highway safety grounds.
No, only refused on the severe congestion. That's my point.
Yeah,
and I'll go with Councillor Eves, but on balance, what we've said, no.
Right, so on balance, taking everything into account, including his expressed concerns at Rectory Road, and taking into account those points about Highways Authority, clear and compelling evidence, the local planning authority's remaining point relates to congestion, doesn't it?
It does.
Good. Okay, thank you. And so, in respect of that point, what it says then is should only be prevented or refused on highway safety ground if the residual cumulative impact on the road network would be severe. Now, bite-sized chunks, what that means is if the inspector finds that there would be an impact but that it's not severe, then that shouldn't be sufficient to refuse the application, should it? No. If the inspector finds that the residual cumulative impacts on the road network are severe, and just pausing there, the test isn't whether there is a severe impact. The decision maker, as you understand, I'm sure, needs to look at the cumulative impacts on the road network as a whole. Yeah, you understand that? If there is a finding that the residual, well, if there is a finding that there is a severe impact, there then needs to be consideration as to whether the residual cumulative impacts on the road network as a whole are severe, yeah? And it's only, and if they're not, then planning permission should not be refused, yeah? Right. if the position is that the residual cumulative impacts on the road network would be severe, yeah, paragraph 111 does not say permission must be refused. What then one has to do is carry out the planning balance that's set out in paragraph 11 of the framework. Yeah?
Yeah.
Good. And so what paragraph 11, and this is why you needed your finger in it, and you're probably going to get to it quicker than me because I'm on the laptop, what that tells us to do, in the tilted balance world that we find ourselves in, yeah, which is to grant planning permission.
Excuse me, sir. May I interject for a moment? I think Councillor Shaw is struggling a bit physically and she may require another short break, I would think.
Well, Councillor Shaw hasn't said anything.
My eyes are beginning to
notified me.
swim. We're reading all this because I will need food soon, being a diabetic. But,
Yeah,
but I don't want, if it's only going to be about 5-10 minutes more questioning, I'm prepared. Well, it's acceptable to go on for there, but if we're going to go on for another half an hour or so, I would prefer to go and have something to eat.
I hope we're not going to go on for this. I'll check with Ms Reid. If we are, then I will certainly break. But I mean, thank you, Mr Foster. But I mean, Councillor Shaw could quite easily have told me, can we have another comfort break? So
now, I would like, if we have a break, I'd like to have a food break. On
yeah,
this.
yes, of course.
Speaking sort of on behalf of Councillor Shaw, I'm just a bit concerned if she's saying her eyes are beginning to swim and stuff, whether it might not be, because obviously we're coming up to the overall planning balance. I don't want to...
Okay, well, Ms Reid, are you content if you might have to go back and repeat some of these if we break?
Can I just finish this little tiny section, which will be literally a minute or so, and then we can break and I'll finish it off after the break, sir?
Are you content with that?
That's fine, thank you.
So that we get to...
Of course.
Yeah.
Which is why I said you might have to wind back, because you might have to end up
fine.
repeating some
Yeah.
things if you feel that in any way you've been disrupted here. But
Thank you, sir.
I try to please everyone,
I'll
really.
just finish this question and then...
Let's do the one question or the 1 point, and
the
then
one
we'll
point
have
and
a break.
then
Yeah.
So if we're in the realms of residual cumulative impact is severe, that then has to be fed into the planning balance in accordance with paragraph 11 of the framework. And that's where the tilted balance comes in. And it tells us that we grant planning permission unless, and the first one is that the applications of policies in the framework that protect areas or assets of particular importance provides a clear reason for refusing the development proposed. And there's a number of points set out in the footnote 7, and none of them apply here. But what footnote 7 doesn't say is, for example, where the residual cumulative impacts on the highway network are severe. So the tilted balance applies in this case, Councillor, doesn't it?
Yes, it does.
Right. And so what we then have to do is consider those impacts, whatever they are, in the context of the tilted balance, and consider whether the adverse impacts of granting permission would significantly and demonstrably outweigh the benefits when assessed against the policies in the framework as a whole. And that's the test that we need to apply, isn't it?
It is, yes.
Right. And that, I'll wait there and then I'll have a couple more points when we come back, sir.
Yeah. Okay. Well,
So I'll keep these open.
Keep that one open.
Right, okay,
that's fine. You've taken Councillor Shaw to the point that you want to explore, perhaps with a couple more questions.
Yes, thank you, sir.
But yes, let's break there.
So could I just raise one thing before you say something, sir? And I'm not, I appreciate members of the public aren't aware of protocol. When I was in the ladies before, and I'm not Councillor Shaw dealt with it admirably because she just didn't say anything really in response, so it's in no way complaining about anything particularly, and I do appreciate members of the public don't know the protocols, but somebody approached Councillor Shaw and spoke to her in the ladies. Now, it's just perhaps maybe a reminder of what the protocols are so that doesn't happen again. And I've got no problems with what's happened, but it's just a reminder for people, if I may.
Obviously,
Excuse me, sir, can I rebut that, please? The residents are just concerned over our councillor who suffers from health conditions, so we were just being... It wasn't me, but we were just being careful.
Yes, I understand both points of view. I mean, the point is, in terms of protocol, as I've said a couple of times, when a witness is under cross-examination, it's nice to get it all completed in one section so they don't have to have a break and have lunch on their own and be in isolation. But when that does happen, it's important that that witness doesn't have contact with other people, particularly their team, but any individuals, because what happens when the witness is on the witness stand is I'm hearing their evidence. I'm not hearing things whispered into their ears by other people. So I don't need to labour the point. I think everyone's heard what I've said now, but please, if a member of the public feels that you want to say something to one of the councillors, then that's fine, as long as they're not in the middle of cross-examination, okay? So let's...
My husband thanks you because I don't have to talk to him for this length of time.
So there is some benefit.
Yeah, well, for my husband there is, yes.
Well, we're getting close to 20 past. Well, just past quarter past. I don't want to cut it down too much, but equally I don't want to have too long a break. Can we go to 10 past 2? Then that's about 50 minutes for everyone. Well, if 2 o'clock's fine.
I've got a sandwich, so
Yeah.
if everything's all right, I could do. We don't. I personally don't need 3 quarters of an
okay,
hour. I don't know if anyone else does.
We've got 2 rival bids so far, 10 past and 2. Mr. Parkinson.
Well, I can 10 past at the same time.
I really don't mind. I mean,
I'll go with
we got
whatever.
sandwiches?
Go on, let's go for 10 past. I don't want to cut it down too much. So I'll adjourn now. We'll resume at 10 past 2. Thank you.
Thank you, sir.
Thank you.
Right. The council's barrister wants to get out by 6:30.
Well, the inquiry is resumed, ladies and gentlemen. Ms Reid, just before I ask you to do your final points, as I left the inquiry room, Ms Crosby, who was one of the interested persons down to speak on the first day, asked me a question. She said she didn't want to speak on the first day, and she still doesn't want to speak, but she'd like to submit her statement as a written representation, which I said was fine, but I would like to have it before the appellant gives evidence, so that if it raises any points that you need to cover with your witnesses, then you've got it in good time. So,
Thank you, sir.
Ms Crosby, if you're still around, if you can get that statement to us as soon as possible, that would be great. Thank you. So, Ms Reid.
Good afternoon, Councillor. We're in the afternoon now, but we're nearly there.
Good afternoon.
But we're nearly there.
At least it's not good evening.
No, we're nearly there. So, where we were just before lunch is we were looking at, I'm just going to take a tiny step back just to remind ourselves where we were. We were in the tilted balance, and we were looking at paragraph 11 of the framework, and we had agreed that even if we were in the realms of residual cumulative impacts being, as the council suggests, and severe, that needs to be fed into the tilted balance. What that means is that the harm identified significantly and demonstrably outweighs the benefits of the scheme when taken as a whole. Yep. Now, just want to recap on where we are following Councillor Eves' evidence in respect of the harm that the council says should be weighed in the planning balance. So we have mitigation that works at all junctions apart from junction 4, which is, and the council's concerns primarily relate to the Ashington Road arm of that junction, although Councillor Eves had some points about the overall delays in respect of it, but primarily relating to one arm in respect of that junction, one junction, and the concerns that he expressed in evidence related to the AM peak only, so the AM peak hour only, and one time segment within the AM peak, so a 15-minute period. So those impacts that he was identifying, that he relied upon to demonstrate what he said was a severe impact, related to one junction for a 15-minute period. Okay? That's where we got to. Now, in respect of junction 4, we also agreed that the reason that those impacts, and that's before, those impacts are before any measures in terms of sustainable transport, trip diversion, etc. taken into account, which he accepted will have some impact on bringing the level of impact down, albeit that hasn't been quantified. Yes. So that's where we are. One junction, 15-minute period. That's the worst case. It'll come down a bit further. You didn't know how much. Now, what we also know, though, is that the reason that junction improvements, physical junction improvements, can't happen at that junction is because of the geometry, effectively, there, isn't it? It's the railway bridge and the river. So it is not possible to mitigate that junction by junction improvements in the highway at that location. Yes? Right. Okay. Now, what we've also agreed, in terms of your evidence, is that the appeal site is that the appeal site needs to come forward to meet the critical housing needs of the district. Yeah? We've also agreed that the appeal site needs to come forward in order to address affordable housing needs, which you accept very significant weight should be given to. We've agreed that the proposal is in accordance with the development plan and that significant weight should be given to the policies of the plan. Full weight, actually, is what you said.
Yes.
And we've also agreed that without the site coming forward, the housing needs that have been identified both in this plan and also in your emerging plan cannot be met.
Agreed.
Now, I appreciate that when matters came before the planning committee felt that the evidential basis was different because at that point, the local authority had concerns about highway safety, which have now been resolved, and you've had independent consultants come in and look at that issue for you. Yes?
Mr. Flexman.
It was also the case that the planning committee had concerns about parking. Those have now been resolved, and we've got an obligation that's delivering what you accept to be a significant benefit. Yes? There were also concerns about numerous other junctions in the vicinity. And again, you've had an independent consultant come in to look at matters on behalf of the local planning authority and members and to give you comfort that mitigation can be provided at those junctions to mitigate those impacts.
Yes, Mr. Flexman did that.
Yeah, Mr. Flexman did that, that's right. So what is left in terms of the impacts that the planning committee, well, what is left in terms of the impacts is a single impact on a junction where for a 15-minute period of the day, in circumstances where it is not possible to carry out improvements to mitigate those impacts.
I'm
Yes?
so sorry to interrupt, but this is quite important. There's 2 points to pick up. First of all, I don't recall, I need to go back through my notes to double check. I don't recall Councillor Eve saying the concern is only a 15-minute period. He didn't say that.
So he did, I asked him
And
about...
certainly he didn't say that the 45 minutes preceding that was acceptable. The table shows a 15-minute period, and it shows the worst 15-minute period. And he was asked questions about that.
He was certainly taken to and asked questions about the 8 to 8:15 or whatever
He was,
period
but
it
that's
was.
very
yeah,
different from him saying, I'm okay with the position 7:15
I
to
asked
8
him the
o'clock.
question, sir. I have the note of it and I've checked it. I said, you are only raising concern in your evidence, aren't you, with that 15-minute time segment? And he said yes.
Well, I'd have to go back to my notes to find out exactly what was said there. I've noted your point there, Mr. Parkinson. That's all I can say at the minute on that.
The second point is, of course, Councillor Eaves also raised, he said it was his most important point, the point about queues from junction 4 blocking back into junction 3. Mm-hmm. So I think that just has to be recalled as well.
Yep,
Right.
okay. I certainly recall
Yes, he did.
Councillor Eaves referring to that.
But I haven't finished my question. So if I could continue with my cross-examination, I'd be most appreciated. So sorry, Councillor Shaw. Right. So I'm going to have to take a step back. So at the time that the committee looked at this matter, there were concerns about highway safety. You've had Mr. Flexman come in and he's looked at those and they have been resolved, but you now accept significant benefit in respect of highway safety. We had concerns, the committee had concerns about parking. There's now an obligation which is resolved, which has resolved those issues, significant benefit parking. Committee had concerns about junctions other than junction 4. Mr. Flexman's come in, we've looked at that. There's a mitigation scheme, an alternative one proposed, and those issues have now been resolved in respect of all junctions apart from junction 4. And what is left in respect of junction 4 is an impact that can't be mitigated with works to the highway. You understand that? So if we are in a position, though, where you accept that the site needs to come forward to meet the critical market and affordable housing needs of the district, it needs to come forward, that it needs to come forward in accordance with the policies of the plan to which you accord full weight, that harm in the AM peak to that junction, in respect of that junction, it cannot significantly and demonstrably outweigh the benefits of the scheme when considered against the provisions of the framework taken as a whole. Can it? And before you answer that, I appreciate different position from the one that you think the committee considered. Different position now. I'm asking you as an affiliate member of the RTPI to take into account all of the evidence that you've heard now, all of those changes that we've taken into account, the inevitable impacts at that junction that have to happen if this site is going to come forward, which you accept it must to meet your housing needs going forward. Though that impact cannot significantly and demonstrably outweigh all of those benefits that we've discussed, can it?
Can I make one point? Earlier on, this morning, I mentioned Percy Cottage Road, and you said you would address that. That hasn't been addressed as yet. I appreciate that. That has also got to be a consideration that if you, the site is going to have an entrance and an exit there, that road cannot cope. There's no way traffic can actually come through there. As I said earlier, a bicycle can't even get through there if the residents parked. But Councillor Eaves did, under full examination, expand on what his concerns were. I did my concerns between 8 and 9. I'm fortunate enough I don't have to go out through the way of Hall Road in the evening. But other residents, I have had evidence from other residents, they do. I can't bring that to the table, sir. But if Junction 4 can't be improved, and it does back up to Junction 3, and eventually it could go up further, you know, if you're going through, there is still a significant concern regarding for highways.
I'm hearing what you're saying, and I've noted certain points of it, but it isn't actually addressing the question that was put to you. So I understand you have remaining concerns. That's quite clear, and you're explaining some of them. But I do need you to just focus on the question that's put to you and give a response to that, please.
Let me just, I'll go back. Councillor, I understand that when the matter came before the committee had a number of concerns. Those have been addressed. In respect to Percy Cottage Road, there's no evidence in your proof of evidence, Councillor Eaves' evidence, the evidence in chief that has provided, I appreciate you've got a concern, but has detailed the issues in respect of that, but I appreciate the concern that you've expressed in terms of it, and I'll deal with that with Mr Blair. When the matter came before committee, highway safety concerns, those have been resolved. You've had someone independent look at it, and now you accept significant highway safety benefits. Concerns about parking, obligation, now resolved, you accept significant benefit, different again from the matters that the committee were thinking were existing at that particular point. Had concerns about various junctions, not just Junction 4, had a professional consultant in to robustly look at this for the local planning authority to give members the reassurance that they needed in terms of those points. And those issues, other than Junction 4, have now been resolved to the satisfaction of the local planning authority. What we are left with is an impact at Junction 4, that cannot be mitigated within the confines of the highway, that was known about prior to the allocation of the site through the core strategy, and that you have accepted in respect of the site, that the site needs to come forward to meet what you accept are critical housing needs for your district and the people in it, not least the 232 affordable houses that will be secured through very robust obligations in the Section 106 obligation. Now, if the site is going to come forward, those impacts at Junction 4 are going to occur. Therefore, it cannot be the case that those impacts that you have identified now, taking into account everything you know now and the evidence as it exists now before this inquiry, significantly and demonstrably outweigh the benefits of the scheme taken as a whole. Right, thank you, that's correct. So on that basis, what paragraph 11 of the framework tells us is that this is a proposal that is in accordance with the development plan, and applying the tilted balance, planning permission should be granted. That's right, isn't it? So on that basis, the evidence of the local planning authority, as we sit here today, having rigorously assessed all of the information before it, the evidence is that planning permission should be granted, isn't it? On that basis.
I still have reservations.
I know.
And I'm going to say, with what you've said is yes, but
Thank you.
when we did the application, we did not have any of this information. So we had to go with the information we were given at the time. And I believe we made the right decision as a committee.
Councillor Shaw, I have been very careful and fair to put those points, and I understand that you had concerns and that those have now been resolved. But those concerns that you accept have now been resolved mean that, in accordance with the development plan and the framework, the evidence before the inquiry now is that planning permission should be granted, isn't it?
No.
No, well, you've just agreed with me, haven't you, Councillor?
I didn't say a word.
No, I
Then
know.
everyone else did.
No.
But
I know.
I'm sorry,
No.
I didn't actually say a word on that. So, yes,
Thank
but I
you.
still have
Yes.
reservations.
Thank you very much. I'm very grateful, sir. I have no further questions.
Okay, thank you. Thank you, Councillor Shaw. Just stay there a moment, please. Right, thank you. Well, bear with me. I had got a number of points that I'd flagged on your proof of evidence, but you've obviously been taken comprehensively through this. I don't think that there remains many of the points that I'd flagged that I do need to ask you about. Just bear with me while I go through them. I think that the main thrust of the remaining points that I may have had went to the planning balance, because I wasn't sure, going through your proof, that I'd seen a full assessment of that, and I wasn't sure whether a similar full assessment had taken place at the committee that considered this proposal. But in light of the cross-examination, I don't think I need to ask you questions. It would simply be repeating matters that have already been put to you and which you've clearly answered. So I don't have any questions for you, Councillor Shaw. Mr. Parkinson, do you have any points in re-examination?
So no, I don't have any questions that fall within the category of clarification, so I'm not going to attempt to do anything else.
Okay, that's good, thank you. In that case, thank you very much, Councillor Shaw. You may retake your seat, and I believe that concludes the evidence for the Local Planning Authority.
Thank you for giving me the time to speak.
Okay, thank you.
So can we just have 5 minutes just to rearrange papers while the Rule 6 party set up?
Yeah, I was going to say we'll need perhaps about a 15-minute break,
Yeah.
really.
15, please, yes.
Thank you.
I know Mr. Foster wants to bring
Yes.
table,
Yeah.
display boards, etc. It's 14:28. Let's resume at 14:45. So I'll adjourn now. We'll resume 14:45. Thank you. The inquiry is resumed then, ladies and gentlemen. Excuse me. So, Mr. Foster, I received the statement that you'd submitted back in December, but then at the start of the inquiry you presented me with a slightly revised version. You said
correct.
you'd added a few things and taken a few things out.
Correct.
I haven't had time to go through it in detail to see where the changes are, so I've still got your original one with various flags on, which it may be that if you've left something out, I may not need to ask you about it. But just so you know, that's how I'll be working. So I'm happy for you to go with the new one. It would be helpful if it's a key point that's new, that you highlight the fact that it is new, and then we can all follow that quite clearly.
Okay. The major change between the two was I'd misread one of the diagrams, and I put the lane in the wrong place in my description.
Okay. But primarily you're going to be working from the one that you submitted on the opening day?
Yes, correct.
Is that right? Okay, thank you.
And also, you recall, my original one was back end of November, and then there was a supplementary one that was submitted on the 23rd of December, I think.
I'm not saying it wasn't. I do remember that you put things in later. I can't remember a statement coming in later. I remember some last-minute photos and things came through, but I can't remember a version of the statement.
No, this particular one was headed housing shortfall, and had some evidence attached, an appeal in Kent.
I may not have a copy of that in front of me then, Mr. Foster. I don't know if you've got a spare copy.
Definitely went to Mr. Wordsworth on, I think, the 23rd, certainly before the closing date.
Yeah, I'm certainly not questioning that. It's simply whether or not I printed it out and now have it in front of me. And I say it's not something that I can recall when I went through the bundle.
Would it be
Ms.
helpful
Reid,
if
you?
I asked for it to be sent? I could probably get somebody to email it if necessary.
Yes, I mean, ideally, if it could be printed out sometime while you're still giving your
Excuse me one
statement.
second.
Can I check, Miss Reid, did you receive this?
Yes, we have.
You've got it, yeah. Mr. Parkinson, have you? You've got it. So I'm the odd one out here, I think.
No, it's got my writing all over it.
If someone's got one that could be copied, then that would be very helpful. Thank you.
No, that's my original one. This one's headed up housing shortfall.
Well, when did you send it through? Could you...
23rd of December, I believe. It was certainly before the cut-off date for evidence.
Yeah.
You've got it? Yes. The appellant's got it, so...
Is it possible that your copy can be photocopied? Is it?
Slow print. It's like a little...
It's fine, it's in the car, but...
In a break.
In the break.
Well, it all depends.
Take 5 minutes, we can take a little break and get them printed.
We can email it to Yvonne and she could probably print it here.
Perfect, yeah. Yeah.
And it's the back end of my presentation, so...
Yeah,
I can
it's
carry
towards
on
the
if
end,
you
yeah.
wish.
Let's try it that way and see if that works.
Okay.
Yeah. Okay, then, when you're ready
Right.
then, Mr. Foster.
I presume I don't need to reintroduce myself, having done that earlier in the week.
Happy for you to to crack on, as it were.
Okay, just to make clear, I'm obviously representing the residents. I'm not going to be talking much about theoretical data. I'm going to be talking about pictorial evidence and my own experiences. A couple of points before we start. I just to remind that we agreed I could show a video later on, about halfway through, I believe.
Yep. Yes.
And the other thing, just...
Sorry, just pause there because Miss Reed's just raised her finger.
I'm so sorry to interrupt. And when the video's shown, just before it is, would it be possible if we just, because I'm not going to be able to see it from this angle.
Yeah.
So when it's going to be shown, if it's possible just for our team to just move our chairs over so we can watch
certainly.
if that's okay.
I'll watch it obliquely, I think. I have seen it on my PC beforehand, but yes, give us enough warning for people to move seats.
And it'll probably take a couple of minutes to get going, so that'll be fine. The other thing, just to mention for the record, the pictures on the easels and the maps are all in your evidence packs, and I've provided enlarged versions earlier in the week so you can see them clearly.
Yep.
And just a further couple of minor points. On the map, the junction map, though that was put together before other evidence came, so the numbers on there are different from the numbers that are being quoted. For example, what's described as junction 4, I think, is junction 1 on there.
Okay.
Okay?
Yeah.
And finally, if I may, a couple of points from this morning. The leader of the council advised me that for the last 3 years, Rochford has over-delivered on the housing allocation. And secondly, because there was a big point made...
Sorry, say that again, just make sure. The leader of the council advised you that...
Rochford District Council has over-delivered on its housing plan in the last 3 years.
Over-delivered on housing in the last 3 years, okay.
The other point I'd like to make is that there was... Miss Reed made some significant comments about Holt Farm schools and the S106 application, or not application, agreement in relation to those schools. I've got here, dated the 7th of January, and I thought it was too late to submit it, which it was in technical terms, but it's from the head teachers of the two the infant and junior schools at Holt Farm, both objecting to the development, the proposed development in SER8. I've got copies of that letter here. I think they were not up to date with some of the goings on. They hadn't been consulted apparently by Essex, and were furious when they found out what was proposed. So I've got copies of those letters here if you wish. Would you like me to hand them over now?
Yeah, I suppose so. Let's do that, and then at least it's before the inquiry, so Miss Reed will have the opportunity to put questions if she needs to. You content with that, Miss Reed?
I prefer to see them, sir, if that's possible, before they're handed in, but in principle won't be objecting to third-party correspondence coming in. But can I just check whether there's going to be anything else, though, because...
Is that the sum total of additional documents that you're expecting to...
Yes, sir.
Yeah, okay, thank you.
Right, so I'll begin, if I may.
Okay.
Right, first I'm going to go through some background. You've seen all this, but I must go through it and be able to emphasise some points.
Of course, others, either watching on the live stream or attending today won't know what you're saying. So.
Okay. Right, so first of all, some background. The proposed development is on land allocated in the Local Development Framework Core Strategy, adopted version December 2011, and the Allocations Plan adopted 25th of February 2014, under the policy known as SER8. For SER8, under the heading of New Infrastructure and Services to Accompany Residential Development, it states the requirement for local highway capacity and infrastructure improvements, including contribution to traffic management of Ashford Road. Essex County Council Highways, as a statutory consultee, recommended approval of the application, but will argue that the recommendation is flawed and does not fully consider the evidence, including its own earlier highway assessment made not only prior to SER8, but also the Rochford District Council policy SER2. SER2, known locally as the Hall Road development, relates to some 600 homes, some of which are still under construction and close to SER8. In the allocations plan for SER2, mentioned in the first paragraph, it also includes the requirement for local highway capacity and infrastructure improvements. And the reason I talk about that is in the MPPF, it talks about cumulative impact of nearby developments, and these are in fact SER2, SER8 are cumulative in a relatively short, close area. So I'm going to refer now to the Ringway Jacobs Essex County Council Traffic Highways Baseline Technical Note dated the 25th of October 2017, which was attachment 1 in my evidence, and it's based on data from 2014-2015, and it describes itself in the document as being prepared to inform the local plan. The reason for reflecting on SER2 is that the Ringway Jacobs assessment does not look beyond SER2 and have not been able to access any similar Ringway Jacobs assessment for looking toward SER8. So it makes sense, therefore, to assume that the impact of SER2 becomes a baseline for SER8. As I said, apart from being common sense, it's also consistent with the MPPF guidance, which states that traffic assessments should consider the cumulative impact of multiple developments within a particular area. SER2 is still in construction 4 years after the Ringway Jacobs assessment. So the assessment was of the highways before, just during the commencement of building phase 1 of SER2 and before the application of 662 homes under SER8. Attachment 2 in the evidence submission depicts a local network referred to in the next section, and for clarity the enlarged version is here. I'm going to ask Mrs Austin to just point to the junctions that I'll highlight. Right, the Ringway Jacobs report states, high levels of congestion are observed on all 3 approaches to the Ashington Road, Hall Road, West Street roundabout, which is junction 1 on the map. It also describes medium to high levels of congestion along the majority of Ashington Road, which is number 2 on the map, and also described there being very little free flow of traffic along the Ashington Road. And in attachments 3A and 3B, which you've had for some time, are examples of typical days on the Ashington Road. These evidences were gathered randomly. There were no schedules or any particular events or anything like that. People just out driving, and they are not all one event. That is various people at various times putting forward that evidence. The Rectory Road junction, junction 3, is highly congested, where it appears to stem from the railway bridge where the road merges into one lane for both directions, attachment 4. And I emphasise that. Appears to stem from the railway bridge. It says around Hockley Town Centre, junction 4, all the principal local routes are shown to be congested in all directions. The B1013 Spa Road, Southend Road mini roundabout is particularly congested. The report also includes local development plan engagement which also identified Nursery Corner Hawkwell, junction 5, as being perceived as a congestion problem. The Ringway Jacobs report, page 65-66, which is what I'm verbally adding, which wasn't in the text, describes Canewden Road to Hall Road. Could you just point to that on the map, please, Christine? So Canewden Road is at the top end of Ashington Road. So what that's saying is that the whole length of Ashington Road is a key congestion corridor. And at the top end of Ashington Road, you can see there are junctions coming in from the left and the right, which from Holbridge and Canewden. and are sources of inflow of traffic into that network. So, the reason I've pointed those things out at the moment is it'll become clear as we go on to talk about SER8 in a moment.
Okay.
Okay. The Ringway Jacobs and Essex County Council assessments were based upon the table which was submitted with my original evidence, which was table 4.1 congestion description, which was page 46 of the Ringway Jacobs report. And at the beginning of this week, I also gave you copies of that. I should just emphasise that the Hall Road B1013 that I mentioned, the B1013 Hall Road is the main spine between Rayleigh and the settlements of Hockley, Hawkwell, Rochford. And the end of that is the Hall Road roundabout as we describe it. We will argue that the Ringway Jacobs report describing the projected impact and mitigation of residential development makes unconvincing comments on the roads and junctions. In the opening statement in the report about SER2, sorry Chris, could you just point where SER2 is on the map? It's in the whole road section, isn't it? The orange section at the bottom. It says about the Hall Road, the development poses a significant increase in peak flows along an already congested part of the network. It does state that numerous improvements have been made to mitigate congestion which have now been implemented, but without further explanation. It adds that despite these improvements, the development is projected to generate 482 two-way trips in the morning peak and 357 in the afternoon peak. This adds up to a total of 1,678 daily trips. Now, I just emphasise it mentions numerous improvements. Now, what's actually been improved is, as part of the development, there are two accesses onto the Hall Road. They've created two new roundabouts there, which allow an inflow and outflow from the Hall Road development. They don't contribute to the junction end of the Hall Road. And as you'll see later, we'll show that the mitigation at the Hall Road is actually irrelevant. So, I move on. So in considering junctions, and for the purpose of this report, and at this point I focus on the mini roundabout at the junction of Hall Road, West Street, Ashton Road, which is described as Junction 1. It's described as having high levels of congestion on all approaches. Ringway Jacobs describes the projected effect on peak delays will be very high, with up to 125% increase. It then adds that widening has been undertaken at this intersection. And I just argue that the widening has an insignificant impact. I'd just like, Christine, would you point to that? The Hall Road junction ones, the pictures of the cars. That's Hall Road junction, yeah. Yes, at that point, you can see that the Hall Road narrows under the railway bridge to the extent that footpaths are not viable for pedestrian use, which is what the Ringway Jacobs report says. Then it widens slightly to the junction. Now that widening, that slight widening, was the proposed mitigation for the extra traffic on there. Now it's not particularly easy to see, but what that widening was providing a small left turn lane about 1 car length long. Now, as you can see, and that is not contrived evidence, that was going there on a off chance. That one,
I'd just say, if it's any help, I have visited all of the junctions, so although I'm more than happy to look at your photographs, I am familiar now with the layout of the junctions.
okay. The point I would make is that that 1 car length of extra width rarely gets used, because you can see from the traffic pictures there, cars approaching that junction tend to straddle both lanes. Occasionally there is a second vehicle, but it's very rare, and that's just pictorial evidence and daily observations. And that was taken at, I think it was 3. What was the time I said on it? It's about 3 p.m. on the 11th of November. So it's a minor tweak, I would describe it, as to mitigate the 125% increase in peak delays at the junction. As I say, they were taken at 3 p.m. on the 11th of November. We checked the road, the 3 arms. There were no obstructions. This was just the weight of traffic and the effect of that junction. And the point is, I've been unable to find, I've requested, but I've been unable to find any evidence that ECC Highways has tested the actual traffic flow against its definitions in the table above, which I handed out separately, since the construction of SER2 started. So I now move on to SER8. The Bloor planning application for 662 dwellings shows 2 access points to the site. The primary access phase 1 and 3 onto the Ashton Road. The secondary access for phase 2 is via Percy Cottage Road. Entering or leaving via this secondary access has 2 alternative routes, one via Ashton Road, the second via the Rochford Town Centre Conservation Area. So I'll make more of this later, but first I'll focus on the primary exit. So leaving via the primary exit onto the Ashton Road southbound leads to the Ashton Road, West Street, Hall Road mini junction roundabout, as discussed. In the case of this heavily congested junction, it's obvious that no junction improvements are possible, and that is not contested anywhere. It's stated, it is the case that at the Ashton Road, West Street, Hall Road junction, no junction improvements could be carried out, and the proposed development would add to queuing and congestion here. And they're the attachments 5. In fact, the Ardent report is quite interesting. It shows drawings of all the key junctions with the current state and then the proposed state as a result of mitigations, except for this particular junction where it just shows the current state, which is actually misleading anyway. It shows 2 lanes from Hall Road into the roundabout as if they were continuous. In fact, the 2 lanes merge into one car length. It fails to show the road narrowing under the roadway. It doesn't even show the narrow lane into Hall Road. And it adds that the Highway Authority has considered, not tested, not measured, has considered the impact carefully and do not consider that this residual impact would be severe. Now, I point out here, if I may, sir, that on Tuesday morning, our local MP, the Right Honourable Mark Francois, reminded us about a meeting he had with Essex County Council by audio link some months ago, back end of 2020, I think he said. And they actually admitted that they don't have a definition of severe, and that their normal reaction, the default reaction, is to approve things. They very rarely reject anything. So I'll just, and it's sort of labouring a point, I suppose, but I'll just further in assessment of the SER2. It described the junction be over operating theoretical capacity, which would be exacerbated by the development.
Sorry, I'm just going to pause you there because I was just writing my note. Tell me again, Mark Francois MP, video meeting with ECC, don't have a definition of severe.
Yes.
Default reaction, tell me that bit again.
Sorry?
You said what their default action or
The
reaction?
default action
Yeah.
is to approve applications.
Okay.
They very rarely reject any planning applications.
Okay.
Even as far back as 2020, an Ardent report in relation to SER2, as it happens, was damning even then. It described it as operating over theoretical capacity, which would be exacerbated by the impact. The report, page 53, 6.62, says the junction is located in an area with severe restrictions for improvements to the layout. The railway overbridge on Hall Road has restrictions in both its width and height. Ashington Road and West Street are historic roads which also have restricted widths due to the properties or the stream on either side. In order to accommodate any significant further improvements to the junction, it will be necessary to acquire third-party land and demolish houses on the Ashington Road approach and or widen the existing bridge under the railway line on the Hall Road approach. This would incur an excessive cost which cannot be borne by this development alone, which should not be expected to overcome an existing capacity restraint of this nature and provide a benefit to the wider area on its own. To be clear, this was before SER2 and SER8 and numerous other developments such as Braes Lane, which have happened in the period since then. So, we have a junction described as highly congested by Essex prior to SER2, to which congestion is increased by the development. Now, SER8 will add to the queuing on congestion, and this is recognised in the Ardent report. But at no point does it seem to evidence that Essex Highways has tested these increases against its own definition of severe, as illustrated in its own table. The words consider and considered do not suggest or imply that the impact has been assessed against any definition of severe, nor indeed their own definition that was in that table. Seems to me, given that they announced that they didn't have a definition for severe, they seem to have forgotten the evidence that was in their report. So, leaving the primary access and heading in the other direction along the Ashton Road northbound leads to the junction with Rectory Road, number 3 on the map as we saw. As above, Rectory Road is described by Ringway Jacobs as highly congested, primarily due to the railway bridge narrowing the road down to a single lane blind corner controlled by traffic lights. And there are some pictures of that in attachment 4. A couple of pictures showing the junction, the blind turn and so on. And it says to be clear, it doesn't say to be clear, sorry sir, it is clear that there is no mitigation possible here. Like the Hall Road Bridge, it would require massive investment to rebuild a railway bridge and widen the road. So that narrowing to a single lane is described as the source of congestion for the Rectory Road, Ashton Road roundabout. At the time of the Ringway Jacobs ECC assessment, the mini roundabout at the junction had 2 exit lanes into Ashington Road, 1 left turn and 1 right turn. And that's been mentioned before, I think, by Councillor Eaves. Due to the proximity of the nearby Pelican Crossing in Rectory Road, which is heavily used by pedestrians and cyclists, the 2 lanes were very short. The distance between the Pelican and the junction is probably 2 car lengths. And like Ashington Road, actually, like Hall Road, where the 2 lanes were quite narrow, they were often straddled by cars, so they created 1 lane. But ultimately, Essex, subsequent to the Ringway Jacobs report, modified the junction to reduce the 2 lanes down to a single lane for what are understood to be safety reasons. Now, I know that was challenged when Councillor Eaves said it yesterday. I live probably about 300 yards away from there, just around the corner. When that change was made, there were boards up explaining why it was happening. for safety and. Unfortunately, I didn't realise at that point that I would be here today, some years on. Otherwise, I would have taken some photographs to provide the proof. I haven't been able to find any proof subsequently, sir, but I do assure you that that did happen. So it's reduced from 2 lanes down to a single lane for what were understood to be safety reasons. Excuse me. So the application simply reverts that part of the junction to the way it was at the time of the assessment. So, question really, has safety become irrelevant? So the application also proposed adding a left turn lane at this junction northbound. It would appear this would cause narrowing of the paths, but I would say based on something I'm going to talk about now, I would suggest that changes are irrelevant. The drawing from this extra lane shown in the original attachment 7A from the Ardent traffic, and that's the left-hand picture at the top. No, the other one, Chris, please, for the minute. Okay, and that Ardent, the left-hand one, that's it. That was the Ardent picture of that junction. What it failed to do, we show the shops that the turn into Manstead Gardens, which is immediately to the north of the proposed extra lane. You can point that out on the colour on Manstead Gardens there. Come in, sorry, go up a bit. Right, go across to Ashton Road. That road across, that's Manstead Gardens. Okay. So this right or left turn into Manstead Gardens is a regular point of congestion in both directions due to the shops, car park, car wash, and photographs are attached there, which show people waiting to get in, get out, block the road, Ashton Road, and that's at the Manstead Gardens turning. And that's a frequent occurrence any time of day. In the original submission, in the evening rush, northbound traffic turning into Rectory Road is delayed by pedestrian and cycle use of the Pelican crossing in Rectory Road close to the junction. These delays spill into Ashton Road, causing delays there northbound. Now, adding a short, narrow left turn lane in Ashton Road is a minor adjustment and has insufficient length to resolve that problem. There is also a well-used Pelican crossing just to the south of the Rectory Road, Ashton Road junction, which also delays traffic in both directions. In short, the revisions to the mini roundabout at this junction actually had nothing to highway capacity nor to improving traffic flow, because that junction isn't the problem. The problem is the Pelican, Manstead Gardens, and not forgetting the earlier discussion from Ringway Jacobs about the source of the delay being the single lane at the railway bridge. So I just emphasise that these minor tweaks actually do nothing. We've seen that these short lanes do nothing. These short left turn lanes do nothing. And I should also mention at this point, when this is in addition to the original evidence, I've not mentioned before the Sutton Road and Berlin roundabout. Again, it adds a turn lane, so it's a similar discussion. But the assessments don't look beyond the junction. If you look at the left turn lane from the Anne Boleyn roundabout, it leads to Sutton Road. Sutton Road is a relatively narrow country lane which leads down from the Anne Boleyn roundabout round in towards the eastern side of Southend. It feeds 2 industrial estates and also leads into, as I said, the east of Southend. And also the Rochford district has a lot of outlying villages, and there's a river that separates them from Rochford itself. So that Sutton Road exit also is the access route for some of the villages in the east of the district. So if you go along that road in the morning peak, it tends to be heavily backed up, worst case, all the way from Southend back to the Sutton Road junction. And in the evening, it's quite the reverse. It's just a heavily used road and it's a very small country lane. And as I say, the traffic assessment, as far as I can make out, makes no reference or assessment of the traffic beyond the actual junctions. The other thing I just mentioned briefly, and it was our MP was wanted to touch upon it on Tuesday, but sort of didn't have the time, is if you look at our roads, and those of you that got here from out of town, mostly driven, I assume, not on public transport, would have spotted that our roads are a mess around this area. So roadworks, necessary roadworks, are a frequent problem. A resident, and I haven't got the actual factual evidence here right this minute, but can acquire it if necessary, made a Freedom of Information request to cover the period July 19 through to October 2020. And he came up with 130 roadworks in the Ashton Road, Hall Road, Southend Road, Sutton Road, Bradley Way. So roughly an average of 2 roadworks per week throughout that period, and that's continued since. Anybody who travels these roads every day knows that they're a mess, and we moan because the roadworks come along and slow us down even more, but they're necessary to try and begin to sort out the mess. So I talked about the primary access. I've not yet talked about the other junction, Ashton Road, which is the Roach Avenue, Daly's Road, which incidentally, along with many other basic errors in the Ardent report, they kept calling it Bailey's Road. And if it would help, I could probably list the 9 or 10 errors I identified, just factual errors in the Ardent report, but I won't dwell on that at the moment. So this junction is a few hundred yards north of the troublesome Ashton Road, West Street, Hall Road junction. Now, the suggestion is adding extra lanes to each leg of the Daly's Road junction by adjusting road markings or road widening, but that doesn't have any impact on the Ashton Road, West Street, Hall Road junction. There are pictures in the evidence pack of traffic backed up from Hall Road past the Daly's Road junction back up to the Ashton Road. So the argument is that that actually does nothing to address the through-going problem. I would say that the left turn does provide an escape route from the Ashton Road, of course, a left turn, but what that does is lead you into the Rochford Town Centre conservation area, which would be a negative consequence. And I'll come back to that in a moment in relation to the High Court judgment, which Miss Reid mentioned this morning. I'd like to pause now, if I may, sir, to have the video clip.
Okay, so do you want to just tread water, as it were, for a few moments while the appellant's team moves? So I think my oblique view will still be okay here.
It's all right. You did. I did. You're right.
Remind me how long it is, 5-6 minutes?
5 minutes.
Yeah.
All right. And we'll stop it at 5 minutes if necessary.
Yeah,
I just point out, just before we press the start button, at the time we commissioned this time-lapse video, it was a rebuttal to what we thought was a time-lapse video submitted by the appellant. It turned out that the appellant had actually submitted still photographs from a video. So we provided stills as well, which I think we've
I've
presented
got them
you in the meantime.
there, yeah.
Stills from the time lapse. Yvonne, if you'd start it and stop it after 5 minutes. Okay.
What is its duration? It'll tell you at the bottom, won't it? Is it?
Right. This is
7:23 in the morning.
Sorry, I meant it's just with Mr. Foster saying stop it at 5 minutes. If it's only a bit, yeah, let the whole lot run then at that. Yeah.
okay. Yes. So these are time-lapse shots from along the Ashton Road at various points through the day. And I'll explain the reason why we're showing it despite the appellant only having stills. up to here was Ashington Road. Now this is the Rectory Road, Ashington Road roundabout and the shops I referred to in the map.
I take it that.
Right.
Take it that's the end.
Thank you, sir. That's it. Shall we give them a couple of minutes to get back into position?
Yeah, thank you.
What date did I say that was? What date did I say that was? Last week, wasn't it? Okay. Right, thank you, sir. So, apart from what one might describe as an obvious purpose in showing that, first of all, for the sake of honesty and clarity, I should say that at about 3/4 of a mile, half mile, 3/4 miles down the road were some roadworks that started about 11 p.m. that morning. 11 a.m. Okay, so the queuing that you saw at the start of that was way before the start of any roadworks. Now, apart from the obvious reason, I've shared some stills with you, which you had earlier in the week. I stand corrected on the roadworks. They were pavement works, actually.
Pavement.
Pavement
Yeah,
works.
Yeah.
But knocking onto road effect. Now, the reason I've given the stills from that time lapse is we've been a bit puzzled by some of the evidence we've seen submitted in things like the Ardent report. And what we tried to demonstrate was, though that was a busy road, as shown by the time lapse, it's not that difficult to take a photograph of points where there are gaps in the traffic and apparently there's little going on. And the original traffic submission from Ardent, it looks like a little country lane where there's never any cars going down, and it couldn't be further from the truth. Apart from the fact they wrongly named it, they also took a couple of pictures of the wrong place. Right, so I'll go back now to what I was saying before. Right, I was talking about the extra lanes providing an escape from the congestion via the Rochford town centre. So going on, looking at the access for the homes proposed in phase 2 of the development is via Percy Cottage Road. Now actually there are essentially two alternative routes on leaving via Percy Cottage. You go to Ashington Road via Greenway and Somerset Avenue, or to Daly's Road via Greenway, Somerset Avenue and the Drive. There's also a road called Rochford Garden Way, which forms a loop around Percy Cottage, providing alternatives for part of both routes. But they all lead to outlets either towards the conservation area or to Ashington Road. Percy Cottage Road and all of these roads are narrow and they're characterised by high levels of on-street parking with little off-street opportunity, sharp blind bends and corners, and in attachment 9 there are some pictures that show the environs of Percy Cottage. And one of them, it's the one that's got an arrow pointing down on it, is actually the proposed secondary access. You can see there at the moment there's a white van parked in there and a couple of others.
Yep.
Yeah. And the people who park there, they don't have any off-street parking capability, and they're rather angry about what might happen if that becomes the access to a new development. So again, one of the exits leads to the conservation area, and again I'll come back to that later in the High Court judgment. One of the things that's really not mentioned in the Ardent assessment, and perhaps most importantly from the perspective of that area, is the fact that the entrance to Waterman's Primary School is nearby. So extra traffic combined with the existing levels of on-street parking could well present a safety hazard for children walking to school. So finally, on the Percy Cottage Road issue, the Ardent assessment, page 38, and I think that's in the pack as well, stated that in addition to the primary site access design, all other accesses have been subject to an independent stage 1 road safety assessment. It goes on to say, again, no significant issues have been raised as a part of this audit. It then refers to the stage 1 road safety audit in Appendix G, where it says, and it's attachment 10 in the pack, it says the road safety audit stage 1 actually identifies 3 risks associated with the Percy Cottage access, 2 crash risks and 1 pedestrian risk. That is not no safety issues being raised, or no significant issues being raised. Now, it's fair to say there is a proposal for some mitigation there, which is basically widening the footpath on that current dead end of Percy Cottage Road and increasing the splay for visibility. But the issue isn't with just that, it's that whole area and the increase in traffic. The other thing that was identified was hedgerows overgrowth, and the answer would be to cut that back. But if it grows again and grows again. A further issue barely mentioned in any analysis is the incremental impact of construction traffic. Whilst the entrance to, I missed to point out, by the way, that stage 1 road safety audit, it was a office-based audit during June 2019, based on a site visit of just over 1 hour duration. So a further issue barely mentioned in any analysis is the incremental impact of construction traffic. Whilst the entrance to the construction site is shown as via Braes Lane, the only access to Braes Lane is via Ashton Road. Apologies, sir. Because of railway bridges in Hambro Hill, Rayleigh, Greenswood Lane, Hockley, Hall Road, Rochford and Rectory Road, Rochford, the routes to Ashington Road are either from the A127 through to Warners Bridge, Southend Road and to the Hall Road, West Street, Ashington Road Junction, all described as heavily congested. I should have added that the information I've had on at least two of those bridges, the Hall Road and Rectory Road, is even though it's an under-bridge road, there's a 7.5 tonne weight limit on those and a 4.1 metre height limit. So, go back. So, access from the 127 through to Warner's Bridge. A127 is pretty much rammed during much of the day. Warner's Bridge, Southend Road, and to Hall Road, West Street, Ashton Road. The other alternative, avoiding bridges, is from the A1235, which is to the west of the Rochford district, via a road called Rawworth Lane, through the village of Holbridge, down a narrow country lane called Lower Road, where it's difficult for even two cars to pass in opposite directions. Just as a by note on this, really, there's an attachment in the context of Bloor. It would seem they've got a very poor reputation in relation to construction traffic. There was a big newspaper article, hugely critical of Bloor about construction traffic servicing a large development in Stratford-upon-Avon. I missed a point there, if I may, just going back to the road safety audit. It says in the audit, the report has been compiled only with regards to the safety implications of road users of the layout presented in supply drawings. It's not been examined or verified for compliance with any other standards or criteria. Right, I'd now like to move on to refer to the Rochford Town Centre Conservation Area. In the above comments I made about routes out of Percy Cottage Road and Daly's Road junctions, I explained that both of these could draw traffic through the Rochford Town Centre. This would be unacceptable. There is evidence to support this. Attachment 12, I've supplied extracts from the 2012 High Court judgment, case number CO/605/2012, which was heard on the 30th of May, 1st of June, in 2012. The claimant in this case was Cogent Land and the defendant was Rochford District Council. The claimant's application was for the inclusion of an area known as Coombs Farm to be included in the local allocations plan for housing development. This Coombs Farm is on a road called Stanbridge Road, which feeds into the Rochford Town Centre Conservation Area. Rochford District Council successfully defended the appeal and the claimant's application was refused. One of the reasons was a potential traffic impact on the conservation area. Though Coombs Farm is slightly further east than the proposed Bloor development, in the judgment handed down on the 21st of September 2012, there are 2 points which I believe to be significant in the context of the Bloor application. The transcript states, Rochford Ashington, in theory, has reasonable good transport links to Southend and the A127, but in practice the area is heavily congested, with congestion on Ashington Road being amongst the worst in the district. It also states, when referring to the reasons offered for not including Coombs Farm in the plan, it would generate traffic on local networks for non-local reasons, i.e. traffic to Southend would likely be directed through the centre of Rochford, including through the conservation area. The judge accepted that argument against that land being put in the local plan. And as I said, the secondary access from the proposed Bloor development would lead through the conservation area or onto the Ashton Road directly. Even if it took traffic through the already crowded conservation area, the exit from that goes down to Bradley Way, where it picks up the traffic that's passed from the Hall Road junction through to the Amber Lynn junction. I'd now like to move on to alternative routes to avoid congestion. Whilst Arden, Bloor and Essex highways argue the impact of the development on road traffic is not severe, the Arden report suggests that increased levels of congestion on the network due to increased traffic demand will likely lead to some existing and new drivers retiming their journeys to avoid peak times of congestion, also adding that some drivers are likely to take alternative routes, if available, to avoid congestion. As we saw earlier on, through the map, all of those alternative routes for anybody moving down the Ashton Road go to one of those junctions that are variously described as congested or heavily congested in all directions. So it would appear that drivers, or there's an opinion, shall we say, that drivers will be taking actions to avoid allegedly non-severe congestion by taking highly or very congested alternatives. Longer routes, burning more fuel, creating more pollution, to avoid congestion, to move into congestion. So it seems to me, thinking also about people changing their travel times and so on, people are, from local knowledge, people do that when they can. People are driven by the need to be at work by a certain time, to drop the kids off a certain time, and you know, that's the lives they live. And effectively, I think what this is asking is asking people to change their lives to fund Blaw's profit. Why should they? In fact, I wonder whether Mr. Flexman would be able to give evidence and we could cross-examine him, because it appears that he seems to have prepared evidence for the appellant rather than the defendant in this. But so elsewhere in the Ardent report, page 70, paragraph 6.35, it describes the RKD, or RKD, I don't know how it's pronounced, software being used to assess capacity for standard and mini roundabout junctions in the network. It makes the following statements, which were in the attachment 10. And I'm going to go through them. Page 71, 6.42 says, the tables reflect maximum ratio of flow capacity for junctions, then goes on to say, the software is not well suited to model the impact of additional traffic on approaches already operating close to or above the theoretical capacity, tending to exaggerate the resultant increase in queue length. They wouldn't want to hear that, would they? i.e. the model becomes unstable. On pages 77 and 78, discussing the results, in point 6.66, it states, the junction is predicted to operate over theoretical capacity with 2029 base flows, and so the model is unstable, with queuing and delays rising exponentially, i.e. queue lengths are exaggerated. Wouldn't like that either, would they? In 6.67 it states, the addition of development traffic will add delay and queuing at the junction. However, not to the extent predicted by the model, since this is unstable. As such, the results should be treated with caution. These comments are related to the Ashton Road, Hall Road, West Street Junction, which I mentioned earlier in this paper. Read the report to the Development Committee on the 24th of June 2021. On page 79 of the RKD results, point 6.73, in relation to the Southend Sutton Road junction, it states that the Southend Road North approach is predicted to operate over theoretical capacity in the morning peak hour with 2029 base flow. So again, the model is unstable with queuing and delay rising exponentially. In 6.74, it states also, the addition of development traffic adds to delay and queuing. However, not to the extent predicted by the model, since this is unstable, and as such, above results should be treated with caution. So, I'm not an expert, but I think I'm quite logical. I would say, in raising this point, is it not reasonable to offer the view that it would appear that the appellant concludes, if you use algorithms and software tools for modelling, and they give answers that don't suit your argument, ignore them. I would now like to move on to the Essex County Council corporate response. Which was attachment 13. Essex County Council made what's called a corporate response. It described as a corporate response, representing the view of all areas of Essex County Council responsibility. not just those of the statutory consultee Essex Highways. Of 20 pages, just 7 were related to highways and transportation. Extracts from the report, not technical highways assessment, are as follows. Referring to highway changes in Ashton Road to accommodate the primary access to the development, it states, the additional lane on the highway, the right turn lane outside the schools, would necessitate a diminution of the segregated footpath and cycle lane outside the Holt Farm Infant School. And this is a cause for concern from both an education and a public health perspective. It goes on to say, the applicant proposes that at this point outside the school, the segregated cycle lane also becomes a shared space before continuing again to the north and south of the school, either segregated or shared. In actual fact, the segregated cycle lane is a misnomer anyway. It is what was formerly just a footpath. Now, with the white line painted up the middle, and dangerous in that, with hundreds of school children and parents walking the path, pedestrians have been clipped by cyclists. The shared space resulting from the widening of the carriageway is in fact the footpath side of the aforementioned so-called segregated space. And according to officers, cyclists will be expected to dismount and walk the length of the shared space. In fact, I would argue that the whole length of the so-called segregated cycle lane is not segregated at all. The Essex report goes on to say, quoting the Department for Transport's gear change policy, it goes on to reinforce that cyclists must be treated as vehicles and not as pedestrians, and the imperative is to avoid conflicts between users. Brackets, this is reiterated in the NPPF. It therefore recommends that users are physically separated on urban streets and shared spaces should be avoided. It then goes on to add, it's very important that the route is safe and inclusive for all. Now, some of the pictures that we updated with the redactions this morning showed a couple of pictures, and there are others in the evidence showing the narrowness of the road, but it's quite interesting to see. The pictures I showed you were of 2 cyclists and 3 ladies. Now, I heard a comment from somebody apparently on the appellant's side, but I can't confirm that all it demonstrated was that it's not very busy. Well, actually, this was during the school Christmas break, when the rush of children and adults up the road was obviously not present. But what we saw at first was the lorry, parked on the footpath, which is in your evidence pack. And the reason it was parked on the footpath was I challenged the driver, why you parked on the footpath, and he said it's because we're causing mayhem in the Ashington Road. Then, unfortunately, I wasn't able to get the camera out quickly enough. The ladies with the pushchair, the 3 ladies with the pushchair pushing a child, had to obviously go around that van to stay on the footpath. But then you can see in the pictures that the 3 of them, between them, are straddling the cycling lane. And then you can see the picture of 2 cyclists, one on each side of the white line, which allegedly segregates the cycle lane from the footpath. You can also see on that picture the 2 cyclists, as I say, though it was during the afternoon and it was during the school holidays, in the background you can see the Ashington Road is quite rammed and heavy with traffic. That was not in a peak period. That's right, don't worry about that. So the Essex report goes on to say, as I mentioned, it's very important that the route is safe and inclusive for all. So we have a situation that the existing cycle and pedestrian route is not compliant with NPPF recommendation that users should be physically separated on urban streets, but also due to the increased traffic and road widening, including in the proposal, Even the path/cycleway separated by only a white line is removed and becomes a footpath that requires cyclists to walk. Further, the ECC report goes on to say, the applicant appears to prioritise securing a means of vehicular access into the site over the potential impact on Holt Farm junior and infant schools through a reduction in the segregated footpath and cycle lane, which we do not support. And I'll refer back to the letters from the school that I handed out earlier. At this point, I'm adding 3 unsolicited comments picked up from residents in the course of this week. That's this week being the time I wrote the evidence. They reflect commonly held concerns about the danger of narrow footpaths and so-called cycle lanes in sections of Ashton Road, particularly in the vicinity of the Holt Farm schools. One said, I've just driven along there and a little girl just ran into the road to get past people on the path. Luckily, I was going slowly, but it scared me. I must add, I've personally witnessed that kind of situation outside the Holt Farm school. Second one, a cyclist said, I tried to avoid cycling the Ashton Road because the cycle lanes are dangerous for pedestrians. This person reported along the pedestrians, the third, this person reported walk along the pedestrian side of the white line in the path, being narrowly missed by a cyclist. The point to be made is that the footpaths are already narrow and dangerous for the literally hundreds of children and parents that walk these paths, shared spaces, to and from school each day. The ECC report goes on to discuss noise and air quality, suggesting that the RDC should need to be confident that the proposals would not have a detrimental impact on the vicinity of the Holt Farm schools. I would add to this that the other schools, including St Teresa's, Rochford Primary and the Rochford Day Nursery, on the day of this writing of this report, 11th of November 2021, I went out around the district between 2:30 and 3:30 taking photographs, some of which are attached with the note. By the day nursery, situated at the junction of Ashton Road, Hall Road, West Street, the traffic was chaotic, and that's one of the pictures, or 2 of the pictures up there. The air was fume-filled from vehicle exhaust, my personal experience. The children's play area for the nursery has a metal fence railing construct, which is approximately 12 feet from the edge of the road. And you can see on one of the pictures in the attachment, there's a lorry just quite close to it. And I say this is a stark reminder. I'm not, a lot of people have brought this point to me. It's a reminder of the case in South London last year when the death of a young girl was attributed by the coroner to exhaust fume pollution. And as I said, photographs in attachment 5 and on the show the proximity. In response to the statement of common ground, which never came to fruition, but we offered a statement as follows. An air quality assessment has not been carried out in the area of Hall Road, Ashton Road, West Street Junction, and particularly at the preschool at this junction. I suggested that as an agreement, as a statement of common ground, and it was ignored. Well, the response, it wasn't quite ignored. They said the response was that the appeal site does not lie within or close to a designated air quality management area, AQMA, the nearest being Rayleigh, some 10 kilometres away. This doesn't mean there's not an air quality problem. It means it's not being tested. You may have seen yellow ribbons attached to the safety barrier outside the Holt Farm School. In this bag is a small handful of, You have a bag here. Sorry we couldn't submit it because it's a bag. A small handful of those ribbons which were removed from the barrier last week. As an experiment, we soaked them in boiling water, and this is the result. We can leave this behind if you wish. What you can see is the bottom is tar that's formed, and if you shake it up, that's extracted from the ribbons by the Ashton Road. That's what our kids are breathing. Road fumes. Apparently there's a discussion going on in Parliament today about a child who died as a result of road fumes. I'd just like to add a comment from the October 2020 air quality assessment, which was, I think, Ardent. Yes, it was Ardent. It says, schools and children's playgrounds are considered to be sensitive locations for comparison with annual mean objectives due to the increased sensitivity of young people to the effects of pollution, regardless of whether or not their exposure to pollution could be over an annual period. And I just point out that those rails at the top of those barriers are about head height for primary school kids walking along. On the subject of public health and well-being, the ECC report highlights a number of issues and concludes, until these issues are assessed and mitigation measures agreed to address any negative impacts identified, the application cannot be supported by ECC in respects of local authority for education and public health. On education contributions, the ECC reports that if RDC were minded to turn down the application, we'd be grateful if the lack of education provision in the area can be noted as an additional reason for refusal. Now, I'm sure that the applicant will claim S106 would address that, but I remind sir that the schools have actually opposed this. So, none of the above, sorry, I think I missed a bit. No, sorry, right. None of the above issues and objections from the non-statutory consultee areas of Essex County Council were included in the report to the Development Committee meeting of the 26th of November 2020. The one item, the footpath, becoming a shared space for a distance, was noticed by a councillor and explained away by the officer with the answer that cyclists would have to get off their bikes and walk. And unfortunately, none of these non-statutory ECC issues were included in the motion to defer, and consequently not included in the discussion to consider and then reject the application. So we have a situation where the report provided to the Development Committee on the 26th of November did not include non-statutory consultee objections of the Essex County Council report, but did accept the statutory consultee element, Essex Highways. And as I said, the RDC report to the Development Committee showed no evidence that it tested Essex Highways' not severe conclusion, because it's ultimately the local planning authority is responsible to satisfy itself of severity. In this matter, I refer to the answer, which was attachment 14, by Brandon Lewis MP on behalf of the Department for Communities and Local Government on the 17th of November 2014, in response to a question in the House of Commons. It states, it's for the local planning authority in considering planning applications or the planning inspector in considering planning appeals to consider whether improvements can be undertaken within the transport network that cost effectively limit the significant impact of the development on traffic levels and determine whether the residual cumulative impacts of the development are severe. And as I said, I see no evidence. I've seen no evidence. I've searched for evidence. I've asked questions. I've seen no evidence that either the Highways Authority or the Planning Authority tested the traffic impact against the A definition of severity. And the only definition of severity that I've been able to find is the one that I shared with you, which was in the Ringway-Jacobs assessment. And the next level above the congested that they describe in all the junctions, next level above is severe. I don't believe severe was ever tested. So now, just before moving on to conclusions, I want to mention some additional evidence that I submitted on the 23rd of December.
So is this your housing bit, which I haven't yet had passed to me?
Yes.
It is. Yes.
It's right. Okay. Yeah. Would you like the copies we've got now?
Yeah, please. Yeah, I think everyone else seemed to say they'd got it, but yeah. Thank you.
Just to double check, oh, thank you. I was just checking that I've actually got the same. Thank you.
Over there. Thank you.
Yes, that is all.
It's relatively short.
Yeah, no, I can confirm I have seen it, but I hadn't got a printed copy of it with me. But yeah, by all means, carry on.
Right, so, excuse me. I'd like to talk first about housing shortfall. In Rochford District, there's been long-running opposition to the housing numbers imposed upon us by the East of England and central government diktat. Pursuing this argument in a letter to the Right Honourable Michael Gove MP, dated the 1st of November 2021, from Rochford District Council, signed by the leader of the council, the portfolio holder for strategic planning and the chairman of the Planning Policy Committee, they challenged the way algorithms are used to decide how many new dwellings we should build. They particularly argued that the algorithms do not work for Rochford District Council being a largely agricultural peninsula bounded predominantly by water. The response from the Minister of State, the letter and the response are both attached. The response from the Minister of State for Housing is interesting, saying clearly that whilst the NPPF introduced a method for identifying housing need, it does not set a target for the number of homes to be built. In fact, the Secretary of State, we know as a result of this challenge that was put, is actually looking at the process of identifying housing need. I don't know what the timetable is for that, but we know also there is a review of planning law going on, which seems to be not going very far at the moment. In talking about housing need, and I'm sure I'll be challenged on this, and I can't evidence it, but I will say it nonetheless. One of the developments quite close to Ashton Road is called Braes Lane, which is where the construction access is. A resident there did a survey, and I'll be happy to try and dig that out if I can, but did a survey that identified that approximately 75% of the houses in that development were bought by local people. Of the 25% were bought by people from outside the district. It also identified that of the people that were from the district and bought houses in Braes Lane, when they moved, they were normally bought by people from outside the district. And the point is, and many people have speculated on it, and it's very hard to prove, but it is provable, that this housing need or housing requirement that was imposed upon us is actually a mechanism for sucking people into the area. It's not totally satisfying the needs of Rochford District people. I'm just going to go on a bit more to talk about housing numbers included in the local plan. As I said, they were not calculated by the local plan, but on numbers imposed. But despite that, in the Statement of Common Ground signed by the appellant and Rochford District Council, in paragraph 2.6, as Ms. Rees says, it identifies a shortfall of 331 in the housing trajectory for dwellings based on the imposed numbers up to the period March 2025. excluding the applicant's proposed development. However, I would argue there are mitigations on the horizon. They're not yet scheduled for build and still to go through detailed planning. In Table 7 of the Statement of Common Ground, it identifies, sorry, lost my track there. It identifies that shortfall of 331, and there are, however, as I said, mitigations on the horizon. They're not scheduled for build and still go through detailed planning, I believe offset this. In Table 7 of the Statement of Common Ground, it notes that an additional 222 houses were granted outline planning permission to be built in the development under construction by Countryside Homes. Now in the table, it says here, 550 under construction. The site has planning permission for 547 and an application for a further 222 dwellings approved subject to Section 106. That extra 222 were approved at July 2021 Development Committee meeting, and the Section 6 agreement was actually signed last week and a decision notice issued. So that's potential replacement for 222 of the 333. On the second one, coincidentally for 222 homes, which includes, I have to admit, some care home type accommodation, but the majority not so. So there's an application for a retirement village off Cherry Orchard Way in Rochford, previously rejected. It was granted on appeal on the 5th of November 2021. In this case, the developer is optimistic that the reserved matters application will be determined by the end of June 22 and aims for completion in that development in the years 23 through 24. So, whilst timing is to be determined for the Countryside Homes plan, it can reasonably be assumed, in my opinion, to cover in total the shortfall described above, this 331. So, and honestly, I would say it's a puzzle. I hate to be critical of my Rochford District Council colleagues, but I do say it's a puzzle that was signed off. I would also add, in relation to the Statement of Common Ground, that windfall numbers are not considered in that projection, trajectory. Over the last several years, the average windfall numbers within Rochford have been around about 50 per annum. Also, as an example, on the Rochford Development Committee on 9th of December 2021, an application for 29 flats was approved. None of these windfall numbers are included in the Statement of Common Ground in the section relating to housing trajectory, but I'm reasonably confident that those 29 will be delivered in that period through to 2025. I would also like to discuss precedent. It's reported on the building site website, the building trade website, and I have actually seen a fuller report from the Department for Communities and so on. It was reported in November 2021. The headline says, Gove turns down Kent housing scheme despite council's housing land shortfall. And it says, despite the local authority having no 5-year supply of land. A key reason in the refusal was that the plans would severely impact on the local road network. Mr. Gove agreed with the inspector that the impacts of granting planning permission would significantly and demonstrably outweigh the benefits, which is a test set out in the NPPF. We argued that this test applied to the Bloor application would equally give ground for refusal of the appeal. I also attached in the evidence, that late December evidence, several reports of appeals rejected on the grounds of severity of traffic impact, and in some cases, despite shortfall in housing supply. Again, before moving on to the conclusions, which I'm almost there, I think. I would like to just share a concern about the local drainage system, actually. In this section, I talk about on 24th of February 2021, I wrote to the Essex SUDS team asking questions about their assessment of the rainfall on the drainage system. We observe roads quite regularly flooded. We observe the field where this is proposed to be built to be heavily flooded, despite the natural drainage there. So I asked some simple questions. I said, this area of Essex is known to be one of the areas with the lowest rainfall in this country. Having done research, I discovered that at that time, over the previous 2 years, average rainfall had consistently been significantly higher than the previous 8 years. So I asked 2 questions of SUDS. One, has the SUDS assessment of the proposed Blue development included the recorded levels of rainfall experienced over the last 2 years? And the second question was, what was the worst case included in the assessment? In response to question 1, after a very long-winded technical explanation, which I'm reasonably intelligent but struggle to understand, it said we asked developers to use longer data sets, which is something we can't ask developers to collect for specific areas. The response to question 2 was, on your second point, we expect SUDS to be designed for up to and including a 1 in 100 year storm event plus a 40% allowance for climate change. It goes on to say the 40% climate change allowance is the upper limit set by the Environment Agency, so we're therefore taking a conservative approach. We also ask for half drain times for storage features, which looks at ensuring there is enough storage capacity for consecutive storm events. So, as I say, I'm reasonably intelligent. I don't think I'm an idiot, but I didn't quite understand the 2 simple answers to the 2 very simple questions. In light of the above, I'd like to share a personal experience. Many photographs shown in the evidence that's been previously provided has shown in the past months the impact of heavy rainfall on roads and some residents' gardens, and importantly on the farmland proposed for the Blore development. It's not unusual for roadways under the local railway bridges to be impassable. We've submitted pictures. There's one relatively recently with cars trying to get through under the Rectory Road railway bridge. Can you just confirm that you did get those pictures? The pictures of the Rectory Road and so on. Yes, thank you. So I'll share a personal experience. Many of the photographs submitted in the evidence have shown the impact in past months of heavy rainfalls on roads and so on. So it's not unusual for the roadways under the bridges to be impassable. On the 20th of October 2021, at 11 p.m, we received a call from my 94-year-old future mother-in-law who lives in Hockley, not very far away, a couple of miles. Her roof was leaking in the torrential rain. Now, to get to her involves going by one of the routes on the maps that we showed you at the beginning. We set out to get to her heading north along Ashton Road towards Greenswood Lane, but could not get through the flooding at the bottom of Ashington Hill. Turning back, we were able to just get through the flooded road under the railway bridge in Rectory Road. Making our way along Rectory Road to join Main Road, Hawkwell, once we got to level grounds, the roads were underwater from side to side. We arrived at the railway bridge in Greenswood Lane to find it impassable with 3 vehicles stuck in the deep floodwater. Now, with no further alternative route available, we turned back to return home. We found Rectory Road flooded and impassable at the railway bridge, or by now flooded. We went to Hall Road to find the railway bridge at that junction, with Ashton Road and West Street flooded and impassable. Next, a long diversion of several miles to get to the Warners Bridge, Southend Road roundabout, flooded but passable by going onto the path and grass verge. Next, the Amberlin roundabout, flooded but passable, eventually home via Ashton Road. All roads were flooded curb to curb and many manhole covers lifted and water flowing out the drains. So I started this section by asking two simple questions about levels of rainfall that have been included and got these long technical answers. And I wonder if the amount of rainfall that night would have been classed as a 100-year event, and particularly whether the mitigation for the loss of natural drainage resulting from the proposed development could further overload the local drainage system. Anybody that lives around here knows that that was a bad night, but we experience bad nights and bad days quite frequently. So, sir, I will now move on to the conclusions. The Ringway Jacobs Essex County Highways Baseline Technical Note dated the 24th of the 10th 2017 stated, the sole purpose of this report is to provide a baseline assessment of traffic and transport to inform the development of the Rochford District Council local plan. It describes all of the junctions and the number of roads in the area affected by two large housing developments known under the planning policies SCR2 and SCR8. Against its definition of traffic flows, it describes the junctions and roads variously as high levels of congestion, very little free flow of traffic, highly congested, congested in all directions, a congestion problem. Of all the difficult junctions, one in particular, the Ashton Road, Hall Road, West Street junction, is described in the baseline assessment as having high levels of congestion on all three approaches. It also states that widening has been undertaken at this section. This very minor adjustment is laughable mitigation for the SCR2 development of 600 dwellings. In the case of SCR8, with a further 662 dwellings off the Ashton Road, the RDC planning officer reported to the Development Committee, made it clear that in relation to the above-mentioned junction, no improvements could be carried out at that junction, and that the proposed development would add to queuing and congestion. So between SCR2 and SCR8, adding 1,200 plus dwellings, both feeding this junction, the only mitigation is not fit for purpose. Since the 2017 RJ-ECC assessment, there appears no evidence available to indicate that the congestion at the junction and its feeder arms or any other road or junction has been assessed by Essex Highways or Rochford District Council, the planning authority. As to whether the cumulative impact would be to move from the earlier assessments of high congestion to severe, who knows, not assessed. As such, one must conclude that the development fails to deliver local highway capacity and that infrastructure improvements are required by policy SCR8. In the course of the interrogation of Councillor Shaw, Miss Reid made much of the history of SCR8 being approved, and approved in the knowledge that there could be no improvements to the Hall Road, Ashton Road, West Street junction. And I think Councillor Shaw was persuaded to agree that that was the case. The point I would make is those responsible for planning when that plan was put forward, who are not now running the council, made a mistake in approving SCR8 in the knowledge that that junction could not be improved. And it was at the end of the major spine through the district of Rochford and fed by three arms, all heavily congested. So I believe on that alone that the Development Committee decision to reject the Bloor application to be correct and that the appeal, sir, should be rejected. Thank you.
Okay, thank you. Sorry, I'm just double checking because I've got a next page there. You're content that you're not giving me those bullet points there?
It was yes, sir. It was written. I've introduced a historical footnote earlier on.
It wasn't the historical footnote. It was the, you say, be remiss to not reiterate other issues identified.
No, I've already covered those.
You've covered those
in earlier on. Yes.
Okay, thank you. I've got all that. Right, thank you, Mr. Foster. Just bear with me a moment. Miss Reid, have you got questions that you want to put to Mr. Foster?
I forgot one point, sir. Should I pass these to you to see?
I'm content that I can see from here, thank you.
So I don't have any questions. I'll pick the points up with my witnesses.
Okay. Yeah.
Did I hear that correctly, sir? No
questions to you from the appellant's advocate, Miss Reid. I have questions.
Okay.
No questions from the appellant's advocate. She's going to pick up any relevant points with her own witnesses. So points that you've raised, she's going to ask her witnesses to comment on and give their view on, without putting words in her mouth.
Yes, so that's right. And just to be clear, that's because, as I indicated at the beginning, in respect of, I appreciate it's Rule 6 party, they have formal status in respect of the proceedings, but in respect of residents, whether they're Rule 6 parties or otherwise, my practice, unless I have points of clarification, is to adopt that practice, which is not, I don't have any particular questions, and I'll raise them with my experts.
Okay.
Could I ask which experts are going to be presenting or questioning?
Yeah, so my witnesses, which are Mr. Blair, who's dealing with highways matters, and Mr. Pycroft, who's dealing with planning matters. I do note, sir, there is just one point, if I may raise it before you do.
Yes, certainly.
I do note that points in respect of air quality have been made in the evidence. We had understood from correspondence prior to the inquiry that we didn't need our air quality expert here because those points weren't going to be raised. Now, I'm not trying to stop them being raised. Clearly, the Rule 6 party must make the points it wants to make. I suppose that we have produced a statement on the back of Mr. Pycroft's evidence, and it's just whether the Rule 6 party thinks now it's going to have additional questions it wants to put, because Mr. Pycroft's obviously not the expert. If they do, and they've changed their mind in terms of that, then just a bit of notice so that we can make arrangements in terms of it. I think it's probably going to have to be a virtual arrangement as well because he's not here. I hadn't anticipated that was going to be the case. I'm not sure that there are any technical questions in respect of that evidence, but it was just a point of clarification, really.
This was raised prior to the inquiry, wasn't it? I do recall.
It was, and the email was that they weren't going to, at that point the Rule 6 party didn't, because you remember, if you remember, sir, I raised it at the case management conference.
Yep.
I said that we'd produce a statement, the Rule 6 party would consider whether they were raising evidence in respect of air quality. I think that they confirmed that they weren't.
I don't think it said air quality, sir.
I'm not taking any issue with them raising it now, to be clear, but it's just in terms of where we're up to and who we've got here, if there are any questions. I think the indication was that they weren't and there wouldn't be. We've then had an addition to the evidence, which I'm not objecting to. They must raise the points they want to raise. It's just in terms of who I've got here, if they've got additional questions. Mr. Pycroft isn't in a position to answer technical questions on the statement that's been served.
Yep.
And so if they have questions, and I don't necessarily need an answer to it this minute if they want it, but I'm going to have to make arrangements for that person to be available to answer them. And that it's going to have to be virtual, that they are brought into it at this point because it was raised previously and they're not here.
Yeah, no, that's a fair point. I think that summarises my response, which hopefully it found its way to you. I was asked the question, I think, that, let's think how I can best phrase this. I'm aware that at an earlier stage in the proceedings, when it appeared as though air quality may be raised, the appellants responded by producing a statement, which is an appendix, can't remember the number, but it's an appendix to either Mr. Pycroft's or Mr. Gascoigne's evidence. And then the Rule 6 party said you decided that you didn't want to submit the air quality, no, bear with, the air quality evidence that at one stage you were going to. I fully accept that air quality is mentioned in your statement, and as you said, you've covered those points now. But at one stage you were going to submit additional air quality evidence, and I think it was possibly in response to that the appellants had produced a further statement. My advice, because I was asked whether or not the appellants could reasonably stand down their air quality witness. And I said, no, I don't think you can, because it may be that the air quality is raised by interested persons at the inquiry. And so I advised that the witness still ought to be made available if necessary, even though that may need to be through a virtual appearance at the inquiry. So I think all that's being asked now by Miss Reid is, were you intending to pursue with Mr. Pycroft, it's going to be, any issues about air quality? Because if you are, he may not be able to respond to them, and Miss Reid would need to ensure that that witness was available virtually.
Let me just try and answer those questions, sir. At the case management conference, we were asked whether we were pursuing environment issues in relation to the conservation area.
Yes.
And we said we were not.
Yep.
We didn't say we weren't going to pursue air quality.
No, I think you did later. I'm not talking about the case management conference. You stated at one stage that you wanted Ms. Waite and
Yes.
an environmental expert to provide additional evidence, and I, through the case officer, informed you that we were well past the date for the submission of what would at that time be additional late evidence, and the response I got back was that you had come to the view that you didn't want to submit that evidence and didn't want that environmental expert.
I do agree, sir, that Mrs. Waite was going to attend, and for various reasons she can't, so we withdrew that. As she wasn't actually an expert witness, but shall we say, in the world of the blind, the one-eyed man is king. She's quite intelligent on these matters, but she couldn't stay. But nonetheless, we did raise the air quality around the areas of the school and the big junction.
Yes, I mean you'd included that in your initial statement. So I mean,
I would expect that we will be asking questions on the subject in cross-examination.
Well, I have no objection to that, obviously. I've made that clear, and I'm not trying to curtail the points that are being made. And as I say, I don't necessarily need an answer to that point this minute. We're obviously going to go into tomorrow and next week with the inquiry. Could I just request that some thought overnight is given to whether there are questions that the Rule 6 party or residents wish to ask of our air quality expert? The statement is at Appendix 3 of the Emery proof of evidence, I'm sure you know that anyway, but just to redirect you in respect of it. If there are questions of him, if we could know tomorrow morning when some thought's being given to it, and then we can perhaps timetable in and make arrangements for that, sir, if I may suggest.
Can you do that? Because obviously we need to, if it's going to be a virtual appearance, then the witness will need to know when it's going to be.
Yes, sir, I expect to be asking some questions about air quality. Part of the reason is we were ignored on the Statement of Common Ground, where we did put some air quality items in. The first version of the Statement of Common Ground came from the appellant on, I think, the 6th of December. We responded on the 8th of December. On the 9th of December, Mr. Gascoigne responded that he would...
You don't need to go through. You did do this in your summary of your case.
Okay.
So, I mean, yes, I accept there's a chronology, and the end result was that there isn't an agreed statement of common ground between the supporters group and the appellants. So.
May I just say one thing, sir? Yeah, there isn't an agreed statement. We were ignored on the matter from the 3rd of January onwards.
Well, sir, we don't...
Obviously, that's the view you take.
Yeah.
I mean, from my perspective, I haven't got a statement of common ground. So, I mean, we've ended up at the same point. I'm not saying that you're not right in putting forward your perspective on that.
So can I just clarify, because again, and it's just going back to having a think about overnight, if there are questions of the air quality expert, if the questions are going to chronology in terms of the statement of common ground, which frankly, A, we don't accept, but B, I don't think it takes us anywhere anyway, because there isn't one and that's it. But if there's questions about chronology and those kind of points, then they can be directed to Mr Pycroft. If the questions are about air quality, substantive matters in respect of air quality that need to be asked of the air quality expert based on the statement that he has provided that's attached to the proof of evidence, then that's where we'll need to make arrangements. And that's why I'm just asking for some, I don't need to know what the questions are or anything like that, but consideration to be given to that point overnight, because what I don't want to do is have him here and then the questions go to things like chronologies about statements of common ground, which I could quite easily, which Mr Foster can raise with Mr Pycroft. So.
Yeah. Well, yeah, clearly, I mean, that's a reasonable point. I mean, a distinction between substantive air quality matters and chronology in terms of abortive attempts to do a statement of common ground. If it's the latter, Mr Pycroft's on hand.
The chronology is not a discussion point now.
Yeah.
We were ignored, so fine. We will ask questions about air quality.
Okay. Okay, well, it's
Right.
ponder it overnight, but certainly I'm taking at the minute that you're saying, yes, you would like to.
Yes,
but let's come back to that in the morning.
Sure.
Okay, right. Well, thank you for that. So, wind back a bit. You've got no further points to raise with Mr Foster.
No, thank you,
That's
sir.
correct, yeah. Okay, well, I'll go through some of the points that I'd got then with you. Mr Foster, please. Let me... Now, some of these may fall away as a result of other things that have been said, but obviously I noted these at the time I first went through your statement. So just let me go through. I think one of the things, because you've referred to it many times, hang on, is this table 4.1 with the congestion description. And you've gone, I'm looking at your original report, which may well be set out very similarly to the one that you worked on here. But basically, you'd gone through a number of bullet points prior to putting that table in, when you say things like the report states high levels of congestion reported for all three approaches to the Ashington Road, Hall Road, West Street roundabout. Sorry, are you with me or you? Yep. So it's those bullet points. Then you've got medium to high levels of congestion along Ashington Road. Rectory Road is highly congested. What I want to be clear on is what time periods are these relating to? Because when I looked through this Jacobs report, some of those that you've picked out of there were specific to one peak period or another. I just want to know how you've interpreted these descriptions of congestion and what you're saying I should take away from your evidence when you tell me that a particular road congested in all directions. I mean, is that in the AM peak, in the morning peak?
Well, in parts of it, they talk about the peaks, PM peak, similar to the AM peak. Others, they don't actually define the time of day.
So it's variable depending.
Yes. For example, if I may, just to explain the point, it says on the it says in the Rochford area, we observe medium to high levels of congestion along the majority of Ashton Road. Rectory Road is highly congested, appears to blah, 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 blah. There is no suggestion there of what times of day those comments are based upon.
Sorry, that's from the report that you were reading, that was it?
Ringway Jacobs report.
Okay, but as I say, when I looked through the report to try and pick out where you'd taken some of these statements from, it did seem that some of them were relating to specific periods. So I think it's, from my perspective, it seemed reasonable to say, well, yes, that is a reasonable statement, but it has to be taken in the context of what time period it relates to.
Sure, I understand that. And may I add, sir, that I mean, peak periods, from my relatively novice understanding of these things, they tend to have a pretty fixed set period of time. But in Ashton Road, we've got schools that start at 7:45.
Yeah.
and finish at 2:10, and others that start at 8:45 and finish much later.
Yeah, I mean, they're fair points. I have picked that out as you know, I've gone through the evidence and as the inquiry has progressed, that yes, you can't simply say there's one morning peak and one evening peak. Right. Well, you may be able to say that those are the actual peaks, but there are other periods in the day when certainly there are local peaks or whatever.
Correct.
Okay. Okay. Yes, I mean, I think just looking at my own notes there, the examples, the second of those bullet points, where it says medium to high levels of congestion along the majority of Ashington Road, very little free flow of traffic. The report only refers to that in the PM peak. And then, no, that was the only one there. So. Nothing hinges on this, but I'm going to just say it. On your page 3, when you were talking about the Jacobs report in the context of SER2, you've emboldened a quote saying the development is projected to generate 482 two-way trips in the AM peak and 357 in the PM peak. I accept that this isn't the development before me, but then you go on to say this adds up to a total of 1678 additional daily trips, and I just didn't want there to be any confusion here. I'm not sure that you're right in saying that. I'm not quite sure how you've got that figure. All the report says is 482 two-way morning trips, or rather two-way trips in the morning peak and 357 in the PM peak. So if they're two-way trips, all you can glean from that is that there are 839 two-way peak hour trips. It doesn't say anything about additional daily trips. It looks to me as though you've added those two together and then you've doubled them.
Correct.
Well, with respect, I don't think that's the correct way to deal with that information that's in the report. I'm not saying here that anything hinges on this, but all it's saying is there were 482 two-way trips in the morning peak and 357 two-way in the evening peak. It doesn't say anything about any other times of the day.
Okay. I'm talking about additional trips in those peaks, and it's 2 times. If I go to the shops...
No, it's not. No.
If I go to the shops and come back...
Yeah, that's included in when it says 482 two-way trips. It doesn't mean twice 482. It means there's 482 two-way trips.
That's interpretation, sir. Not sure. It's not clear. Shall we say it's not clear in this report?
Okay. Yeah, I'm not going to labour the point because, as I said, nothing's going to hinge on that. Just on page 5, just so I'm clear what you're telling me here, it's towards the end of the big middle paragraph. You say there's also a well-used Pelican crossing just to the south of the Rectory Road, Ashington Road Junction, which also delays traffic in both directions. I think it's actually the bit just before that. You say,
sorry, remind me, you said page?
Yes, sorry, page 5.
Yep.
You've got a big middle paragraph on page 5. Towards the end of that, it's actually the bit that says, in the evening rush, northbound traffic turning left into Rectory Road is delayed by pedestrian and cycle use of the Pelican crossing in Rectory Road, close to the junction. And then you say delays spill into Ashington Road. So have you followed the bit that I'm at in your report?
Yep.
I just wanted to be clear what you're saying there. I mean, it's clear that pedestrian and cycle use of crossings.
Okay.
I think.
Let me explain, sir. Yeah. The pedestrian crossing, the Pelican crossing, is at the end of the cycle lane leading up to Rectory Road, and the cyclists and pedestrians use the Pelican crossing. It causes a traffic delay there from traffic turning left out of the Ashton Road northbound. Okay, but that lane is very short.
Yeah.
And after 2 cars, sometimes only 1 car, it starts backing up down Ashton Road. Now, I know the applicant says they're going to put a left turn lane there, okay, to create a double lane.
Yes.
But that is a very short length. And when you see the experience of cars being delayed there, they would still actually fill that up and still cause delay on Ashton Road.
Yes, I think I follow what you're saying. I was just trying to get the balance here, because obviously if pedestrians and cyclists are wanting to cross the road, then that's an essential movement. I'm just trying to get your interpretation of the balance between prioritising traffic movements and pedestrian and cycle movements.
Okay, I'm not.
It sounded as though you were critical of the fact that cyclists and pedestrians wanted to cross the road.
No,
I just wanted to be
quite the reverse, sir. If I put that across in that way, I apologise.
Okay.
No, I'm simply saying that a consequence of that being a heavily used Pelican crossing causes delay in the Ashton Road.
Yeah. Okay, thank you. Now, just so when I revisit your evidence, I can actually follow what you're saying. I was confused on your page 6. You're talking about traffic leaving the development via the secondary access on Percy Cottis Road. You tell me there's essentially 2 alternative routes. And I thought I'd followed them in the main, but I couldn't on the map find Green Way. Is that...
Did you say page 6?
I did, yeah. Page 6, almost halfway down, there's a paragraph saying the access for the homes proposed in phase 3 is via Percy Cottis Road. So
Are you looking at the original version?
I am. I'm going through your original one, yes.
All right. The page, right, there's page 7 in the,
Okay, yeah.
in the other one.
Yeah, sorry, I did say that. I wasn't going to cross-reference, but yes.
Okay. Yes, it's a convoluted series of quite small residential roads. And
I picked up most of them. I wasn't sure that I could spot Greenway. So if you're telling me it's definitely there, I'll go and have another look.
It is.
Greenway, okay. Yeah, I was going to ask you about the points that you'd raised about the road safety audit relating to the Percy Cottis Road.
I'm sorry, sir, I've just been corrected. The house is called Greenway. It's still Percy Cottis Road.
Oh, it's a house called Greenway.
Sorry about that.
Right. That perhaps explains why I couldn't find it, but yeah. Okay. Yes, I say I was going to just ask you or ask you a point about the Stage 1 road safety audit that you referred to for the Percy Cottis access, because you've emboldened the fact that it actually identifies 3 risks, but in your oral presentation you did then go on to say that solutions were suggested for that. Whether or not you agree with them, I just wanted to quiz you, because you hadn't, you'd left it hanging, as it were, in your original proof to simply say that 3 risks were identified. My take on that when I looked at that was, well, yes, they are, but there are explanations as to how it's considered they would be addressed.
My take would be at variance with that, so in the sense that
Well, no, that's still correct, but whether they would be effective, I think,
Right.
is where your difference is it? Yeah, I mean, they're definitely put forward as those reviewing the road safety audit have responded by saying this is 3 issues identified. This is our suggestions to how they would be addressed.
Indeed, and may I add, actually, I mean, I picked those 3 to highlight the point that Ardent said no risks were identified.
Okay.
But they were, and there were others identified as well.
Okay, yeah. I think now I'm going to give you a page in your original one, so you'll have to relate that again. But this is, I've got page 9. This is where you're talking about the Essex County Council corporate response. And you talk about the segregated cycle lane being a misnomer. So I think you did still refer to that in the version that you were working from today. It was just really the point that what you've said here is from the Rochford Supporters Group's perspective, a white line painted up the middle is dangerous. Dangerous in that, you say, formerly a footpath, now with a white line painted up the middle, and dangerous in that, with hundreds of school children and parents walking the path. And I think really that what I want to say in that context, and just ask you there, is that in terms of your evidence as a whole, and the obviously the assertion that the residual cumulative impact on the road network would be severe, I think it's right to say that the evidence that you've put forward, it's not included any traffic counts, traffic figures, queue assessments. It's predominantly based on the photographs, and you've submitted a lot of photographs to demonstrate the points that you want to put forward, but they're not backed up by any junction capacity assessments or traffic flow information. And on this one here, you're telling me hundreds of school children and parents, but you've not put any figures in to support that, have you?
Okay, I understand that. That it's quite a simple discussion in the sense that the school has a capacity of, the Holt Farm schools have a capacity of 500, I think, 500 roughly. And if you look at Ashton Road on school days before the school opens, most of them are walking. The catchment area is very close. Yeah, it's just been pointed out to me, all the schools in Ashington area account for 2,346 pupils.
Sorry, 2,003?
2,346.
Okay.
And on the matter of the junction or traffic assessments, formal assessments, as I said at the start, that we are relying on pictorial evidence and experiences, and we are not traffic experts in terms of using the software, and we are not funded. We are, residents that are interested in our area.
Don't take me wrong. It wasn't put forward as a criticism as such. It was me just making sure I'd followed your evidence correctly, and that I hadn't overlooked anything in there.
Absolutely.
Okay, thank you. I do just need to pick you up on your page again. It was to do with this Essex County Council response. A few things about this, but one of them, which I've got on page 10, and I'm sure you've got on a slightly different page, where you say the Essex report goes on to quote the Department of Transport's gear change policy, and I looked through the full Essex Council response, and yes, I picked out the reference to gear change policy. Sorry, I'll just wait while you. So it was page 10 on your original submission. Can't easily find it in this one. You did refer to it again.
I do remember it very well. I'm just my brain's obviously a bit scrambled at the moment, sir.
Yeah.
Right, if you'd like to ask a question, I'll try and answer
Oh,
it.
here we are. I think I found. So I think it's actually page 11 in your the version, your revised version that you submitted. So on page 11, there's quite a lot of text, and you're going on about 2 inches down from the top. The Essex report goes on to say, quoting the Department for Transport's gear change policy, and then you start to say a few things there. But then a little bit further down, you actually say, it would be not compliant with the MPPF recommendation that users should be, and you put in quotes, physically separated on urban streets. So when I saw that, I thought, oh, you put in quotes, you've referred to the MPPF, so let me have a look in the MPPF and see where that is. And I couldn't find it. So I think what I'm trying to say is, although that you're implying there that that's something in which the proposal would be in conflict with an MPPF recommendation, I don't think that's strictly correct.
I think the section that I put in quotes was in the Essex report, I believe.
Yes, I think that you're right. The bits in quotes relate to the Essex report, but reading that, you've then gone on to say it's not compliant with the MPPF recommendation. So
Okay.
just highlighting that wasn't how I read that.
And, the point I'd made is a white line isn't physical separation. Maybe
Okay.
there's a curb up the middle or something.
No, yeah, I understand that point, yeah. Just another point, though, on you were at pains to say that the non-statutory consultee areas of Essex County Council were not included in the report to the Development Committee. I'm not quite sure if that's correct, is it? Because when I looked through the 26th of November committee report, I picked out most of those points in the Essex comprehensive response were reported in there. I jotted down 4.54 to 4.61. These are paragraphs in the committee report. 4.73 to 4.11, with highways subsumed within that at 462 to 472. So I'm not asking you to go and look at it now, but I'm just really, you've highlighted the fact that as far as the supporters group's concerned, those points weren't put forward to members.
Okay.
I don't think that's correct. But
Okay.
you can,
What I can say is the members didn't discuss them. No, which may
well,
be,
that may be a totally
that's a
different matter.
discussion, but
Yeah.
it's a very, very thick report.
Yes.
And typically the members focus on things that get highlighted by the officers for them, often.
Yeah.
And my point is that by those items not being discussed, they therefore weren't included in the deferral and therefore weren't actually able to be discussed in the June meeting when it came back, because the discussion was restricted to the reasons for deferral.
Yeah, I mean that may well be the case, and I'm not suggesting anything other than that. But in terms of whether or not that information was available to councillors, council members, in the November report, I think, as I say, when I saw you tell me it wasn't, I thought, well, I better check that.
Thanks.
And it looked to me as though it was, but it may well be, as you say, that it wasn't focused upon
That case,
in any
I
discussions.
stand corrected, but I'm
Okay.
sure you'll realise I'll go and read it myself again.
Yeah. As I say, it isn't a criticism; it's a clarification,
Yep.
really. There.
Sir, I'm so sorry to interrupt. Just a point as well, and it's just a reference note as well
Okay.
from me, if I may. In core document 5.1, which is the 24th of June report, and it's the addendum report, at paragraph 2.34, there's reference there to an updated additional consultation response has been received dated the 12th of February 2021 from Essex County Council.
Yeah.
And that's the one which is, that response is the letter that's been referred to.
Okay. When you say that response is the letter being referred to. Yeah.
You recall in Councillor Shaw's
Councillor Shaw's got them in her appendices.
She has, and it's Appendix 4. Councillor Shaw, I think it's also in the core documents, but I've been using Councillor Shaw.
Appendix 4,
Yeah,
letter the
12th of February 2021,
Right.
which,
Yeah, so that's the second one. And so the earlier committee report had the corporate response,
Yes.
which is the Appendix 2.
it is,
Yeah.
and then this later one is referred to in that addendum report also.
Yes,
At that point.
but in effect, both of the Essex County Council responses were before members. One was in the earlier committee report, and one
Yeah.
was as an addendum or whatever to the second report.
Correct.
Is that correct?
Correct.
Okay.
Yeah, and it's that 2.34 to 2.35 in that addendum report at core document 5.1 that's referring to that later document of the 12th of February 2021, in addition to the points that you've just raised, sir, in terms of references.
So that was in the June 2021 Development Committee. Sorry, so I couldn't hear you very well.
Oh, I'm so sorry. Yes, and if you go to later, if you want to find, it's core document 5.1, and it's page 6.9,
Okay,
and it's paragraph 2.34 to 2.35.
okay. I suspect I missed that because I was thrown off the Development Committee in June.
Okay, well, thank you. Thank you for that. I think we're just about at the end of what I wanted to check with you, Mr. Foster. I think the only one bit that you didn't, well, I better just check on here, but on those bits that I asked you if you were going to cover in your presentation earlier, when you said it'd be remiss not to mention others, and I turned over the page and I saw they were the bullet points that were in the original bit here, your original statement. The only one I wanted to check with you is your third one, where you say risk to Rochford Conservation Area. I just wanted to be clear what risk you're saying there would be to the conservation area.
That's the bit I withdrew originally in the sense of the environmental.
Okay.
The risk is about traffic.
So should I score it out here then, or what? Or
I need to see it to be
well,
sure.
it's just the bullet point that says risk to Rochford Conservation Area.
That's about traffic, so
So it was a
any risk that I've included in the actual report that I've just made about Rochford Conservation Area is about traffic impact.
okay. So just so I'm clear, what are you saying that that would be unacceptable, or
Well, I cross-refer that to the High Court judgment that I mentioned, which was that the Coombs Farm development was not included in the local plan because of traffic impact on the conservation area, and I was explaining that the
yeah. Okay. So it's a traffic impact that you would have some concerns about.
yes.
Okay. Let's try. Okay, thank you. So that was all there. Just when you went through the second, or rather the revised version, I put a few more flags on, so I think some of them were the same points. Just let me quickly check. Yeah, time periods. Yeah. No, I think that's it. Thank you, Mr. Foster. So I haven't got any more questions. You've had no questions put to you by Miss Reid. had you have had an advocate taking you through your evidence, this would be the point now where I'd ask if any re-examination was required. So I'll give you the opportunity. If you've given me an answer to a question earlier and you've had time to reflect and you think I didn't explain that very well, let me clarify it, I'll let you do that now. But if you're content that everything you said was fine, we can just say that's the end of your cross-examination.
I'm content, sir. End
You're
of
content.
cross-examination.
Okay, thank you. So we've got to 17:05, so a good time to break. So thank you very much for your contribution,
Thank
Mr.
you,
Foster. Thank you, Mrs. Austin. And you may retake your seats and start to remove your display boards, as it were. Thank you.
Do you need us to move those now?
No, sorry, you can do that. So let's just reflect where we are.
Well, so I think my preference, given that we're now after 5 o'clock, and even if we were bashing on was we'd need a comfort break anyway, would be to break until, I'm quite happy to start again tomorrow morning earlier, but to start afresh tomorrow. It's been quite a long day. And
Oh, yes. Had we have finished earlier, then I would have been toying
yes.
with whether or not we could
Yes.
start the appellant's evidence, but I think we've had a long day. We started at 9. Just let me tell you, though, I mean, clearly what I need to happen, we need, I don't know if it's come through, but we need that statement from Ms. Crosby, the written reps. It's not essential that it's in before the appellant's evidence, but you know that would be ideal in case there's something that you needed to take any of your. Thank you. Thank you. Yeah.
Thank you.
Yeah. Okay. Well, we'll have a look at that overnight, and obviously can see what that says. Yeah. So what I was going to say is, based on your time estimates and my run through how I thought it might pan out, I thought that we might be talking. Sorry, it's Mr. Blair first, is it for you? Yeah. I got a total there of 5 hours and 15 minutes, and that's taking on board your uppermost estimate for evidence in chief, Mr. Parkinson's upper estimate of 2 hours for cross-examination. I've put in half an hour for cross-examination from the Rule 6 party, which may or may not be close to it. Anyway, cut a long story short, 5 hours 15. So what I'm getting round to is if we have an early start tomorrow again, possibly 9 o'clock if people are happy with that, 9 o'clock, then with the fair wind we ought to definitely get through Mr. Blair tomorrow.
Yes.
On that basis. That would leave Mr. Pycroft to be dealt with next Tuesday. I understand, Mr. Parkinson, what you said yesterday, we're not going to be able to start till 10:30 next Tuesday. Is that right?
Yes, that's right.
Okay, so that's a bit of a blow because it means we can't get a racing start. But again, not that I'm trying to pin anyone down to these times, but I'd got 3 and 3/4 hours in total for Mr. Pycroft on a similar sort of basis.
So certainly on the planning evidence, obviously I can't put points, Mr. Pycroft, that, well, having called a planning witness, I'm then constrained in some of the points I take. So we'll just need to, I can't remember what I put down.
Well, you said an hour.
Said an
You
hour.
said an hour. I mean, yes,
Okay.
I mean, by all means reflect on this
Yeah.
and come back to me. But what I'm really saying there is Mr. Blair tomorrow, Mr. Pycroft possibly finished Tuesday morning, early Tuesday afternoon. So I think where I'm going with this is that if we then tried to do the conditions and Section 106 straight after Mr. Pycroft, it would mean that we wouldn't do the site visit on Tuesday afternoon, but we would do that on Wednesday morning instead, and then have closings sometime Wednesday afternoon.
Okay, can I? Yeah.
So that's Plan A. Mm-hmm. Plan B might be that, well, we still do the site visit on Tuesday afternoon, but that would mean leaving the conditions and Section 106 to Wednesday morning and follow that by the closings. I'm just floating options here to see if there's any preference from one side or the other as to how that would work.
Take instructions, sorry.
Yeah,
My team's
yeah.
right up there. I just want to ask them a question.
Okay.
So from my perspective, Mr Parkinson might have a different perspective on his instructions. We can be flexible because my team doesn't necessarily need me here for the 106 and the conditions session. On the basis it's a round table discussion, and I think in terms of the 106, our solicitor is going to be dealing with that, who's been negotiating that in any event. So on that basis, whether from my perspective, I can use the conditions section 106 and site visit time to write my closing, and therefore it doesn't matter from our team's perspective which way round you do it.
Yep, understood. Are you in a similar position? I know that it's likely to be case officer for the conditions session, so you may or may not have wanted to be there, Mr Parkinson, I don't know. But
I think we haven't decided yet. I mean, I may be here but not speaking and typing instead,
okay.
just in case anything comes up.
Are you equally flexible then whether we have the site visit on Tuesday afternoon, at whatever time after we've finished with Mr Pycroft? Of course, there is your air quality witness who we may need virtually, and that may also need to be on Tuesday afternoon. So I think my preference is on this basis that we try and deal with all of the evidence and the condition session, etc., on the Tuesday.
That certainly works for us. And then with a view to starting at what time on Wednesday?
Well, if we had the site visit in the morning, we could have a fairly lengthy site visit. I'm not saying that the minute the site visit's over, we start closing submissions. I'd set time 2 o'clock or whatever, 1:30 or 2 o'clock on the Wednesday for coming back for closing submissions.
So the only reason I ask on that, and it's not to do with finishing closing submissions, because I'd probably aim to have got them done on Tuesday evening. It's just that I have a hospital appointment in the morning on Wednesday.
Well, all right.
Which I quite need to go to. I mean, obviously this takes priority, but if there was a way that I could do that and then come down for the closings at 2 o'clock, then that would help.
Well, as far as I'm concerned,
it sounds like it's going to work anyway because we've done.
I'm very happy to fit around that.
Mr Foster, from the Rule 6 Parties Group, if I know we'd said a couple of days ago that we were possibly looking at Tuesday afternoon for the site visit, but if it ends up being Wednesday morning, are you still content with that? Fine. Yeah, okay, and we can obviously agree what time we would start, I mean, and whether or not it's all done in one bit, or if we do a bit and then come back at another of your selected times, as long as we can finish it at a time that allows us to start closing submissions at an appropriate time. I mean, that would either be 2 o'clock or I might have gone for 1:30, depending on whether I think a lot of interested persons want to summarise their cases, because that'll take a little bit of time as well. But basically, I've got an hour, I think, and 40 minutes or thereabouts as estimates. So if we start at 2, we should finish by 5, or not much after.
And so just in terms of the timetable then, I suppose a couple of points. One option in terms of the air quality expert, I mean, I need to take instructions on his availability. He's fine, right, okay. One option would be to, depending on how far we get with Mr. Blair tomorrow, but just make him available if we get to a point where we can fit him in before close to make best use of time. Tomorrow.
Yes, certainly.
Rather than start Mr. Pycroft and it be split. Yeah. And that would seem to make sense. If we get to a point where we can do that, we can then start on Tuesday, Mr. Pycroft's evidence all together, and then proceed in the way that you've suggested.
Yeah. Well, if we start at 9 tomorrow, and we go through till I said about 3:30.
Yeah.
So what's that? 9 to 3:30, that's 6.5 hours, isn't it? Take
Yeah.
off at least half an hour for lunch, that's 6. Take out a mid-morning break. So it looks as though we will get Mr. Blair done and possibly have a bit of time for air quality if that works out well for parties involved.
I'm great.
But if it
Yeah.
doesn't work then, he'd be available on Tuesday as
Yes,
well.
he would, yeah, yeah. So I'll work on the basis that I don't need to go through matters with Mr. Pycroft for tomorrow, and that we're starting his evidence on Tuesday then, sir,
Okay.
on that basis.
Yeah, all sounds good. Right, okay, well, I was going to ask for the attendance list back, but I see it's here. Is there anyone who hasn't signed the attendance? Oh, sorry. Can someone get the list to that end, please?
Sorry, sir, just briefly, just so I'm clear. So it's 9 o'clock start in the morning till
Yes,
3:30
if
tomorrow
everyone's happy
afternoon.
with that, I think it's good if we can, and then
Okay.
we get a good start. So, yeah. Yeah, anything else from any of the parties before I adjourn? No? Okay. Thank you then. On that note, I'll adjourn now and we'll resume tomorrow at 9 o'clock. Thank you.